circulated. These are public proceedings being broadcast live in Parliament House and via the web. For those joining online, I'm Senator Nita Green, Chair of the committee. I'm also joining you online today from Cairns. With me today is the Deputy Chair, Senator Paul Scar, and Senator Larissa Waters will be joining us shortly, also via video conference. I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, and this is described as being in camera. If you are a witness today and intend to request evidence in camera, please bring this to the attention of the Secretary as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera, and such a request may, of course, also be made at any other time. Witnesses speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphone to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. And I now welcome our first panel of witnesses today. I welcome representatives from the Fitzroy Legal Service, the First Nations Advocates Against Family Violence, and joining us via video conference, the National Legal Aid, Women's Legal Services Australia, and the Caxton Legal Centre. That's quite a lineup, so thank you for joining us. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretary if you need it. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? And we'll start with our witnesses in the committee room there. I can't see your name panels, unfortunately, with the camera angle, but we'll start with Fitzroy Legal Service. Thank you.
Yes, hi, my name is Hamish McLaughlin and I'm a witness from Fitzroy Legal Service, the Chief Executive Officer.
Good morning, my name is Amity Mara. I'm the Manager of Policy Advocacy and Projects at Fitzroy Legal Service.
Great. And First Nations Advocates Against Family Violence?
Kerry Staines, CEO of FNAV.
FNAV, okay, thank you. That's a lot easier. And also via video conference, we're joined by the National Legal Aid.
Catherine McKernan, Executive Director of National Legal Aid.
Great. And from the Women's Legal Services Australia?
Good morning, Megan Bradshaw. I'm the Chair of the Women's Legal Services Australia Family Law and Domestic Violence Committee, and I'm also a Legal Practice Director at Women's Legal Service Queensland.
Thank you very much, Ms Bradshaw. And Caxton Legal Centre also joining us today.
Good morning, my name is Colette Botts. I'm the Practice Director of the Family, Domestic Violence and Elder Law Practice at Caxton Community Legal Centre.
And good morning, my name is Daniela Pratt. I am the Managing Senior Lawyer of the Family and Domestic Violence Program at Caxton Community Legal Centre.
Thanks so much. Now, we do have the benefit of your submissions, which were all outstanding and very detailed. Do any of the witnesses have a brief opening statement to make before we go to questions? We'll start in the same order, if that's helpful, with the Fitzroy Legal Service. Do you have an opening statement to make?
Yes, thank you, Senator. I too would like to begin by acknowledging the Ngunnawal people and pay my respects to their elders past and present. So Fitzroy Legal Centre service opened our doors in 1972, which was just a few years before the introduction of the Family Law Act. So for as long as there has been a family law system, Fitzroy Legal Service has been seeking justice for victim survivors of family violence. We operate a substantial and highly regarded family law litigation practice, which assists with both parenting and property matters, and which has a family violence focus. We also help thousands of victim survivors every year through family violence outreach and duty lawyer services. Family violence is undoubtedly one of Australia's most appalling human rights issues and should be a source, in our opinion, of great national shame. We know that financial dependence is a leading cause of victim survivors being trapped in violent relationships, particularly when children are involved. That is why we see the reforms in this bill as being so critical. So we are supportive of the bill and we commend it to the committee, but we feel there are a few amendments that could be made to make the system fairer and more accessible for victim survivors. I'd like to draw your attention to three. The first relates to accessibility. As you'll be aware, to consider the effects of family violence, the court will be required to make a finding of fact that family violence has occurred. Our practice experience suggests that there are many barriers to victim survivors understanding what is required to prove that family violence has occurred. For instance, that determinations are made on the balance of probabilities and that corroborative evidence may not necessarily be required. This lack of understanding can discourage victim survivors from raising family violence in proceedings. So to facilitate access to justice for victim survivors, we suggest including these principles in the legislation itself, rather than having them remain buried either in case law or explanatory memoranda. The second relates to homelessness. Victim survivors are some of the members of our communities most at risk from the current housing and homelessness crisis. We therefore suggest that the risk of homelessness for victim survivors and their dependent children be explicitly included as a factor that the court must consider when assessing present and future circumstances. Finally, the third amendment relates to disclosures of protected confidences. Disclosure of a victim's survivor's protected confidences can be incredibly traumatising and can place them at risk of further family violence. We consider that further safeguards are needed to ensure such disclosures only occur when absolutely necessary and after due consideration by the court. Thank you.
Thank you very much. And I've already forgotten the abbreviation of First Nations Advocate Against Family Violence, but you'll have to remind me, Mrs. Staines, and if you have an opening statement.
Sure, thank you. FNAV.
FNAV, got it.
Yeah. I too would like to acknowledge the Ngunnawal people of the lands that we're meeting today and pay my respects to elders past and present, and also to acknowledge all the lands that everyone is joining us from today. I'm a descendant of the Waka Waka Mandandangi people from Queensland, and I'm representing FNAV, First Nations Advocates Against Family Violence, normally known as National Family Violence Prevention and Legal Services, and I represent what's called the FVPLS sector, which is the Family Violence Prevention, a lot of acronyms, sector. So as a peak, we're the only Aboriginal community-controlled organisation that specialises in domestic, family and sexual violence. Our services provide both legal and non-legal support services to Aboriginal and Torres Strait Islander victim survivors of family violence, and we have a model that's a holistic approach. We have a national footprint with 14 members that have close to, in combination, 50 site office locations and service more than 250 remote communities and very remote communities to Aboriginal and Torres Strait Islander people with a staff of up to 300. Overall, FNAV is supportive of the proposed amendments in the bill, and we recognise that these changes contribute to addressing the weaponisation that the family court proceedings can have against victim survivors of family violence. For our member services, family law matters primarily relate to parenting and children's issues, and our clients generally do not have many assets besides superannuation. Therefore, our response primarily focuses on certain aspects of this bill, which includes the schedules relating to the decision-making framework, children's contact services and Section 60I certificates. Important to note the challenges that many of our member services who provide support in rural, remote and very remote locations, and to acknowledge that distance in itself is a barrier to justice. This is poignant when discussing child contact centres and attendance at divorce proceedings. Speaking to the decision-making framework, property reform, and we support that all forms of abuse and the economic impact on the survivor with the introduction of the effect of the family violence in the assessment to assets, which is including superannuation. This enables the court to consider the victim's reduced ability to engage with work over the period of time of experiencing violence. Under Schedule 1, Part 2 principles for the property and non-child related proceedings, this new division will provide Aboriginal and Torres Strait Islander people with more flexibility and simplified approach to property proceedings. Any non-child related proceedings also need to be culturally appropriate and safe, and consider where English is not the person's first language and provide interpreter support services. Schedule 1, Part 3 with the duty of disclosure, financial matters is critical and fair and helps with the timely resolutions of disputes important to victim survivors. By transferring from the family law rules to the Act, this may strengthen the court to make presumptions where there's a lack of disclosure. We need that to note that before presumptions are made, that there needs to be assurance that all parties have been duly informed of their rights. Under the Children's Contact Centres, we have the interest in the regulation of the accreditation rules that support the bill. We support the amendments and further support the findings to develop accreditation children's contact centres for Aboriginal community controlled services in line with the Closing the Gap priority reforms. This will deliver trauma-informed, focused domestic and family violence and culturally safe services to our families. In fact, investment into a hub model that supports pre-court legal support for Aboriginal and Torres Strait Islander people to access legal support prior to mediation can include pre-court legal support, support with parenting matters and support with property matters, all to aid in more successful mediations to avoid court appearances. Both recent supports by the Andrew Metcalfe Review and Dr Warren Mundy make recommendations that specifically support our FEPLS sector to expand in both service provision and geographical spread. The model and the framework has already been developed, and consideration should be given to a mobile service to rural and remote and very remote locations. It would be imperative to legislate that services to Aboriginal and Torres Strait Islander communities needed to be delivered by Aboriginal community-controlled organisations. Section 60I certificates of the unintended consequences, with the introduction of the power to apply for a review, is welcome, particularly for those who self-represent. In Schedule 3, the attendance at the divorce proceedings to appear by video, we believe that promotes access to justice in our very remote areas, is more cost-effective, reduces the needs for parties to become face-to-face if it's not safe, and where safe for both parties, they could appear via video. It is beneficial to allow courts to determine sole divorce applicants and proper consideration for arrangements for children under the 18 when making divorce orders needs to be considered. For the support for the information orders provided by the department, we need to be aware that we're in support of this. However, providing information can put parties at risk of harm. I think overall we wanted to note that we support the amendments and see this as a stepping stone as the overall reform to family law, and commend the family law arrangements that now include family definitions to consider kinship care and the culture. These amendments strengthen the support for Aboriginal and Torres Strait Islander women fleeing violence. We know, again, the Metcalfe Review highlights the role of our sector and supports our model and the hub model for outreach, as does the Mundy Review. We see this very much as incremental building in a longer-term roadmap, and we believe it needs to align with the policy positions also taken overall. Thank you.
Thank you very much. And we'll go to National Legal Aid next. Do you have an opening statement to make?
Yes, and I've already provided it to the committee, so I'll keep my comments brief.
Thanks.
I'd just like to also acknowledge that I'm on the land of the Gadigal people and pay my respects to elders past and present. Legal Aid Commission, National Legal Aid represents the 8 state and territory legal aid commissions, who are the largest providers in the country of family law, family violence and child protection legal services. Alongside that, we provide a range of specialist programs such as the Family Advocacy and Support Services based at the Family Law Courts and the Independent Children's Lawyers Program. Like our witnesses before us, we very strongly support the systemic reforms that will be enacted through the amendment bill. And we really support the distinct recognition of family violence as a factor in property disputes. These reforms will promote the safety of victim survivors of domestic and family violence, who are predominantly women and children, and it will recognise and address the impact of family violence on the economic well-being and housing security of victim survivors. Our lawyers see firsthand the impacts of domestic and family violence on their clients, and so we really look forward to seeing, hopefully, this bill being implemented. We do think, however, we've got a few things we just would like to be considered. We're not suggesting at this stage that there be changes to the legislation, but we do think there's some things that need to be considered in terms of the implementation of the bill. One thing that we just want to highlight and ensure that in development of any practice guidelines or policy that might go with particularly the protected confidences, that consideration of the best interests of the child remain at the forefront of consideration of how protected confidences may work. Our independent children lawyers often need to access a range of documents to really make sure that they're providing and understanding the situation for children. So we just want to make sure that that's a lens that's applied in terms of implementation. And we also want to make sure that the implementation of the process doesn't create additional administrative burdens and additional processes, both for unrepresented or self-represented parties, but also for independent children's lawyers and other legal aid lawyers who are already providing services with very under-resourced circumstance in terms of how their fees. So we recommend absolutely that the bill, if it can be amended, that would be great, but also that there's consideration to require the court to advise parties and refer them to legal advice in circumstances where one or both are self-represented around the protected confidences issue. And we would also recommend that there's a provision in 3 to 5 years to review the bill so that we can make sure that the processes are implemented appropriately and are meeting the needs of victim survivors in particular, but also making sure that the processes make sense and are not creating too much administrative burden. And then the final thing I would just mention that any legislative change or implementation of a reform works best when there's appropriately resourced parts of the system. And so we would really just want to highlight the importance of appropriately funding and providing access to legal assistance services for people experiencing disadvantage, particularly victim survivors of domestic and family violence. That there's greater access to family violence and trauma-informed, culturally safe specialist services, which I've just mentioned, and also a support of greater diversity and inclusion in the family law profession and across the system to just ensure the diverse needs of the Australian community can be met by the system. And I would, in that instance, would support the evidence put forward by Mrs. Staines in terms of the need for culturally safe and culturally appropriate services as well.
Fantastic. Thank you very much. Ms. Bradshaw, I think it was, from Women's Legal Services Australia.
Yes, thank you. I'd also like to start by acknowledging the traditional custodians in the land that we meet today. For me, it's the Turrbal and the Yagara people. Women's Legal Services Australia is the national peak body for 13 specialist women's legal services in each state and territory. Women's Legal Services provide free legal assistance and wraparound support services to women to ensure a trauma-informed, multidisciplinary and integrated approach. Every year, Women's Legal Services assist over 25,000 women, and we see firsthand the impact of family violence on women's economic wellbeing, housing security and health, which is often exacerbated by the unfair or unjust distribution of property post-separation. Women who access our services often report being scared of seeking a property settlement due to fear of escalating violence. We also know that women often do not leave violent relationships because they are effectively forced to choose between violence or poverty. We know that perpetrators will often use systems to perpetrate further violence, such as withholding financial support and failing to disclose financial records. I would like to share with the committee a case that illustrates the type of matter where reform may make a significant difference to the life of a victim survivor. In this case, both parties were in their late 70s at the time of the family court proceedings. The husband had perpetrated violence against his wife for over 50 years of marriage. The husband was eventually charged and faced criminal proceedings. It had taken the wife many years of counselling to get to a stage where she could talk about what happened to her without being afraid of the husband's reprisal. At separation, they agreed to an informal property sale, and the wife believed that the home she lived in with their son was her property to retain. Nearly 20 years after the separation and the informal property settlement, the husband commenced court proceedings to seek orders for the sale of the house. The wife at the time was living with and caring for their adult son who had special needs, and he relied on her for his daily care and residence. The proceedings in the court had focused on the contributions of the parties. The husband did not disclose the family violence. The wife was unrepresented because her legal aid grant had expired. She had disclosed some family violence, but was too traumatised by the proceedings that were commenced so long after separation, and also the fear of becoming homeless in her 70s, and that the husband was still able to inflict harm so many years later. She was unable to disclose the violence she experienced in sufficient detail for the court to flag the relevant case law. From the wife's perspective, she struggled to understand how it was just and equitable that a man who abused her and her children for so many of their lives was able to sell the house she lived in and leave her and her adult dependent child homeless, while he continued to work and was financially supported by his current partner. Relying solely on the old age pension, she couldn't afford legal representation. Being forced to engage in proceedings was traumatic enough, and it made her feel like she was being victimised all over again. Women's Legal Services Australia has long advocated for family violence to be considered in financial proceedings, and we support the reforms in this bill to recognise economic and financial abuse. We also call for adequate funding to guarantee access to legal assistance services for people experiencing disadvantage, including legal aid and specialist women's legal services. We call for funding to ensure that access to family violence and trauma-informed and culturally safe specialist legal assistance services are available, particularly for women who are victim survivors of violence. Thank you.
Thank you so much. And the Caxton Legal Centre.
Thank you. We at Caxton also acknowledge and pay our respects to the traditional owners of the land we are on in Brisbane, the Turrbal and Yagara people. Caxton has over 40 years' experience in family law, including as duty lawyers assisting self-represented litigants at the Federal Circuit and Family Court of Australia in Brisbane and the Family Advocacy and Support Service. We are respondent duty lawyers at the Specialist Domestic and Family Violence Magistrates Courts in Brisbane, and we assist older persons experiencing or at risk of experiencing elder abuse as a form of domestic and family violence through our Seniors Legal and Support Service. We broadly support the Family Law Amendment Bill, and in our opening statement would like to highlight two key areas. Firstly, we support the inclusion of the just and equitable requirement across the decision-making steps, which makes it clearer that the starting point for separated couples is the status quo, that is, the arrangements that the parties have put in place, unless it is fair to make an order to adjust that. This is particularly relevant to older persons who are separated by illness, in instances where one person no longer has capacity to be part of the relationship or to make decisions about finances and may need to go into aged care. These older couples, who have equal bargaining power, may have put in place long-term arrangements for their future. When separated by illness and the need for a property settlement arises, one of two things usually happen. Either the party who is not in aged care and who retains decision-making capacity prioritise their own needs, sometimes understandably, and no longer prioritise the needs of the couple, or a third party, often an adult child, acting as a substituted decision-maker, conducts negotiations on or engages in proceedings on behalf of the party with impaired capacity, in cases where they may have a conflict of interest and be motivated by inheritance protection, especially in cases where there has been a second marriage. The proposed amendments to the just and equitable requirements offer safeguards to the more vulnerable person in these circumstances. And secondly, we broadly support the approach to the less adversarial trial processes. As duty lawyers, we commonly assist parties who have not complied with any filing requirements and are already being threatened with contempt proceedings by the time they come into contact with us. In these circumstances, the other party is extremely frustrated by the lack of action causing delay by the other party. Both parties are usually desperate for proceedings to be expedited. Thank you.
Thank you very much for all of those opening statements. I know the three senators have a lot of questions for all of you, so we'll start with Senator Scarr and then we'll go to Senator Waters, who's joined us now on video conference. Welcome, Larissa. Senator Scarr, you have the call.
Thank you, Chair. And at the outset, if I can acknowledge all the work that the witnesses and your organisations do, you make such a profound contribution and assist Australians in times of dire need. If I can be parochial for a moment and recognise my friends at the Caxton Street Legal Centre, you've got 3 Queensland senators here, so we're all very familiar with the work that Caxton Street does. So thank you very much. I want to put to you something from the Law Council of Australia submission and just obtain your response. In paragraph 28, and I quote, "We have concerns that without substantial additional resourcing, the measures proposed in this bill will further increase unmet demand and will place such pressure on the existing family law ecosystem that they will fail to achieve the government's aims." End quote. So I just want to give each of you an opportunity to provide your reflections on that statement and the need for resourcing to accompany these changes, which could well lead to greater demand for the services you provide. So if I can start with Hamish and Amity.
Thank you for the question, Senator. We agree that there is a greater need for increased resourcing, both for services provided in court to support with the implementation of these processes, so increased funding for services like FAS, increased funding for duty lawyer services that a lot of our organisations provide, yep. And increased funding for general legal assistance from the very start when people come in from legal advice throughout their matter, yep. Noting that at the moment, particularly with duty lawyer services, it's often hard to support people throughout litigation, and that often that assistance is kind of just provided at the front end. And so we would really appreciate greater resourcing throughout to support litigants throughout the matter. We believe that the reforms put forward here are of such an importance that they need to continue, and that resourcing needs to flow from that rather than the current lack of resourcing being a barrier to these important reforms coming through.
Okay, thank you. And just to continue that theme before I move on to the other witnesses, I note there has been some increased funding provided by the government in relation to this space. The point that I took from the Law Council of Australia submission and some of your submissions was, from my perspective, clearly family violence needs to be considered in these contexts, and it's right that it's considered in the Act, but it is going to lead to questions having to be litigated in the courts, potentially evidence being provided, perhaps longer hearings, which are necessary in the circumstances. So in that context, your comments with respect to the Law Council of Australia observation, Mrs Staines?
Yes, sure. Thank you. I think, and whenever there's a change in any bill, there needs to be resources around education for both the practitioners to be able to apply those laws on the ground. I think with response, so if we look at, for instance, the children contact centres, which I mentioned, I think if there's some additional resourcing into those areas at the front end, we're hoping that that actually stops more litigation going through to court so that mediations are more successful and they're safer. So I think if there's an investment at that front end in the longer term, we'll see a reduction, hopefully, in costs, court costs in that way. So I think initially there needs to be an increase in resources, both obviously with the current processes and then with the new implementations. But like I said, with any change, there needs to be resources, and given the pressures that all of our services are currently under, any change, you're right, there has been an investment, but that flow has not yet to come through, and we don't know the details of that yet.
Okay. Mrs Bradshaw, do you have anything to add?
Yes, thank you, Senator. So the current data from the court is that over 80% of cases currently involve domestic violence. So the court is already dealing with domestic violence matters day in, day out, and they're well placed to do so. In addition to that, changing legislation is also about increasing the community awareness. We know that many people settle their property settlement matters outside of court, and it's so important that the Family Law Act highlights domestic violence so that not only the court but also the community know that this is a relevant factor when dividing property.
Okay, Caxton?
We do echo the sentiments of our fellow witnesses. We do believe that there is a strong need for further funding and resourcing while we support the amendments. Particularly with property settlement matters, what we find as duty lawyers based at the Brisbane Court is that there is a very large amount of self-represented litigants who are not eligible for legal aid funding because it is quite hard to get that funding for property settlement matters only. However, they can't afford to pay for their own private representation. And the vast majority of people that we come across, there is family violence in those matters. So there really is a need for community legal centres, especially, we believe, who try to fill that gap of people who aren't eligible for a grant of aid but can't afford their own private representation, to have further funding to be able to assist those people.
Okay. Ms McKinnon?
Thank you. I would echo everything that's already been stated by my colleagues and fellow witnesses. The thing that I will add is, yes, as Mrs Staines mentioned, there has been an announcement of additional funding for the legal assistance sector, which is prioritising domestic and family violence, and we are yet to see how that is to be distributed. That will go some way to supporting, the ability to meet the demand. But I think I would also like to note that there have been two reviews. There's been the review into the National Legal Assistance Partnership, and there's also the Family and Relationship Services review, and both of those reviews have recommended looking at investment in the service system. And so part of the National Legal Assistance review, and then the negotiations around the National Access to Justice Partnership is looking at the long-term reform required over the next 5 years. And so we are looking at working with the government around moving to, and it's recommended in the NLAP review, looking at moving to a justice impact assessment being made when legislation is changed, to look at the impacts on the service system and make sure that funding is considered alongside any legislative change in the service system is considered. And so we look forward to working with the government, continuing to work with the government on that long-term reform piece.
And just that point you made about justice impact study, that's the point that's made by the Law Council of Australia as well. And they raised it in the context where the government, and I'm not saying this in a partisan way, the observations made that the amendments will have nil financial impact. And the Law Council says, well, actually, we need more resources to provide the services that will flow as an indirect consequence, or perhaps as a direct consequence, of these amendments. Is that the context in which you're saying that a justice impact study should accompany reforms like this?
Yeah, absolutely. That's what we're saying as well. That as we've all said, and the best way to make sure that victim survivors are kept safe and able to access what they should be accessing is when the service system is adequately resourced to provide that support, and that's across the system from within the community, as Mrs Bradshaw's mentioned, in terms of communication and awareness of people who don't go through the court system, but also within that system as well.
Okay, thank you. Sorry, I'm just trying to work out, have I left anyone off? I think that's it. Okay, good. We've got a large panel, so I'm...
may I just add a comment in relation to your line of thinking there? And I think it's always important to think about the downstream impacts of legislative change on finances. But currently, the costs are effectively being borne by victim survivors through family violence not being taken into account when property is divided. So that's where the savings are made presently, and so I'd just encourage you to consider how appropriate that is.
Sorry, just so I understand the basis for the reforms. So when you're saying the savings are made...
Well, currently, effectively...
Under the existing system?
Exactly. So if we take your point that...
I think I understand. If I can just reflect it back to you, I think you're saying, well, the savings at the moment are coming from the pockets of people who are suffering family violence.
Yes.
They're the ones who are basically paying the cost. Is that the point you're making?
Yes.
Yeah, thank you. I want to ask, and I've got limited time, and there's a lot of you, which is great. There should be more of you. And you should be funded more. So I want to ask you about this issue around compensation awards and the extent to which compensation awards flowing from family violence should or should not be taken into account in the context of properties, settlements and spousal maintenance. And in this regard, and I might start with the Women's Legal Service in this regard, I noted with great interest paragraph 40 of your submission where you said that in some jurisdictions, and I quote, compensation can be refused if the perpetrator may benefit, end quote. So there's a concern that unless you, as I understand it, unless you exclude a compensation award, it might have this perverse effect that the victim doesn't get compensation. So I'm interested to explore that issue. So to the Women's Legal Service first.
Yes, thank you, Senator. So the current position in the family law system is that someone can seek that a compensation payment not be included in the property pool, but those principles and arguments come from case law, which we say should be in the legislation. It should be made really clear in the legislation that if you receive a compensation payout, particularly as a victim survivor of domestic violence, that should not be taken into account in the division of property.
Okay. If I can ask the other organisations if you've got any views with respect to that. Ms Mara?
Yeah, we would really echo the sentiments of Women's Legal Services Australia. We find that at the moment with the case law, there are narrow circumstances where you are getting compensation awards being included in the property pool. And given the nature of why those compensation awards are being provided, we think that's entirely inappropriate, and that those compensation awards should really be cordoned off so that they can support victim survivors in their journey of recovery.
Okay. Mrs Staines?
Completely echo Ms Bradshaw's comments, and it makes total sense. I can't understand how that would be considered appropriate.
Okay, thank you. Ms McKinnon?
Support the position put by Mrs Bradshaw, and I don't have anything else to add.
Okay, thank you. Ms Botts and Ms Pratt?
We also support the position of the Women's Legal Service. No further comments from us.
Okay, thank you. A comment, third topic is the issue of costs. And I want to... sorry.
After this question, I'll hand the call over. So if you've got this question, and then I'll hand the call to Senator Waters after this round of questioning.
Okay, that's fine. And just before I get to this question, could I ask all of you just to take on notice the Law Council of Australia's submission? They made a number of recommendations. I'd be keen to get each of your views with respect to those recommendations and whether or not you agree with them or you have any concerns with respect to them based on your practice at the coalface. That would be very useful. So the last question goes to this issue of costs, and the Women's Legal Service in their submission, I think it's touched upon in some of the other submissions, says Section 114UB3B should be amended to ensure women's legal services clients are protected. The cost provision should apply to clients of all legal assistance providers, including legal aid commissions, community legal centres, family violence prevention legal services and Aboriginal and Torres Strait Islander legal services, end quote. So if again I can start with the Women's Legal Service to explain why that recommendation is important.
Yes, thank you, Senator. So the bill proposes to amend the cost provisions to set out the circumstances that the court needs to take into account when awarding a costs order. And in the bill, it currently refers to if a party is in receipt of legal aid. And what we say is that that doesn't go far enough, that legal aid doesn't necessarily mean community legal centres. It does not necessarily mean women's legal services. And we would hope that that is the intention of the section, because we do get the same treatment in the court as legal aid, for example, fee waivers and the like.
Okay, I understand, and I'll certainly endeavour to flush that out. Does anyone else have any questions in that? Any additional comments? Everyone's in agreement with that principle, I assume. Okay. I note you're all in general agreement. So thank you, Chair.
Thanks very much, Senator Scarr. Senator Waters, you have the call.
Thanks very much, Chair. Good morning, everyone. I acknowledge First Nations owners of the land I'm calling in from in Meanjin, and credit to the other Brisbane-based folk here. And also just thanks, as always, to the CLC sector for ensuring access to justice and doing so on the smell of an oily rag. Appreciate deeply the work that you do. A number of the issues that I want to cover have been touched on, and we've begun the exploration with the questions already. So I want to delve in particularly to the protected confidences changes. And I might start with Ms Bradshaw at Women's. Could you please, for the benefit of us all, outline for us what are the current rules in relation to disclosure of protected confidences, both through the subpoena phase and through the evidence adducing phase? So what do the current laws say about that, and how does this bill propose to change that, and do you think it's doing so in the right manner?
Thank you, Senator. So the current process for subpoenas in the family court is a process through the registry. So what I mean by that is a party files a subpoena in the registry. There's no hearing. It's then served on the interested party, and then the records are produced to the court. So in order to object to those records being produced, a party needs to file a notice of objection prior to anyone inspecting those records. So there's no hearing to discuss whether or not the subpoena is appropriate. It's all done on the papers through the registry, unless a party or a agency, such as a councillor, objects to the subpoena. And what we see in practice is that subpoenas are rarely objected to. The grounds for objection currently are if the records are irrelevant, privilege, like legal privilege, or too broad. So with this bill, the proposed change is to essentially establish a two-stage process. So where the subpoena can be objected to. So my understanding of the bill is that the process would remain the same unless the court made different changes to their practice and rules. But essentially, the subpoena is still filed in the registry, but it can be objected to prior to the records being produced, and then secondly, prior to them being adduced, so relied on in the proceedings. And so the bill sets out the factors that the court should take into account if there is an objection regarding the production or adducing of the evidence. And the bill goes into some detail of explaining the harm that can be caused by those records being relied on. And we support the definition of harm in the bill and all of the factors that the court needs to take into account. In relation to the third part of your question around does it go far enough, in our original submission on the exposure draft, we did support the onus being on the person seeking to file the subpoena to seek leave first. As you know, that has been removed from the bill. And so now it is for the victim, survivor, the counselled person or the counsellor to object at one of those stages in the matter. If the onus is not switched back, as the exposure draft proposed, we think that there's some changes that could be made to the bill that would provide some additional protections. And I'll just take you briefly through those, but they are set out in detail in our submission. The first one is just ensuring that the definition of protected counselling records is broad enough, and it does include not only the file notes from the counselling, but any records associated with the counselling. And that would make the definition similar to the sexual assault counselling privilege provisions in New South Wales and Queensland that Women's Legal Services assist with. The other change we suggest is also clarifying the specialist service. The bill talks about records of the specialist family, domestic violence and sexual assault service being covered by the provisions, but it's not defined. In addition to that, we also suggest that an additional factor could be included where the court has a positive obligation to advise a counselled person that they can object. So that provision exists in the New South Wales legislation around the sexual assault counselling records, and we suggest that that should also be in the bill. Because what we see in practice is that so many victim survivors don't know they can object. And that's the current situation, and perhaps could occur with the bill. And it's so important that people know that they have the right. And finally, that they also know they can consent and getting advice about consenting. So our final suggestion is to expand the circumstances around consent, so it makes it clear that a victim survivor can consent to all or part of the records, and also suggesting that they receive legal advice about those records. Hopefully I've answered the question.
Yeah, thank you. That's such a clear distillation of what has been quite a convoluted process. So as you rightly refer to in the exposure draft of this bill many months ago, there was a proposal at the time to switch the onus so that the person who wanted to access the other person's counselling records had to effectively show why that was going to be relevant to the court proceedings. So I share Women's Legal Service concern that proposed switch of onus has been dropped. But I'm quite attracted to the protective suggestions that you make. I understand government's not for turning, so they're not going to change the onus back. But I like your 4 suggestions there. So hopefully the committee can take those on board, and perhaps we can. I'll certainly be suggesting that we recommend that those changes be made. Just in relation to your suggestion that parties be informed that they can consent either fully or partially, and that they should get legal advice on which course to take. Have you got a suggestion about particular funding that should attach for CLCs to be able to help applicants and respondents at this point in the court proceedings?
Yeah, thank you, Senator. Adequately funding the legal assistance service is always a huge issue. And we know that with the sexual assault counselling privilege provisions, when they were introduced in the states, for example, in Queensland, that was with additional funding. And so in Queensland, we provide advice and representation to counselled people in criminal proceedings. We provide that in conjunction with Legal Aid Queensland. So we provide them with advice and assistance regarding their rights to object or consent.
Okay, thank you. That's really, really helpful. Can I take you now to one of your other suggestions, which I was really intrigued by? The bill makes some changes to divorce proceedings, but what it doesn't change, and what you're suggesting that it should change, is in section 44(1)(b) of the Act. There's a requirement for parties to attend counselling prior to making an application for divorce if they've been married for less than 2 years. Now, I'm astounded that that's still on our statute books. It seems quite an ancient notion that people shouldn't be in charge of their own affairs and don't know their own minds. And can you run us through why you think that should be removed, and why the hell it's still on our law books?
Thank you, Senator. Yes, absolutely. We support the removing of that requirement. In terms of why it exists, I think that's difficult to say, but what I can say is that I don't think it's in line with the current situation for families, and that people should be able to choose to separate without having to undergo this onerous and sometimes quite traumatic process. People should have the right to divorce if they want to.
And it sort of ignores the fact that there's quite long waiting lists for counselling anyway, even if you were motivated to do so. And surely if you were doing so, it should be voluntary. All right, thank you. Can I just do a sense check with the other CLCs? Do other folk agree that we should get rid of that old provision?
Yes, Senator. Certainly Fitzroy Legal Service does, yes.
Yes, FNAV concurs.
And so does National Legal Aid.
Great. All right, thank you. And apologies to the folk who aren't online because it's a bit tricky to see who I have and haven't missed. Sorry, Chair, I
need to share the call with myself because I've got a couple of questions about similar types of provisions. We've got about 10 minutes to go. So if you've got one more question to put, and then I'll share the call.
Okay. Well, can I ask, please, to FNAF, can you run us through the specific impacts of the changes proposed in this bill on First Nations communities? Does it go far enough, and are there any other reforms that you'd like to see?
I think, as I mentioned in the opening statement, we see this as a stepping stone with the overall family law reforms. And so, yes, we think this is strengthening the position for the Aboriginal community-controlled sector and our Aboriginal women victim survivors. However, we do need to see it sitting within the larger policy context, such as Monday's review and some of the suggestions. So I guess couched within a roadmap, we see this as, yes, one of the stepping stones, and it's built on the previous amendments, and I guess we need to do more, but I think we're certainly going in the right direction.
Thanks, everyone.
Thank you, Senator Waters, and thanks to all our witnesses. I just have a couple of questions. Some of them have been covered already, so I've gone through and crossed out a few, but if I can go to that question that Senator Waters was just asking you about, the provision for couples to attend counselling if they've been married for less than 2 years. I have to say, I also think it's a bit outdated. But I was wondering, probably the evidence that we probably need as a committee to make some recommendations around that would be what the detriment is to anyone involved in that process, but particularly if there's women involved in family violence, what the detriment of that existing provision might be on your clients. I was going to put that question to Women's Legal Services, but I'm happy for anyone else to answer.
I'm happy to answer. So yes, of course, requiring a victim survivor to attend counselling is a very traumatic process. In addition to that, it's a very confusing requirement, and particularly for culturally and linguistically diverse women, understanding this requirement because they've been married less than 2 years means they need to attend counselling.
And has any of, maybe from a National Legal Aid's point of view, have you had circumstances where you've had clients in family violence situations that have had this requirement on them and it's made them, I guess, wait longer before leaving a relationship?
I can't comment directly to that. I would just reiterate what Mrs. Bradshaw said in that, victim survivors of domestic, it's completely inappropriate for victims of domestic and family violence to attend counselling that's not put in the safety and other arrangements to ensure that it's not contributing further to that violence. And so in terms of ensuring victim survivor safety, it's really important actually to remove that requirement because, as Mrs. Bradshaw's outlined, it has a range of impacts in terms of people escaping that violence, leaving a relationship, and actually accessing help.
Okay, thank you very much. I really appreciate that. I'll stay with you, Mr. and Mrs. McCorman, and ask about we've dealt with these issues, through the previous bill and through a few different inquiries. And one of the things that comes up a lot from victim survivors is child support and how child support is used as a way of inflicting further sort of control, coercive control and violence as well. And you make a recommendation around including the withholding of child support as an example of economic and financial abuse. I think it's a good thing that economic and financial abuse is being included in the bill. It's sort of one of those things where you thought, why isn't it already in the legislation? But here we are, we're putting it in. But what has prompted you to ask for that particular sort of characterisation of economic abuse to be included, and how does it sort of play out for your clients?
Thank you very much for pointing to that recommendation, because yes, absolutely, we would love to see reference to child support made. The reasons for that is we provide support, legal representation and advice to child support in the child support space, particularly for victim survivors of domestic and family violence. And we've been working with Women's Legal Services Australia and a number of other stakeholders on the changes that are needed to the child support system to really make sure that victim survivors are able to access and be financially independent and access the financial, the finances that should be coming to them. We just think that child support is such a critical part of how financial abuse can occur and economic abuse can occur for victim survivors. And so in terms of strengthening the legislation, it's just really important, I think, to acknowledge that is a key lever that unfortunately perpetrators may use to continually financially abuse their ex-partners. And so we just really think it's critical for that to be at the forefront of people's minds in the family law system as well, alongside the child support system.
Thanks very much. Thanks for your recommendations. If I can go back to the Women's Legal Service, I read through your submission and there's quite a few recommendations in there. I just want to go back to, I guess, the premise of family violence being included as a consideration in the division of property. I note that you support that and you've called for it for a very long time. It's something that it seems like we've finally got there, but I really want to understand the impact of family violence on future circumstances and why that should be taken into account. And why it should be codified in the law. Your submission sort of talks through that, but particularly around future circumstances and how that would, family violence continues to impact someone in a property or a financial point of view after the relationship's ended.
Yes, thank you, Senator. So the current position is that it can be taken into account pursuant to case law. And so you've probably heard of the case of Kennan, where it stated that family violence could be taken into account if the contributions were made more arduous. So the case law has developed a bit over time to widen that to some extent. However, the legislation the bill makes it very clear that it should be taken into account at contributions, but also the future needs, as you highlighted. In relation to future needs, how family violence impacts on a victim survivor's future needs is complex and wide, but some examples of that is a victim survivor not being able to work due to their physical or psychological impacts of the family violence, and then that has a flow-on effect in terms of the victim survivor's income and superannuation. And also the reduction in the property pool potentially. So can then result in the victim survivor living in poverty as a result of the family violence.
Thank you. Thanks very much for that. I thought I've just skipped through a few things that have already been asked, but the other question I had for the legal centres, we've touched on the cost provisions with you guys and with the other witnesses. Just to make sure that this is covered off, the bill clarifies that a recipient of legal assistance under family violence and cross-examination of parties scheme, which is not means tested, is automatically exempt from contributing to the cost of an independent children's lawyer. I just wanted to understand whether that means that how that would impact your clients. Would your services be in a position to know if your clients would fall within the financial hardship provisions? And would any of your clients not fall within the financial hardship provisions? So I'm essentially asking how that would play out for your clients. Maybe if we start with the Fitzroy Legal Centre, if you have a view on that. You could also take it on notice if it's something you haven't.
Thank you, Senator. We
yet.
can speak briefly to it and happy to send through further information if needed. So we assist a wide variety of clients, and some of our matters are eligible for legally aided funding, but some of them are not. And our clients can face hardship in a variety of ways and for a variety of factors that sometimes go beyond the simple financial hardship provisions. So, for example, they could be victims of multi-generational violence, or they could be from a community that's traditionally targeted from oppression that makes it a lot harder for them to access the legal system. And so those clients tend to fall through the gaps with the existing sort of proposals and legislation. And so a slight broadening of those rules would help us capture more of our clients who we strive to assist.
Great, thank you. And Caxton Legal Centre, if you have a view on that one. Yep.
Yes, so we have like an eligibility criteria that we do apply for clients in terms of those that we can assist, and particularly assist on an ongoing basis as well. And so there are people who do face significant financial hardship and they simply cannot afford their own legal representation. It's really inaccessible to a very large part of our population. So yes, expanding and clarifying those costs provisions would definitely assist our clients because it's not something that they have the finances for.
Great, thank you. I only have time for one more question, so I may put a few others on notice. But one thing we haven't touched on with this panel is the inclusion of pets in the property orders, part of the Family Law Act. I thought I might ask you, Ms Bradshaw from the Women's Legal Service, people might not understand how pets are used, particularly in the breakdown of relationships where there's been family violence. Just for the benefit of the committee and those that are watching online, can you just explain how including companion animals, as they're referred to in the bill, will actually assist those property orders to be made?
Yes, thank you, Senator. So in our experience, pets are often a reason why some victim survivors don't leave violent relationships, because they don't know where they can go. A lot of emergency accommodation does not allow for pets, and so in practice many victim survivors stay in a violent situation because of that concern. In addition to that, we see that some perpetrators of violence use the pet as a way to control and sometimes actually commit violence and other horrific acts on the pet to cause harm to the victim survivor.
And that past evidence of possible cruelty or family violence will be taken into consideration when the court makes that property order, if I'm right, if I've read it correctly. Is that right?
Yeah, that's also my understanding of the bill, and that's not the current situation.
Yeah. Okay, well, thank you so much. I'm so sorry that I've run out of time with my questions, but I want to thank all the witnesses for attending today and for your I'm sure I share the views of other senators, and thanking you for your very detailed submissions as well. They're very helpful for us to concentrate on the issues in the bill, but acknowledge the broad support for the purpose and reforms in the legislation. So thank you very much for appearing today. Our next panel is ready to go, so we'll do a swap over of witnesses and then I'll go through the opening statement I need to make. Thank you.
Thank you very much.
Thank you.
Thanks. Okay. Now, I think our next panel is standing by, and I think we have a few people online and in person, so I might just go through the opening statement that I need to make and then we'll hand over to witnesses to see who we've got online. I'm now welcoming representatives from the National Women's Safety Alliance, Lucy's Project and the Council of Single Mothers and Their Children. I understand that the National Women's Safety Alliance are joining us in person and via video conference today. Lucy's Project and the Council of Single Mothers and Children are also joining us by video conference. So we'll just wait till everyone has signed in. So that's great. Thank you. Thanks for taking the time to speak with the committee today. The information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? We can start with the National Women's Safety Alliance. Angela Lynch, Ms. Lynch, are you there? Oh, we've got someone in the room, so we might start in the room and then we can go from there.
Hello, my name's Catherine Burney. I'm the Executive Director of National Women's Safety Alliance.
Thanks, Ms. Burney. Ms. Lynch?
Yes, it's Angela Lynch. I'm appearing today as a member of National Women's Safety Alliance.
Thank you. And Lucy's Project online, I think we've got Ms. Dam with us today.
Yes, hi Senator. My name is Monique Dam and I'm the CEO of Lucy's Project.
Thank you. And Ms. Sebastian from the Council of Single Mothers and Children.
Yes, indeed. Good afternoon, Senator. Good morning. I'm Communication and Policy Coordinator at the Council for Single Mothers and Their Children.
Thank you so much for all joining us today. Would any of your organisations like to make a brief opening statement before we go to questions? And we'll start in the same order if that's helpful. And we'll start with the National Women's Safety Alliance. We've got an opening statement.
Thank you, Senator. We do. Thank you for the opportunity to be here today. I'd like to begin by acknowledging the traditional owners and custodians of the land that we are meeting on, the Ngunnawal and the Ngambri people, and pay my respects to elders past, present and future, as well as acknowledging any Aboriginal or Torres Strait Islander people who may be in the room or online with us today. The National Women's Safety Alliance brings together over 780 individual and organisational members to provide policy guidance, lived experience and frontline expertise to inform national policy and reform on women's safety. NWSA strongly supports the proposed reforms. Central to our submission is the emphasis on how the family law system must evolve to better address the realities of domestic violence, coercive control, economic abuse, while ensuring children and victim survivors are at the centre of legal considerations. A key priority for the NWSA in responding to this bill is a central focus on safety of both children and victim survivors. The NWSA, alongside with our colleague in Women's Legal Services, assert that child safety and the protection of survivors must be foundational principles in the amended Family Law Act and should not be compromised by other legal objectives. The reforms are seen as a significant step towards addressing the gaps in the current family law system, particularly around property settlements, financial arrangements where family violence is involved. We are advocating for the immediate implementation of amendments after the bill's passage to ensure swift protection for those affected. The economic impact of domestic violence is a critical issue our membership highlighted. The financial vulnerability faced by many women, especially single mothers, after leaving abusive relationships cannot be underestimated. Women who have experienced family violence suffer significant economic consequences, including a much steeper decline in income compared to those who have not faced violence. This financial strain often leaves them at greater risk of poverty and homelessness. NWA and our colleagues call for the proposed legal changes to take these realities into account, particularly through mechanisms that address economic abuse, debt, asset wastage caused by perpetrators of violence. This legislation must ensure that victim survivors are not further disadvantaged in property settlements and that courts should prioritise their housing and financial security. Regarding property settlements, NWSA advocates for clear guidelines that consider the impact of violence on contributions to the asset pool and the future needs of the parties. The inclusion of family violence as a specific factor in property decisions is welcomed, with the expectation that this will lead to fairer outcomes for survivors. In particular, we would like to see the courts prioritising victim survivors from becoming homeless, especially when they have children. We also support recommendation that compensation awarded to survivors of family violence should be excluded from property settlements to prevent perpetrators from benefiting financially. The definition of protected confidences must be expanded to include all documents arising from counselling relationships, not just file notes. The definition of professional service should cover all counselling for sexual assault or domestic violence. Disclosure of records leave in courts must inform the confider of their rights. In tandem with this expansion, the court must address systems abuse, where perpetrators manipulate legal and government systems to continue exerting control on survivors. This includes standardised improvements in how courts identify and address systems of abuse and coercive control, particularly in situations where both parties allege violence. This is seen as a crucial step in preventing further victimisation through a legal process. The NWSA membership have emphasised the need for greater legal assistance and clearer court procedures to provide victim survivors, particularly in complex property disputes. We call for greater funding for women's legal services and improved training for family court professionals to ensure they are equipped to handle cases involving family violence, trauma and diverse cultural backgrounds. We also support the consideration of a legal program being established to assist DV/SV counselling services in responding to and objecting to subpoenas on behalf of their clients. Often these issues are complex and can involve court advocacy. Community legal centres prioritise victim survivors, and often DV and SV counselling services are unable to get advice from CLCs and are required to use their limited resources to privately fund their own legal advice on these matters. We also advocate for the ongoing training of the legal professionals to continue to obtain education on training and identifying and responding to coercive control in the context of domestic family violence. Thank you. I welcome the questions.
Thank you very much. And we'll go to Ms. Dam at the Lucy's Project. Have you got an opening statement you'd like to make?
Yes, thank you, Senator. I'd also like to acknowledge that I'm joining you today from the land of the Darug people and pay my respects to elders past and present, and extend that respect to First Nations colleagues with us today. Thank you to the committee for the opportunity to give evidence at today's hearing. Lucy's Project is a national charity that aims to improve the safety and well-being of people and animals experiencing domestic, family and sexual violence. Perpetrators of domestic and family violence often threaten, harm and kill animals to control and intimidate women and children. Women and children subjected to violence often experience grief, anxiety and fear when separated from their animals. By contrast, being able to stay with their animals can support their healing. We support the proposed amendments to the Family Law Act, which would enable courts to consider any family violence perpetrated against a party and any history of actual or threatened cruelty or abuse by a party towards the companion animal when making an order in relation to that animal. However, we think there is an opportunity to further enhance the safety of people and animals subjected to violence. We recommend amendments to the bill to ensure that family law courts prioritise the safety of people and animals experiencing domestic and family violence. Firstly, we recommend that the court should be required to regard the safety of the parties, any child and the companion animal as the paramount consideration when making orders with respect to a companion animal. Secondly, we recommend that certain considerations should take precedence over others, and primary considerations should include any existing apprehended violence order or family violence order in relation to the parties or companion animal, noting that this is not in the list of considerations in the bill. Any family violence to which one party has subjected or exposed the other party, and any child of a party or any other child in the household, noting that family violence is often perpetrated against children. Any history of actual or threatened cruelty or abuse by a party towards the companion animal or any other animal, noting that perpetrators may have harmed or killed other companion or assistance farmed and wild animals to intimidate and control women and children. And any attachment by a party or a child of a party or any other child in the household to the companion animal, noting that there may be children other than a child of the marriage who have lived with and formed a relationship with the animal. And we believe that all the other considerations relating to companion animals that have been proposed in the bill should be secondary considerations. Thirdly, we recommend against family law courts being required to consider who paid for the maintenance of an animal, as perpetrators of domestic and family violence often use economic and financial abuse, which can include controlling access to money for the payment of food and veterinary care for a companion animal. Finally, we recommend that if a court determines that neither party should have ownership of the companion animal, then it should be able to order that the companion animal be surrendered to a family member or a friend, or that the companion animal be placed in the care of a registered animal welfare charity, rather than being required to make an order that the companion animal be sold. And that concludes my opening statement. Thank you, Senator.
Thank you so much. And we'll go to our final organisation on the panel today, the Council of Single Mothers and Their Children. Do you have an opening statement you'd like to make?
Yes, briefly I would. What I'd like to do, if I may, is raise a few points that are really important to us, then just mention some other things that we'd be happy to speak to, if that's helpful to the committee. First of all, I'd acknowledge that I'm speaking to you from Wurundjeri country, and we particularly acknowledge that differently from the mainstream population, 43% of all mothers in Aboriginal communities are single mothers, and that they experience amongst the very worst kinds of disadvantages that all single mothers do. I imagine that you will be speaking with Aboriginal organisations. I hope so. But we acknowledge the extraordinary work of single mothers amongst the Aboriginal and Torres Strait Islander community over the last 200 years. We are, as I'm sure you know now, I've spoken to this committee a few times, we are not legal experts, and we are not a family violence oriented or funded service. What we are is a community service of around 6,000 members. We have a support service briefly funded by the Victorian government, which takes calls from over 3,000 women per year. And while we're not a family violence service, we are constantly engaged with women who are on the journey of recovery. And so while we don't pretend we know anything about the law, we know a lot of the problems women have with the law. So going through the things, small claims program, a very good thing and really helpful. We particularly note the very difficult situation of women who are in Australia in a marriage, in arranged marriages, or from cultures in which women are expected to cede all financial management matters to their husbands. These women are particularly disadvantaged in any form of family law property settlement. Our workers find that they may even not even understand the banking system, what their signature on a document conveys, or anything at all about their husband's income, their house ownership status, etc. So we recommend that an assessment of legal capability is built into the legislation, and where for literacy, culture and other reasons, the person has been held in ignorance of their rights, either explicitly by their partner, or where the partner now seeks to take advantage of that ignorance, they are assisted by the court and any other institutions involved, such as Centrelink and the banks, at no cost to themselves to understand their position. We recommend further that while this assistance is taking place, no dispersal of property or other action to diminish the value of the pool should be permitted to take place. The value of women's labour, where they have been the primary carer of the children, cook, cleaner, organiser, etc., is increasingly recognised and quantified. PricewaterhouseCoopers has done a study which shows the extraordinary value to the bottom line for Australia. Where this is coupled with family violence, the extraordinary toll on primary carers should be recognised in property settlements and spousal maintenance. Recovery from family violence takes various forms and varying amounts of time. It is often the case that a minimum of 5 years is required to resettle and begin to reduce such behaviours in themselves and their children as hypervigilance, mental and emotional fatigue, separation anxiety and the like, and to begin to engage more deeply with school, work, friendships, etc. Additionally, there is considerable evidence showing that these women, having given up career or reduced their paid work to be primary carer, at separation face considerable difficulties and take much longer than their former partners to retrain and re-establish, with many never making up the gap. And we refer you to the Institute Health and Welfare for stats on that. We recommend that at a minimum, the existence of family violence should raise the victims' received percentage by 10%. Now, so I say we're not lawyers, so there may be problems with that, but we nevertheless put it forward. The other things that are important to us, and I'll just mention them briefly because time is limited. The role of children. We were very pleased. I came online just in time to hear a little of the previous statement, and our first colleague from the National Safety for Women, etc., raised the issue of children and the safety of children and the primacy of the safety of children. It strikes us as ironic that this legislation that we're considering now is almost always, and indeed I think it's written into it, that it is regarded as non-child related. And yet what we see is that the decisions that are made at property settlement have a profound impact on the recovery time for children who have witnessed or been experienced in violence, or even without violence will suffer some separation loss. And we strongly support the submission and recommendations made by the Centre for Excellence Child and Family Welfare, with whom we work very closely. Child support is a form of financial violence unwittingly facilitated by family court decisions. I can explain more about that later. It is a hope that the new Division 4, which I understand will provide improved protection against systems abuse, may consider this. In response to the explanatory memo, we were party to a submission with Therese Edwards from Single Mother Families Australia and Kay Cook, Professor at Swinburne, and we emphasised the recommendations we made there. I'm just going to ask you to wrap up soon, Ms. Sebastian, so we can go to questions if you've got a couple more points to make. A couple more points. The Children's Contact Services. We absolutely support this, but we are concerned around what we often see as inadvertent disclosure of details to other parties. So we think that the committee could perhaps be recommending that in alignment with this accreditation, there has to be an emphasis on those systems that will facilitate or prevent that. And finally, experience with women whose psychological and counselling records have been weaponised against us. We strongly support the exclusion of protected confidences, or where they are required for a good reason, that there be some very good process of taking the person through that. Thank you. Thank you very much. Sorry to wrap you up a little earlier. I know we've got lots of questions for the panel. I'll hand the call to Senator Scarr to kick things off.
Thank you, Chair, and thank you to the witnesses for appearing today. And Thank you for engaging with this committee process, and I note some of the witnesses, as has been mentioned, appear before this committee on a number of occasions, and I always search the program to ensure you're on the list so we can continue the dialogue. So thank you so much for participating in this process and everything that you do in the community, especially for those in very vulnerable situations. If I could go to the National Women's Safety Alliance first, and there's a reference in your opening statement, and this is mentioned by a number of other organisations, including in the first session we had. I didn't have the chance to ask them a question on this point, so I'll put it to you. You say, in particular, we would like to see courts prioritising victim survivors from becoming homeless, especially when they have children, end quote. And I agree. The question I have is, do the other provisions dealing with, in particular, current and future circumstances, which talk about the extent to which either party to the marriage has the care of a child of the marriage who has not attained the age of 18, the financial resources of the party, etc. Do they? It would seem to me that they could or should include consideration of that issue. Why do you think there needs to be something more explicit in that regard in the drafting?
I think for me, thank you for your question, Senator. It's good to see you again. I think that we need something explicit because we still have a reality where women and children are being asked to choose between violence and poverty and homelessness. Now, that may not be the spirit of what is intended within the Act. It is absolutely what is happening on the ground, and that is the feedback from our members. I think that's why also in a lot of our points we've said we do need explicit things that we might assume are taken into consideration, but the actual on-the-ground results are, it's not. And so for me, I mean, Angie, if you want to contribute to that.
Yeah, absolutely.
Yeah, I think that... sorry, I know. Yeah, no, I think that, just backing up what Catherine has said, that making it explicit in the legislation also makes it explicit in the minds of solicitors, and some solicitors may be leading lives that are very different from what their clients lead, sure. And it really makes it explicit in how they negotiate outcomes. And also a lot of people, as we've heard, don't have solicitors, so having those explicit particulars in legislation can really guide people who are acting for themselves as well.
Okay. All right, very good. And Ms Sebastian?
I agree with everything that's been said. I'd add, Senator, that one of the most distressing things we see is where women have been severely disadvantaged after the property settlement, do become homeless, and their children are then taken away from them on the grounds that they are not able to care for them properly. Now, sometimes that is able to be fought, but this issue, and in fact it's very much hidden from plain sight, we think, in Australia, because in every state in Australia we now hear stories from women who are losing their children because of homelessness. Now, that is not all down to this particular matter, but it is in the housing crisis. I agree with Ms Lynch and my other colleague that making it explicit in the legislation will make it much clearer for those parties who cannot imagine homelessness, cannot imagine the difficulties of paying rent. Do not see, for example, the Anglicare rental snapshot that shows that something like only a small percentage of single mothers can afford the current rental housing. And there are stats that we can give you to show that. During Anti-Poverty Week, Food Bank has done a major survey which showed 69% of single parents are massively disadvantaged in this housing crisis.
Thank you very much. Ms Dam, did you have anything you want to add in that regard?
Not specific to the provisions, but I can make a comment that for women and children experiencing domestic and family violence with animals, they definitely face barriers to accessing housing that will enable them to stay together with their animals, and that is often a barrier to leaving a violent perpetrator.
Okay, thank you very much. And if I can just touch on another point made in the opening statement of National Women's Safety Alliance, and again this was echoed, I think Ms Beanie, you were here during the first session, so you heard it. You say, we also support the recommendation that compensation awarded to survivors of family violence should be excluded from property settlements to prevent perpetrators from benefiting financially. And, quote, Women's Legal Service referred to provisions at a state level where compensation may not potentially be paid if the money would end up in the hands of a perpetrator, which is something I picked up in reading the submission that's of particular concern, that unless it's dealt with, it might be a barrier to victim survivors actually getting compensation, which would be very concerning. When you talk about compensation in this regard, you're talking about victims of crime compensation. Are you also talking about damages that might be awarded against a perpetrator personally? What's the scope of the compensation you're referring to in this regard?
So with our work with Women's Legal Services Australia, who we work quite closely with, for us the scope is certainly victims of crimes and any compensation that might come from that from a perpetrator of domestic, family or sexual violence.
Okay. Ms Lynch, did you have anything you want to add to that?
No, that's fine.
Okay. All right. Thank you. Ms Dam, I want to go to this issue of companion animals. As a proud owner of a rescue greyhound called Incy, who I would never sell. Can I just ask you that you make the point, and it's a point I picked up when I was reading the legislation, that it's quite binary, the orders that the court can make at the moment. Either they award property of the companion animal to one of the parties or it's to be sold. Now, my rescue greyhound's priceless, but this concept of selling companion animals, it seems somewhat bizarre to me. I'm not sure where that concept came from. I would have thought, at the very least, there needs to be discretion for the court to make an appropriate order. So, just interested in your views in that regard.
Yes, thank you, Senator. And we absolutely agree that there should be more options for the court to be able to make an order in relation to a companion animal if they determine that neither party should have ownership. And there was some research commissioned by Animal Medicines Australia in 2022 of Australians, and they asked Australians, what options they would consider if they could not look after their pets anymore. And 59% said they would give them to a family member, 40% said they would give them to a friend, 20% would give them to a charity, 15% would send them to a shelter, and only 8% would choose to sell their animals. So I think this is why our recommendation is that the court should be able to order that the companion animal be surrendered to a family member or friend or placed in the care of a registered animal welfare charity if the ownership is not going to be given to either party.
And it also begs the question, doesn't it? What happens if the animal can't be sold? No one wants to buy the animal. What do you do then? I'm not sure what happens then under the drafting of legislation. Is that a concern?
Thank you, Senator. Yes, that is definitely a concern for us, particularly for animals who have been subjected to domestic and family violence. Often they also experience grief and anxiety and distress when separated from women and children. Often when there is violence perpetrated concurrently against women and children and animals in a household, animals may sometimes intervene and may seek to protect women and children, and so they feel a very strong connection to them, and vice versa, women and children also develop a very strong connection to their animals, who they also seek to protect as well. And this is why we're recommending that further amendments to the bill may be able to strengthen the protections and prioritise the safety for women and children with companion animals.
Can I, just in relation to this, I want to read to you what the Law Council... Have you had a chance to read the Law Council of Australia submission?
Yes, I have.
So they, if I can, and I don't want to verbal them, but they essentially support the concept, but say there are amendments needed. But they do give this warning, and I quote, "There is a very real risk that these provisions will exacerbate conflict and extend proceedings. Currently, animals are treated as any other item of property. This makes it straightforward for legal practitioners to advise parties on their entitlements. Treating animals separately will undoubtedly create complexity and potentially prevent matters from settling, or at least create conflict on that single issue. This potential complexity is indicated by the fact that there are now 6 Section 60cc best interest factors in respect to children, whilst the bill proposes 8 factors for companion animals," end quote. How do you respond to that concern? And in that regard, I'll ask you to take on notice the recommendations the Law Council of Australia makes with respect to amending the provisions that are proposed, because I'm interested in your views. But how do you respond to that concern about potential unintended consequences of trying to deal with this extraordinarily important issue, leading to more protracted legal proceedings, etc.? What's the current issue at the moment? I guess that's the crystallisation of my question. Obviously, there's a problem at the moment in terms of how the system engages with this issue. So if maybe you can draw that out for us a bit more.
Yes, sure. And thank you, Senator, for referring to that submission. We did have the opportunity to consider it, and if there are concerns about the number of considerations that the court would be required to consider when making orders in relation to companion animals, that may potentially inadvertently increase the complexity and duration of family law proceedings, then we would recommend in the alternative that perhaps family law courts could be required to consider a smaller number of factors, but those factors being any family violence to which one party has subjected or exposed the other party, and any child of a party or any other child in the household, any history of actual or threatened cruelty or abuse by a party towards the companion animal or any other animal, and any attachment by a party or a child of a party or any other child in the household to the companion animal. So this would potentially exclude some of the other considerations that have been proposed in the bill. One of those considerations, for instance, relates to who has paid for the care and maintenance of the animal. And as mentioned earlier, we think that in situations that relate to the orders to be made in relation to a companion animal, we know that economic and financial abuse is often perpetrated by perpetrators of domestic and family violence. So really, if there is a concern that for the courts have to consider a longer list of considerations that may increase the complexity, then our recommendation would be for there to be a smaller list of considerations, but that those considerations are very much focused on a history of family violence, animal cruelty and abuse, and the attachment of a party or child to the companion animal.
Okay, and just that final question, because I can sense the chair all the way from Cairns wanting to share the call.
I am, thank you.
Just the last issue. And maybe you can take this on notice by giving us some case studies, if you're aware of it, of how the current system is failing to adequately deal with this issue, and if there's anything you can add at this stage in abbreviated form, please.
Sure. We definitely can prepare some case studies for the committee, and Yes, in the interim, I'd just like to share that, in research that was undertaken in 2020 by Domestic Violence New South Wales, which is the peak body for domestic and family violence services, 55% of domestic and family violence workers said that victim survivors have disclosed to them that the perpetrator killed an animal or animals in the context of domestic and family violence. 81% said victim survivors have disclosed the perpetrator threatened to harm or kill animals. 86% of workers said that victim survivors sometimes, usually or always expressed concern for their animals or disclosed animals experiencing violence to them. And critically, 48% of workers said that their clients have delayed leaving a perpetrator by more than a year due to fear or threat of an animal being harmed. And, as we all may recall, earlier in the year, we were devastated to learn of the alleged murder of Molly Ticehurst in New South Wales, and to learn that her 12-week-old puppy was allegedly killed by her former partner in the lead up to her alleged murder. And this is why it's so important to take animal abuse seriously as a high-risk factor. And this is why we're supportive of the proposed amendments, but would also recommend further amendments to really enhance the safety of women and children. And if I may add one more comment, we do support the recommendations of the Women's Legal Services Australia that provisions concerning companion animals in the Family Law Act and family violence legislation in the states and territories should be consistent and allow victim survivors to address the care and safety of their companion animals in either jurisdiction. And that may address some of the concerns that have been raised by the Law Council in relation to the complexity and the duration of matters as well. And we would support their the Women's Legal Services Australia's recommendation that a court should be empowered to make interim orders in relation to the ownership or care of a companion animal.
Thank you.
Thanks, Senator Scarr. I do need to share the call. If you've got other questions, I could ask you to put them on notice and I'll share the call with Senator Waters.
Thanks very much, Chair. Hello, everyone. Thank you very much for your time today and for the work that you do. And in particular, Ms. Dam, really wonderful to have champions for animals and animal welfare, particularly in this context. So thanks for your advocacy to date and before us today. I'll start with you, Ms. Dam. I thought your suggestions for further amendments were very sensible and well reasoned. And thought your statistics about what people actually would like to see happen for their pet if they're not able to keep them was really helpful. So 60% for a family member, 40% would give them to a friend, and only 8% would sell them. So I suggest that perhaps the legislation should have used the word rehome rather than sell. But yeah, just flagging that we're taking those suggestions on board, and thank you. Ms. Burney and Ms. Lynch, can I go to you? Thank you very, very much for the work that you do in advocating for the safety of women as one of our national peak bodies, championing the rights of women to be safe in their homes, on the streets, at work, everywhere. Can I ask, you put some... I really struggle with the concept of protected confidences and where to draw the line, because obviously we don't want to damage the relationship with a confider, a woman, and a counsellor, in particular a sexual violence counsellor or a family and domestic violence counsellor. But you put some really interesting reasoning to us in your submission about, well, even those systems can be weaponised by a perpetrator, and you use the example of dear Hannah Clark's situation, where her estranged husband, Rowan Baxter, had essentially manipulated his counsellors and created a false evidence base that he then used to reinstate access to his kids. So we're trying to find the right place to draw the line so that justice and safety can be served in every situation. So can I ask you to reflect on, do you think the bill's got it right in relation to protected confidences and where the onus lies, what the grounds are? And Women's Legal Service made some useful suggestions for extending the definition of protected confidences, clarifying what a specialist service would mean, ensuring that the court has to tell the confider that they have a right to object, and then also the confider having legal advice to the extent that they can partially consent if they wish. Could you reflect on, please, whether you're in favour of those suggestions by Women's Legal Service or anything else that you want to share with us about this protected confidences issue?
So we absolutely support those recommendations in expansion from Women's Legal Services Australia. I think it's important to note, though, with the case of Hannah Clark and her children and Rowan Baxter as the perpetrator, the counsellor did no safety assessments for domestic, family or sexual violence. So, and yet that report was given a lot of weight within those decisions from the family court. I think we, obviously, in National Women's Safety Alliance are dealing with a lot of frontline services as our members. Now, multidisciplinary teams such as our colleagues at In Touch Multicultural Legal Centre, when they receive a subpoena for counselling notes, they have in-house lawyers who are able to go through the legislation and either make objections. We're asking small sexual violence services to be able to do that to protect their clients. And for us, that's why we need specifically called out specialist services that should be protected, because it isn't currently. And there's too much flexibility to say that it is really important that these notes are included in the discussion. And I'll hand to Ms Lynch now.
Yeah, thanks, Catherine. I think that just reiterating what Catherine said, that from the front line, subpoenaing is increasing. And that it puts an enormous burden on very critically underfunded, chronically underfunded frontline sexual violence services and domestic violence services. They are answering subpoenas, and now within this legislation, look, I think in some ways it has to remain a discretion, because in some ways some of the information in these notes will be important to the best interests of children. In making determinations in the family court, but it is putting an enormous burden on frontline. Basically, a lot of them are state-funded services answering really Commonwealth legislation, essentially. Mm-hmm. The other thing that was raised by National Women's Safety Alliance is and it should be amended within the legislation, is that this kind of, what we are seeing is the undermining of the sexual assault counselling privilege at a state level. So at state level, a number of the states do have protections around sexual assault counselling notes going into the criminal courts. But what can happen in an intimate partner sexual violence situation, if there's criminal proceedings and family law proceedings, you can see perpetrators using the family law system as a way of getting that information quite easily, And so we think, and it really is it's a public policy issue of the undermining of, I suppose, another protection that exists. And that we would ask that specifically within the how the family court makes determinations around these notes, that there is a consideration of, are they already protected, or should they be protected under the sexual assault under sexual assault counselling notes privilege, or sort of other similar privileges. So they're the kind of things, I suppose. Some of those are the other thing that we would be thinking about is, if it's not notes, should the DV and sexual violence services be providing a short, I suppose, a report to the court which protects the raw notes going forward, but provides some contextual information that the courts can still use in making determinations about the best interests of children, but also protects some particular confidences that may exist in those notes, and that they don't want to share with the perpetrator of their crime, of the crimes against them. So they're the kind of things that we've been, that National Women's Safety Alliance are sort of putting forward for consideration. And yeah, obviously some of that sits outside. It's the mechanics of what happens when this lands out in the field for frontline services. And it does create a huge burden on, and many of the services just will hand over all the notes because they just don't have the capacity to do anything else.
Yeah, thank you. So in that situation, as you rightly point out, where most sexual violence services are underfunded and frankly not even able to help everyone that they wish to help precisely because of that underfunding, and therefore can't spend the time on vetting subpoenas. In that circumstance, when all of that material gets given to the court, just for my understanding, who vets that? Is that automatically given to the alleged perpetrator, the person who's applied to access those confidences, or does the court have some lens that gets looked at before that material is given to the perpetrator of sexual or domestic violence?
Look, I've been out of practice for a long time, so I'm not really sure. But I think that there's not a lot of vetting. And I think that the broad brush of what is in the best interest of children is so broad at the moment. And that's why this need for legislation needs to be brought in to kind of narrow the focus somewhat. So it can be handed over. Yeah, definitely. Obviously, in a lot of times that may well be to lawyers, to his lawyers, but still that is highly distressing for many victims of violence to know that, issues of the utmost personal nature to them that they've been discussing with their counsellor, often about what he's done to them, is being handed over to the perpetrator themselves. So this provides a vetting, I suppose, a system of vetting, which is better. But it's really about the mechanics of how this is going to be achieved. Often the subpoenas will go to these services, and it's the services, even though the person may have the counsel person may have standing, it will be the services that will be responding. And, they already can't go to the community legal centres because the community legal centres are saying, well, we want to keep, in case the counsel person comes to us, we want to keep that, we want to keep our legal advice to them. And so then you're really in the open market of engaging private lawyers to do this work, and that's highly expensive. It's, the whole process is quite time consuming. But yeah.
And certainly, Senator, our membership testimony from current cases where people have reached out to us because they are desperate for support in these matters, there is no vetting process at this stage. And if vetting does occur, it's extremely limited, exposing those vulnerabilities to a perpetrator of crime.
Yeah, all of which really reinforces the need for better protections here, and particularly for funded legal assistance, so that people making those, the confider, if you like, can be actively involved in whether or not those documents are released or should be objected to. So thank you for going through that. Can I second?
Could I have a comment on that?
I was just going to say, Ms. Sebastian wanted to add something to that.
Sorry. Go, please.
Thank you. I agree. I agree with everything that's been said. In particular, that there's no vetting. We don't know that from the legal aspect, but we certainly know that from what's happening to women. Their files are just being handed over. One of the things that's particularly of concern to us, what women say to us, is that they had no idea when they were seeing a counsellor that this could ever happen. And it's not just them telling the story of what's happened to them. And in fact, very often that's a small part of it. What women tell us happens if they are in a situation with a trusted counsellor, then they talk about their feelings of inadequacy as a parent, their distress at what's happened to the child. They talk about their children in the most intimate ways and the difficulties that their children face. And quite often both they and the children have disguised some of that pain from the perpetrator as a strategy so it doesn't make it worse. So it's, and what we've been told and what we've seen is that some women have then had those counselling notes with those reflections about things like am I being a good mother? How should I deal with this? Have been used against them in court. In parenting decisions, though, we haven't heard of that in the property disbursement.
Thank you.
Those reflections, even under this legislation, you can imagine with the discretion will allow that in because it's an adversarial system. They will say that's relevant to the best interests of children. She will be cross-examined on it. So that discretion, this legislation will not necessarily protect those mothers.
I think that's a really powerful articulation of what we know happens an awful lot. And the other side is, of course, that many of the services that are trying to support women in this situation might then feel compelled to not take as comprehensive notes as they otherwise would, precisely to avoid any future possible disclosure, which has its own issues.
And worse, what they do is warn women that not to go too deeply into these conversations for fear that they will be subpoenaed.
Yes, and no one can heal properly if they're not getting appropriate counselling support. I've got one more.
I have a couple of questions and we're running out of time. So if I can ask you to put the rest of your questions on notice. I just have, you have covered a lot of the ones I was going to ask, but I've only got 7 minutes left, sorry. So I have to wrap you up there. If I can just quickly go to some of the issues that have been covered. I wanted to just go over the Ms. Sebastian, you from the Council of Single Mothers, you spoke in your opening statement about the importance of the housing needs of children being taken into account when dividing property. And I just wanted to see if you could elaborate on that issue. You mentioned the needs of the children being really paramount to your organisation's concerns. Do the provisions at the moment cover those needs, or how could they be improved to make sure that that's really clear in the legislation?
I think I don't fully understand enough how the suggested provisions will work to know if they will do it. But I think in response to Senator Scarr's question about homelessness and that preventative thing, I think that's where I would say we need to put the emphasis. We need to highlight for judges, lawyers, etc., that, it's the bleeding obvious. I mean, I'm sure, Senator, that you're very aware of the housing crisis in Australia and the fact that women and children are and in particular picking up Senator Waters' very last comment about the need to heal. And children are already, we're seeing, just because of the housing situation, we're seeing teachers increasingly worried about the impact of hypermobility for kids, and the going between houses is a factor in kids' education. So for kids who are subject to family violence, even if it's not, some of them, we've got mums who've got kids who have brain injury. They've been hospitalised by their fathers. But sometimes it's watching, and the witnessing is just as bad. And those kids are living with terror in their brains. And so finding that, for the women, finding that they are left with insufficient means to keep a roof over the heads of their children is, I don't know how to suggest that this needs to happen, except that I do think it needs housing, the risk of homelessness to women and children after separation, I think needs to be highlighted in the legislation, because, until and unless we have housing declared as a human right, then we have to take every possible step we can to hold up signs in front of judges and lawyers.
Thank you. Covered off the other questions I was going to ask you, so that's super helpful. If I can ask, my other questions were to Lucy's project, and thank you for articulating really clearly some of the ways that pets, I think, are used, particularly in violent relationships. we've touched on this with other senators, but in regards to the orders the court can make, they are quite prescriptive. And I was wondering about your views around the court making an order for an animal to be placed with a family member. I think you sort of suggested a few different orders that the court might be able to make, how that might be able to assist the court or, you know, to assist, I guess, the two people involved in the property settlement if they can't come to another agreement.
Thank you for your question, Senator. Yes, so we do recommend that if the court determines that neither party should have ownership of the companion animal, then the court should be able to order that the companion animal be surrendered to a family member or friend or placed in the care of a registered animal welfare charity. And I think this was also one of the recommendations in the RSPCA Australia submission as well.
Thank you. And we're running out of time, so my last questions were to the National Women's Safety Alliance, and they go to, I guess, how some of the provisions in the bill that aren't necessarily directly about family violence could assist in a situation where there is a violent relationship, and I'll take you to those. What I was really curious about, Ms. Lynch perhaps might be able to answer this one, or Ms. Burney, is the factors that are going to be taken into account in determining property orders will now include family violence, so that's great. But there's also some other ones in there that I thought really in the context of family violence would be helpful as well to people who are seeking property orders. One of them was another consideration that should be included is wastage. And there's no definition of what wastage is, so I was wondering if you could explain, I guess, what your understanding of that might be. Some of our submitters have asked for a clearer definition, so that might be helpful. And then the other one was liabilities incurred by either party, and I was thinking that might be quite helpful in situations where part of the financial and economic abuse is that either the victim survivor is asked to take out a loan or take out liabilities or incur liabilities and is essentially forced into doing that in a violent relationship, or where part of the violence is associated with, you know, gambling debts or things like that. And I was wondering about those two issues, wastage and liabilities incurred by either party being taken into consideration, how that might impact your clients.
I can talk. I mean, yes, I think that they would be really helpful for in relation to family violence matters as well. I think that in relation to wastage, that's the intentional or probably reckless disregard in relation to, you know, like reduction in the value of certain assets. And you certainly do see that in family violence with the running down of businesses. And also the running down of the value of the property as well, if he's living in the property and doesn't do anything in relation to the upkeep, et cetera, et cetera. So that wastage, I mean, obviously a definition makes it really clear. So I think it would be good to have a definition in there. Surely they can pull it out of case law. The case law would have been dealing with this for the last 50 years in family law. And the debts and liabilities also would be something that is of benefit, especially in relation to financial abuse matters, and really being able to pull out that evidence around misuse of the assets or running up liabilities inappropriately, and with the intention of her not getting anything, basically.
Yeah, right. Okay. Thank you. I'm so sorry we've run a little bit over time, and that's all the time that we have with this panel. But again, you know, I'm sure other senators would join me in thanking you extremely for your submissions and for your continued engagement with the committee on these issues, and your expert advice to the committee about how we can improve legislation when it comes before us. So thank you very much for everyone who joined us today. We're due to go to a short break, so the committee is going to adjourn, and we'll come back at 11:15 Canberra time.
We're also happy.
Thank you. Will resume its hearing, and I now welcome via video conference Professor Belinda Fehlberg from the University of Melbourne and Associate Professor Miranda Kay from the University of Technology, Sydney. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name and the capacity in which you appear today? We'll start with you, Professor Fehlberg.
Hi, I'm Belinda Fehlberg, a Professor of Law at the University of Melbourne. I appear in my own capacity and I speak to a co-written submission written by myself and my colleague, Associate Professor Lisa Samus, who isn't available to join today.
Hi there, my name's I'm Miranda Kay. I'm an Associate Professor at UTS where I teach and research family law, and I'll be speaking to my submission which was made in my personal capacity as well.
Great. Thank you both for joining us today. Do either of you have an opening statement you'd like to make before we go to questions from senators?
Yeah, I do. Do you, Belinda?
I'm happy to make an opening statement, or I'm equally happy just to go to questions.
Great. Well, Miranda, if you have an opening statement you'd like to make, and then we'll go from there.
I just wanted to say, first of all, that I actually welcome most of this bill, and I really welcome this government's attempts to try to make the family law system safer. for everybody involved. But I just have a few specific points that I wasn't sure would come up in questioning, so I wanted to talk to those. First of all, in relation to the definition of family violence, it is not the point of this hearing, but I do think the committee should note that there is a complete lack of consistency of definitions of domestic violence in every jurisdiction across Australia, and it's so unhelpful for everyone involved in the system. Once we add this new subsection 2A to section 4AB, it's going to be a very long section. I'm worried, although I understand why we're doing this, I think it might lose the simplicity and educative function of that original overarching definition, which just focuses on coercive control and fear. You just can't list all permutations of controlling behaviour, but it feels like the bill is trying to do that. And I'm slightly worried if we have a situation which is outside those list of examples, people might not realise that the overarching definition is really what's important. Just looking at one of those examples, and it's the one, it's paragraph 2 of section 4AB2A, which says sabotaging the family member's employment or income, or potential employment or income. I'm concerned that the word sabotaging could be too high a hurdle to overcome. I actually think the new definition in the New South Wales legislation, which says preventing, unreasonably restricting or regulating employment or income, is actually preferable. I think sabotaging suggests a positive action, which won't always be present. I can answer questions on that. I'm also worried this is a slightly rushed bill. There's been no tidying up of the property divisions in the Act. We still have two separate whole parts of the Act for de factos and married couples, which are identical but messy. We will still have section numbers such as section 90XZG and section 90XZJ, which are real sections which are ridiculous because there's been no overhaul of the Act. All we do every time is just stuff more sections in, and it's just such a mess. The changes feels a bit rushed, and I think Belinda might be able to answer more questions about the empirical evidence that maybe should have been behind this. However, given that, I'm going to talk just to specific provisions of the bill. The research that we do have in Australia very clearly shows that women and children are financially disadvantaged after separation. Therefore, it's unclear to me why section 79.3, which is really the main provision in this property reforms, just mirrors or codifies the current court approach. It seems to me the government is saying we're happy with the fact that women and children are disadvantaged after separation by codifying the current approach. However, if we are happy with that approach, I think it's preferable to have the steps in the legislation, but I do think that we should put the needs sections in section 79.3b before the contributions. I think needs are more important. Going on to look at the family violence contributions, look, it's better than the current common law approach, but in my opinion, the requirement that the victim of violence still has to demonstrate an impact on their ability to contribute is really unfortunate. If you have a resilient woman, like the wife in the case of Bridges, who continued to make contributions in the face of severe violence, she will still continue to receive no adjustment whatsoever for family violence. In that case, the judge said the father had definitely engaged in family violence towards the mother and the children, and the family and the violence had a significant impact on the mother, but then went on to find that within that context, the mother has been able to, and this is an amazing woman, improve her financial position. She's undertaken study, she's obtained employment and been the main financial contributor. Therefore, the court could not infer that the family violence had any adverse impact on her contributions, and so it was not appropriate to make an order. That decision would, I think, be decided in exactly the same way after the new bill. In an even more extreme case, the case of Farina and Loss in 2019, which involved allegations of physical abuse, including dragging the de facto wife by her hair, reversing a car into her, destroying her belongings, psychological abuse, financial abuse, killing her cats, and threats to set her on fire, the court held that the violence would have had a serious personal impact on her, but that conduct by itself was not in any way relevant to property division. Her evidence was insufficient to establish the impact on her capacity to make contributions. Again, I think, and I'm happy to be corrected, that this decision would be decided in the same way under the new provisions. Now, that may well be what's intended, but I just want those of you who are passing this legislation to be aware of that. These new changes are not, and you might be told they are, a free-for-all in terms of family violence and property division. They definitely are not that. Lastly, in relation to contributions, I think the wastage provision, which is currently in the considerations in section 79.5, the new section, should actually be in the contributions section as well. That's how it's currently mainly dealt with in the case law. I can't see why that should be changed. I also think we should be giving examples of wastage. And then I'm just very quickly going to go to the considerations in section 79.5. I welcome in F, paragraph F, the housing needs of children being added. I actually think the best interests of any children, not just their housing needs, should be the first consideration for the court. UK legislation says that courts making property orders give first consideration to the welfare of any children. Australian legislation has no reference to the welfare of children at all in the property division. What are we saying? I also suggest there should have been given, and this might be controversial, to the housing requirements and or financial support of children over 18. Research in the UK shows that a third of divorcees have legally non-dependent children over 18. I might be speaking from personal experience. I have 3 over 18s living at home with me. And yet those needs, or more importantly, those of the parent with whom they live, usually the mother, are irrelevant to property division. And I just wonder whether some consideration should be given to that. So that's my statement, but I'm very happy to answer questions.
Thanks very much. And Professor Fehlberg, did you have any points you wanted to make before we go to questions?
I have an opening statement. I'm happy to offer it. So I thank you for the opportunity to appear. Lisa and I, like Miranda, welcome the bill. We welcome the federal government's commitment to improving the Family Law Act. We really do appreciate the consultative approach taken by the department throughout the exposure draft process in 2023. We appreciate the department's very positive and productive engagement with stakeholders, including the Academy, and also the department's responsiveness to the feedback on the exposure draft. And we think that the current bill has benefited a great deal from that process. And we've focused in our submission on Schedule 1 of the bill, the property reforms, like Miranda. We really make 3 key points. The first relates to the value of careful evidence-based analysis in informing change. And the point here is that fundamental change to the property and maintenance provisions of the Act hasn't been the subject of consideration in Australia for many years. We are concerned that we don't currently have the research evidence base to inform significant change. The ALRC inquiry was very significant, but its consideration of property and maintenance was quite brief. And what we're seeing here is very different to the approach currently being taken in the UK, a 2-year inquiry by the Law Commission into financial remedies on marriage breakdown, because, of course, de facto disputes aren't included in their legislation. So that said, Lisa and I would emphasise that what's very clear, despite our lack of evidence, is that there's consistent research evidence in Australia since the 1980s, and we see this evidence in other Western countries too, including the United Kingdom, that women and children experience particularly significant economic disadvantage after relationship separation. And the ALRC also emphasised this in its report. And so given this, our concern has been all the way through this process that legislative reform should address that disadvantage. And we think Schedule 1 of the bill goes some way to doing that in its attempt to deal better with domestic and family violence, and also the new reference to the housing needs of children under the age of 18. We think that's a very good start, that more could have been done, but this is a very good start. Our second point is that we support the clearer articulation in the bill of the steps and factors in the property decision-making framework We agree with Miranda's point that it would be good to reverse the order of factors to be considered in the proposed new section 79.3 and 90 SM3 so that needs appear before contributions. We think list order is important in signalling priority to be attached and that changing the ordering would signal the importance of addressing post-separation economic disadvantage. Our third point relates to the family violence issue that Miranda discussed. We are in agreement there with her. We're supportive of the federal government's intention to legislate in this area. It is a little concerning that we are loosely legislating in favour of a Kennan and Kennan approach, which has proved problematic in family law. But it's good to see family violence being clearly articulated as a matter that's relevant when we're looking at current and future circumstances, because that has been unclear. So that's a positive. Finally, we appreciate that the moment has probably passed, but we mention in our submission an alternative approach that we formulated back in, I think, 2017, 2018, which if the government was, or at any stage, willing to consider a more ambitious approach to rethinking post-separation property, really does prioritise needs over contributions, which we think would be clearer to the broader separating population than the current legislation. So that was really all I wanted to say. Thank you.
Thank you so much. We'll go to questions from senators now. Senator Scarr, I'll hand you the call first.
Thanks, Chair. Thank you very much to the witnesses. Just by way of introduction, I must say your comments do generate some unease on my part in terms of the reservations that you've stated. Clearly, as I understand what you're saying, you clearly support the direction and support that amendments need to be made and these amendments go in the right direction, but you still have, as I understand it, and I don't want to put words in your mouths, reservations in some material respects. If I could just get perhaps firstly your views for the record that in the absence of any other material reform proposals, you still support the amendments which are proposed in this regard. If I could get your views on that first, please.
Miranda?
Look, it's better than nothing. I'm not sure that's a great endorsement. I think it is, as Melinda says, a good step in the right direction. My fear is that this is a one-off. We haven't looked at an overhaul of property division since 1975, since the Act came in. My fear is that we will do it and that will be it for a very long time. So I kind of think we should get it absolutely right. But given this is the bill in front of us, I'd rather it, I guess it was passed than not, but I think it could be improved. I think it's my position.
Professor Fehlberg?
Thank you. I would rather see that this bill went into law than that it didn't, because I think we are certainly in need of change in this area and this does take us in the right direction.
Okay, thank you. I just want to make sure we got that on the record, and your reservations in relation to the reform process and the point you've made are well noted. In terms of this concept of reversing the order by which matters which have to be considered by the court are dealt with, the concept of putting needs before contributions, from a strictly legal point of view, is that more a question of signalling rather than the legal outcome? Would you get to the same, if the law was applied technically as it should be under the current drafting. Should you get to the same outcome, regardless of whether or not you put the needs before the contributions, or is that a matter of both legal significance and of significance in terms of indicating to the community the priorities?
I see it as the latter. The court has to consider all the factors in a list. The court is not asked to attach particular priority to the first on the list. It just from our experience in this area, that seems to be what has happened. So, for example, before the Family Law Act was amended this year, in the parenting space, in the area of parenting disputes, we had the two primary considerations, which were the need to consider meaningful relationships between parents and children, and then, in essence, safety. And what we saw was that meaningful relationships were being emphasised above safety concerns. And those changes were really underpinned by that concern, and that has now been resolved in the current legislation, which has been great to see. So we have that experience, and we speak from that experience.
So it's this concern, just teasing that out, Professor Fehlberg, it's this concern, I think the term is that's used in one of the submissions, mythologising some sort of significance given to the ordering that isn't the way the law works, but in the other context that occurred, and we received evidence in a previous inquiry dealing with that tranche of reform about that, and how it was something that sort of evolved. That's the primary concern from your perspective, is that correct?
Yes.
Okay.
Yes.
Okay.
No, I don't think under the previous provisions in relation to parenting there was any requirement that the courts consider meaningful relationships up first or prioritise them, but it just seemed to encourage that, the ordering in the legislation. Yeah, it seemed to encourage.
I'm sorry to interrupt. I was going to say, I think the ordering might have more of an impact on couples who are settling their disputes outside of court, who have lower asset pools. So I think contributions become much more important where people have larger asset pools. If you've got a small asset pool, the truth is that needs become the most important factor. Where is one party going to live? Where are the children going to live? Is actually much more important to both the parties, hopefully, than the contributions that have been made. So I actually think the order might become, as you say, a signalling, but I think it's going to be very important for dispute resolution outside court. It's my feeling.
Okay, and just in that regard, Professor Kay, we've received previous submissions, and I don't know if you've had an opportunity to review some of the other submissions received in relation to this inquiry, and particularly from the Community Legal Centre sector, that have called for a more explicit recognition of the threat of homelessness as a particular needs-based consideration that should be explicitly dealt with in the list of considerations. I noted your comments about children over the age of 18, which were well made. I'd still be living at home if I could. But if do you think there's substance in terms of the need to actually include a subclause that more explicitly deals with that issue of the threat of homelessness? And happy for you to take that on notice.
Yeah, I might take that on notice. I mean, I'm well aware that the largest growing sector of homelessness is women over 55 after divorce. So I think, I don't know whether housing needs covers that or not. I would have to think about that more carefully.
Okay, Professor Fehlberg?
Yes, I'd prefer to take that on notice too.
Okay, if you could, that would be useful. Professor Fehlberg, you made mention of an alternative approach that you had advocated for perhaps with others back in 2017, 2018. I'd just like to tease that out a bit for the purposes of the inquiry. How is the approach in this bill different, or to what extent is the approach in this bill different from that alternative approach that was previously advocated for?
Our alternative approach was a four-step approach. So there are many, many more factors that the court considers now, and that the court would have to consider, if the bill was passed. And we looked at research by my colleague Inbar Levy on factor overload, and how having too many factors to consider really isn't very conducive to decision making. It's the laundry list approach to legislation, where you have so many factors that it's difficult for judges and people in the community to make sense of the factors and work out what's most important. So in our approach, we suggested that first should be the reasonable housing requirements of any dependent child of the parties, with a focus on the home where the children would spend most of their time. And our second factor was the material and economic security of each of the parties, once again with a focus on their housing and income and what's reasonable given the available property. Our third consideration would be whether an adjustment should be made in favour of one of the parties as compensation for relationship-generated loss. That would extend to losses that exceed needs of the parties. So at that point, you would have domestic and family violence being compensated, and that compensation would be independent of any consideration of contributions or needs. That would be separate. And then finally, our final factor was equal division of any surplus remaining after consideration of the previous three factors. Of course, we knew in proposing this that it was quite an ambitious model, but we thought it was really directed at addressing economic disadvantage, which we see as a very, very serious issue for many people post-separation, but particularly women with dependent children, and there's lots of research on that to support that point. How is this different to the current bill? Higher priority is attached to children's housing and also to material and economic security of the parties. We're really putting those up the top. We're not starting in our list with contributions, and that's set against our previous discussion that contributions don't have to be considered first, but if you look at any family law decision, you will see that they are. Also, our approach to dealing with relationship-generated loss is different, and family violence is different. In particular, domestic and family violence would be considered as a matter for compensation and not as something considered as part of looking at contributions and future needs loosely. I think they're the key differences.
Professor Kay, do you have anything to add in that regard?
No, I endorsed that proposal actually in my submission. And in the previous government's consultation on property as well, I think they had very few submissions, but pretty much all of them endorsed that approach as well from memory. So I think it's a much bolder step, but it may be too late in the game. But I think it's a better approach.
Professor Kay, you gave us a case study two case studies which were quite powerful, very powerful to be frank, in relation to a woman who's been a victim survivor in a relationship, and because notwithstanding those issues, they've still managed to achieve certain outcomes, and the fact that they've demonstrated that ability or manifested that ability to achieve certain economic outcomes meant that the court wasn't able to adjust a property settlement for the fact that they'd gone through those horrific experiences. And you beg the question as to whether or not it was intended under the bill that should be the position. I certainly interpret the bill, including, I think there's a number of injunctions in certain places that say consideration of family violence is not to be considered in a punitive or in a punitive sense, but has got to be linked to economic consequences. So my interpretation of the bill is it doesn't deal with the issue that you express. I just wanted to tease that out a little. Is that your interpretation of how the amendments would work in practice?
Yeah, I think there are two issues. One is the woman who continues to make contributions, and the other is the one that doesn't have sufficient evidence to link the violence to the impact on her contributions. So the second case, which was really severe violence, she simply didn't have evidence to show how it impacts on her contributions. I read the bill as continuing that link between the exposure to violence and the contributions impact. But, you know, I might be wrong, but I think that has been done on purpose. I know some of the submissions ask for a link to say that the family violence should have an impact on financial contributions. I would very much argue against that, because I think the impact could very well be on her welfare contributions or contributions to the family as well. So, yeah.
So just dealing with those two issues and dealing with the second one first, the question of evidence.
Yes.
How do you address that issue? As soon as you involve a court or a tribunal that needs to make a decision, clearly they need to make the decision, presumably in this context on the basis of balance of probabilities, and they need evidence in order to make a decision. How can you effectively deal with that issue apart from, and I'm sort of thinking as I'm asking the question here, apart from making sure there are appropriate resources to community legal centres and other advocates who can assist victim survivors in terms of preparing and presenting a case, how else can you effectively deal with that issue?
Well, the court can infer that there has been an impact on contributions. They could infer that from the evidence of violence, and sometimes they will do that. But what I think your point about having decent lawyers to actually do these affidavits is a good one. I think you are going to need more. There's going to be more cases coming towards the court, and I think you're going to need more funding under Section 102NA for lawyers to help women to draft decent affidavits, because my research has shown that self-reps cannot do this. And I didn't look whether the, actually I might get back to you, whether the applicant in the case where she couldn't show the evidence was a self-represented litigant. It's possible she was, because certainly my research has shown that those women fail at pretty much every case when they bring a Cannon claim. Right. I'm not sure I've answered your question, but
well, that's I'm dealing with these two limbs. So the second one I was dealing with first in terms of evidence. So I might, if you can take on notice to provide us additional details with respect to those two cases, I'd certainly like to delve a bit more deeply into those two cases. But just on that second limb, dealing with evidence, I might ask Professor Fehlberg, do you have anything to add in that regard?
I would just add that there might be impacts of domestic and family violence that aren't felt in contributions. So somebody's mental health, just the impacts of family violence can be very, very, very substantial. And I think that has been the concern with linking it back to linking domestic and family violence to contributions is that it misses impacts that are relevant and that would be covered by a more, by a compensatory approach.
Right, but it seems just dealing then with that contribution aspect. In a lot of cases, and again, I'm thinking as I'm asking these questions, so because I'm concerned about the issues you raise. Presumably, there'll be many instances where contributions are impacted by family violence, and we've heard evidence to that extent or in that regard. The particular area you're talking about is where if you simply looked at things through an economic or financial lens, you might say, well, the contribution, I can't draw a link between the family violence and a negative impact on contributions, but the family violence was there and has an impact. How do I then take that into account in terms of a property settlement under this regime? That's the question. And as I understand your evidence, there's from your perspective, there's a lack in the scheme that's being proposed in that regard. Is that correct?
Yes. Yes, I think that's absolutely right. I think the court, under the needs sections, can take account of ongoing impacts and future impacts, but in some cases they're not going to be able to look at past impact of violence if it didn't impact on the contributions. I think that's right. I think that continues.
Senator Scarr, do you need to share the call in a moment? If I just give you we've got one more question you can put, and then I'll hand the call over in a moment.
Yeah, thanks, Chair. I might just use that opportunity then just to finally tease out this issue. And perhaps you can take it on notice as to whether or not you think there is a way in which the scheme can be tweaked or adjusted in some way to address the case studies which Professor Kay provided us and otherwise deal with that issue, which is somewhat troubling and which I'll certainly be raising with the Law Council of Australia and the Attorney General's Department. But if you can perhaps just take that on notice and give that some thought.
Sure.
Yeah.
Okay. Thank you. Thank you, Chair.
Thanks very much. Senator Waters, you have the call.
Thank you, Chair. Hi, Professors. Thanks very much for your expertise and your 30 years of work in this space. I'm not a family lawyer, so I know a little bit about this area, but only through the course of inquiries like this and from the benefit of expertise from folks such as yourself. So pardon my ignorance in this question, but I'm staggered. Is it correct that there is actually no compensatory approach at the moment? And that obviously that's one of the factors that you're suggesting in your alternative approach, albeit the third one. It's an important one. Is there no process of compensation in the course of a property settlement for the family and domestic violence that's been committed?
No.
I feel embarrassed that I didn't already know that.
The approach in Canon is to it's complicated. It's a little bit complicated, but there was a case called Canon back in the early 1990s. 97, yeah. And it basically determined that where there was a pattern of family violence that had a significant impact on the contributions of a party, that could be taken into account in giving weight to her contributions. So in a way, she gets rewarded for making her contributions under the shadow of domestic and family violence. So she gets extra consideration for that. So that's the approach that's been taken for many years. Miranda might want to flesh that out a little bit more, but in broad terms, that's the approach, and it's led to real problems for women trying to establish a pattern of conduct. It's led to issues of linking conduct to contributions, as Miranda said, and generally adjustments have been small, in the range of, well, if there is an adjustment at all around 5%.
Yes, thank you. And I've been listening to the points that you've made around this already, and I've read both your submissions where you outline that Kennan approach and the inadequacy of it, and that you believe this bill continues that approach and effectively codifies it without addressing that fundamental concern.
Can I just add it's marginally better. It doesn't require, so Kennan requires kind of exceptional violence. I mean, they were very conscious of floodgates arguments. It requires that, as Belinda said, a pattern of family violence. That's really hard to show. So there are definitely, it's better than the Kennan test, but I just didn't want the committee to be left with the impression that family violence will automatically be included or considered in relation to contributions, because I don't think it will always have an impact.
I agree. Better. It is better.
And again, pardon my ignorance, is there any provision, not necessarily under the Family Law Act, but under any legislation federally, for there to be compensation for a survivor of family domestic violence?
This is so complicated. The Australian Law Reform. No, it's actually this. No, the Australian Law Reform Commission suggested a tort of family violence that would be considered federally. That has never taken off. If I'm honest, I don't completely understand how that would have worked, but that was certainly a compensatory approach. But the previous government and this government have both, I think, quite clearly rejected that approach. So no, I don't think there's any compensation. And I think, in fact, the courts are very clear to say that this is not compensation for violence, because they're so scared of bringing in fault or conduct, they will immediately be appealed if they do that. So I think very clearly it's not compensation.
That's at least at federal level. At state level,
yes.
I think there's another submission that talks about avenues at state level, but then we run into the issue that people have to go to different courts for different things, and that's very, very difficult financially and otherwise, of course.
And that rights would differ depending on what state or territory you live in. Yeah. Okay, well, thank you. I look forward to delving into that a bit more in future work. Can I get your view on the balance that the bill seeks to strike in relation to protected confidences? We've had a bit of evidence about that this morning already. Do you think that the bill is clearly beneficial to add additional elements of harm that need to be considered, but do you think there should be any other approaches taken in relation to protected confidences?
I am so sorry I have not addressed that part of the bill. It's certainly not within my expertise. I don't know.
That's fine. Professor Fehlberg, any comments from you on that?
Oh, I don't have any comments on that. It's beyond my submission. I'm sorry.
No problems. Well, just another issue that has again come up a bit this morning that the bill doesn't address but arguably could and should is the requirement for there to be counselling undertaken by couples who wish to divorce if they've been married for less than 2 years. Now, I can infer the policy reason for that, and frankly, it's ancient rhetoric there. But do you think that rule should remain? And do you have any views on whether that is an inappropriate rule, particularly where there's instances of family, domestic or sexual violence?
I don't have particularly strong views on that. I can't, if I'm honest, off the top of my head, I can't see why we have retained that, but I'll hand over to Belinda.
This is something that I teach in my, family law classes, but I haven't looked at in any detail, and I would say that I would agree that it's a relic of the context in which the Family Law Act was first introduced back in 1975, and a concern that people would be separating and divorcing too quickly, and a concern to be seen to be putting something into the Act that would caution people in short marriages. But I would favour not retaining it. That would be my view. I'm not aware of any utility that it has.
Indeed. Look, I don't have any further questions, but thank you very much both for the detailed evidence you've given so far.
Thank you very much, Senator Waters. I like that term you just used, Professor Fehlberg. I can't see any utility. It's a nice way of putting it, I think. I wanted to ask some questions, particularly about economic disadvantage post-separations. We've concentrated a lot on the particular provisions, but I wondered whether from your research and the work that you undertake, whether you could set out for the committee exactly what sort of economic disadvantage women and children are experiencing post-separations, particularly in separations involving family violence, and how long it sort of takes women to actually recover from that sort of financial separation.
Okay. There's quite a body of research, so I'll be very brief.
Yes, thank you.
I think is helpful is, and I'm happy to follow up with any references if you would like. I'm sure you have plenty of other things to do, but if that would be helpful. So Barbara Broadway and colleagues, in a report from Partnered to Single in 2022, analysing HILDA data, so Household Income and Labour Dynamics Survey, 10,000 people in this survey, a survey done every year for the past, I think we're up to wave 15. The analysis found 32% of single women with at least one child and one previous de facto relationship or marriage lived below the poverty line, 32%. And that was compared to 10% of women with at least one child who were still in an intact relationship. So 32% as opposed to 10%. And then an ACOS study in 2022, most recent data I can find, sole parent families have the highest poverty rates at 35%. Children in sole parent families, there's a 44% chance that they'll be living in poverty, which is more than 3 times that of children in couple families, which is 13%. And this is increasing, this poverty rate of children in sole parent families. Of course, not all sole parent families are families arising from parental separation, but they are a reasonably high number. Then there's research by David DeVoe and colleagues back in 2014, which found that women with dependent children experience a particularly steep decrease in their equivalised household income compared to men who experienced an increase after separation in their equivalised household income, and that the effects of that were being felt 5 years after separation. That was looking at, once again, at HILDA data. That just provides a sense generally across the population and the separated population in relation to domestic and family violence and the impacts of that. We do know there's been analysis of outcomes of Kennan cases that show very low adjustments for family violence, of course, that's referred to in the ALRC report. We do know that women and children leaving violent relationships, women leaving will sacrifice safety for money. So women will leave in order to be safe and then give up any pursuit of a property adjustment, and that's a significant problem as well. There has been research in Victoria by the Women's Legal Service, the Fair Shares research, that supports these points as well. Miranda, probably.
I think you've covered it. I think she's covered it. So, yeah.
Okay. Thank you. And I guess the follow-on question from that is some of these amendments seek to provide a better chance of an economic fairness or a more secure future for women in those situations. How do you see some of these amendments, reducing that disadvantage? What are the key ones that we need to hold on to and keep when it gets to the ballot?
I can too. So I don't think the property division section actually changes very much, apart from the family violence considerations. I think but I think the future needs, including housing needs of children and including violence in those future needs, I think those are the things you need to hang on to and maybe improve. Yeah.
Okay.
Belinda.
Can I also ask both of you, I think, or we've had a discussion with other witnesses as well about the current application of that case, Keenan and Keenan, around property divisions. I'm just seeking to understand, I guess, how that has been impacting contributions at the moment, and what do we need to know sort of in terms of the committee writing its report about how this bill, there is a lot of case law that's being referred to or discussed, and solicitors are giving advice on it, but what's the importance, I guess, of codifying the law in relation to property settlements and particularly around contributions in terms of giving clearer advice to people, even particularly unrepresented litigants?
So do you mean the canon bit or the general property?
Both. Sorry, I guess I'm conscious of time and I was trying to combine two questions in one.
Fine. Yeah. Look, I think anything that goes into the legislation is better than it not being in the legislation for self-represented litigants and for people going through any form of dispute resolution, whether it's just between themselves or with a family dispute resolution practitioner. I think the more guidance, the less that's hidden from those who don't have very expensive lawyers, usually. There's a huge lack of legal aid. I'm sure you've been told for property division in all jurisdictions. You basically can't get legal aid for property division in Australia, only for parenting matters. So that's another, I'm sure that's beyond this, but so I think putting it into the legislation is better than not. I think the improvement in Kenan, for the Kenan, the violence bit, is better than the common law, but it's not perfect. Yeah. Okay.
I would agree. I think in terms of communicating the changes, with the parenting amendments last year, the Attorney General's Department prepared a couple of short documents, one for the community and one for lawyers, and I thought that was very helpful in communicating the impact of those important changes. And if something similar was done this time, that would be a very positive thing as well. I think just to have a one page and if people know, if people can find that easily and know that family violence is now relevant to the way property is divided, that would be important. So I guess I'm talking here about the messaging and the communication of change. Yeah.
Yeah, no, that's a good thing to take into account. I guess the last sort of area I wanted to touch on was the considerations that have been included into property orders. I think, if I'm right, Professor Kay, you touched on the consideration of wastage. You said it was in one area but not the other. Can I take you back to that?
Absolutely. Yeah. No, look, it's a little bit complicated. So at the moment in the common law, in the case law, the courts have the choice of looking at wastage, which would usually be something like gambling, addiction, going off on some ridiculous pyramid scheme maybe, and wasting your assets. At the moment, the court has the choice of dealing with that under contributions as what we shouldn't call, but it's kind of a negative contribution, or they can deal with it under the considerations. And I'm just not sure why that has been changed in the bill. It's only gone into the future considerations. I actually think it should be in exactly the same way as the family violence provision. It should actually be in both the contributions and also as a future needs factor.
And at the point where property is identified, Miranda?
Yes.
As an add back?
Yes. Yeah.
Yeah.
Okay.
Chair, just on that point, if I could.
Yeah, of course.
Thank you. I I think you'll find, Professor Kay, it comes out of a submission that the Law Council of Australia made to the exposure draft. So I'm interested in your view on this, but Law Council of Australia posed some concerns about the introduction of wastage in the factors, and seemed, as an alternative, they proposed that it should be moved from the contribution side to the present and future consideration side. So that's the origin, I think, of it being moved. So interested in your views on that, but also interested in your views in relation to intent around wastage. So it seems to me, when I've been considering this issue, there's a difference between someone who's intentionally wasting the assets with a view to causing harm in the context of a breakup, as opposed to, say, someone during the course of the relationship investing money in an investment that doesn't pay off. Do you see any distinction between the two?
A huge distinction, yes, absolutely. Look, we go into relationships, we generally take the good with the bad, right? I think that's absolutely right. If you're going to take the upsides, you sometimes have to take the downsides. But I think the current test that the court has is intentional or reckless, and I actually don't have a problem with that test. If someone is completely reckless with your assets, I also, maybe that should be taken into account in terms of contributions. And obviously intentional. My first client, when I was practicing family law in the UK, her husband burnt down the family home as an intentional way of getting rid of the assets, and there was no insurance. So, that obviously should be taken into account.
That's obvious. But if someone makes an investment on the share market that doesn't pay off, that's at the other extreme.
And the court already does draw that distinction very clearly.
Thank you. Sorry, Chair. Yep.
No, that's okay. I guess perhaps if I could put it this way, if that's what is recognised in case law around intentional or reckless, is it important that we clarify that in the legislation or in the bill, so that it's clear what wastage means? It's come up in a couple of submissions around a definition of wastage.
Yeah, I don't see any harm in having examples of wastage in the legislation the same way as we have as violence. I think it might stop some of the frivolous claims going ahead that could otherwise occur.
Well, it occurred to me that actually what it might stop is wastage itself, because when people know what the law is, they might be less likely to, I guess in extreme cases of family violence. But if codifying some of this area of the law is also about setting a community standard about what is reasonable, it might also, give some direction to people when they're first going through those initial stages of a breakup, that they can't just go off and, buy a yacht or something. I don't know. Or transfer money to a friend because they really need it or something. Okay, well, that's all the questions that I have. We've got another 5 minutes, Senator Scarr, if you had any burning questions. Otherwise, we'll adjourn for lunch.
Oh, could I? Well, I note the injunction that concluded your comment there about lunch. So
I'm stomachs, maybe.
I'm wary about that. But there was one other area I did want to pursue with indulgence, Chair, and that is some of these definitions that are contained in 4AB2. So these are examples of behaviour that might constitute economic or financial abuse of a family member. And I think these have been touched upon, and some of the words that are used here and whether or not they're appropriate. And I think, Professor Kay, I think you touched on it, and I just wanted to tease it out a little. 2A Roman 1 talks about forcibly controlling, and you've got some concerns as to whether or not forcibly gives the correct nuance to what we're trying to get at here. Is that correct?
No, my concern was really on the next paragraph, the word sabotaging.
Oh, okay.
I think that's very hard. I just prefer the New South Wales example. I think, say you had a couple who both agreed, I don't know, when they were young, the wife would stay at home with the children. They're now older, she wants to return to work, and he says, no, you can't. Now, that could be coercive control, but is it sabotaging? I'm just not sure that that's the right word. It seems to me very strong, and I just think the New South Wales provisions are better. So I'm happy to send those to you. They've been recently drafted, and I think they're quite good.
If you could, you don't have the same concern about the use of forcibly enforcing. You think that adequately encompasses coercion of the type we're talking about?
I mean, you could the truth is you could get rid of the word forcibly, because there is the overall requirement of coercive control in paragraph 1 to be family violence. So I don't have a problem with that going at all. I think they're trying to draw a distinction between many couples' relationships where we control each other's money, but it's done in a benevolent way. I mean, you know, that's what happens. But the fact is that paragraph 1 of section 4AB, or subsection 1, sorry, 4AB, is actually the most important.
Okay. All right. Thank you. Thank you, Chair.
Thanks so much, Senator Scott, and thank you to both of our witnesses and your other contributing author, Professor Fehlberg, for your submissions. The committee is going to adjourn now for our lunch break, and we'll be returning at 1 o'clock Canberra time. Thank you.
Thank you very much.
Thank you very much.
broadcasting? Well, thanks very much. We'll resume our hearing after the lunch break, and I'll go through the opening statement I need to make before our next panel of witnesses, who are all joining us in person today in Canberra. So thank you very much for making the effort. I'm sorry that I can't be with you. Funnily enough, family responsibilities prevent me from doing that today, but thank you for taking the time to speak with the committee. We're now welcoming representatives from Relationships Australia and Family and Relationships Services Australia. Thanks for taking the time to speak with us and for your submissions. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today?
Thank you, Senator. My name is Nick Tebby. I'm the National Executive Officer at Relationships Australia.
Good afternoon, Chair. My name is Dr. Susan Cochrane. I'm the National Policy Manager for Relationships Australia.
Hi, Chair. My name's Robin Clough. I'm Manager of Policy and Research at Family and Relationship Services Australia.
Thank you very much. Would either of you like to make a brief opening statement before we go to questions from senators?
Yes, I think so. Do you want to go first?
Yeah, thank you, Chair. Look, thank you for the opportunity to provide evidence to the committee today. I would like to start by acknowledging the traditional custodians of the land on which I join you today. I pay my respects to the Ngunnawal people, and I acknowledge other people and families that have a traditional connection to the lands of the ACT and region. So Family and Relationship Services Australia represents over 160 members with 135 organisations directly delivering family and relationship services across the country. And these services include family law services, which are funded through the Attorney General's Department. FRSA supports the government's commitment to making the family law system safer and simpler for separating families, and we welcome the second tranche of reform. However, I do note that the proposed amendments raise the potential for unintended consequences, and of greatest concern to us is that amendments may inadvertently afford new opportunities for the perpetration of systems abuse. Schedule 5 of the bill provides for a statutory review of the operation of the amendments after 3 years, and this is an important and welcome addition. However, to help mitigate unintended consequences and ensure that the amendments are well understood and working in practice, we would recommend that some form of real-time monitoring of the court is undertaken when the legislation comes into effect. And we also consider it essential that all professionals across the family law system are sufficiently trained to understand family violence and the nuances of coercive control. As a peak body representing providers of family law services, we're also acutely aware that the court deals with only a minority of cases, and many separating couples work out their property matters through family dispute resolution or with legal advice or simply on their own. And so it will be important that guidance and information materials about the changes are developed and targeted to different audiences across the family law system. And finally, I just note that Schedule 2 of this bill provides for a regulatory framework for children's contact services. FRSA has long supported the establishment of an accreditation system, and we support in the main the proposed amendments as set out in Schedule 2. And I do note that in reaching this conclusion, we talked with the Australian Children's Contact Services Association Board to ensure that they were comfortable with Schedule 2 also. However, I do note a change from our submission. We think that Clause 10 KB1A should include the words "and significant others" to reflect that contact services also facilitate contact between children and other important people in their lives besides family members. So I do welcome questions from the committee on the issues covered in our submission. Thank you.
Thanks, Robin. And if I may share an opening on behalf of Dr. Cochrane and myself for Relationships Australia to echo Robin's comments, thanking the committee for this opportunity and acknowledging that we're meeting today, some of us, on the lands of the Ngunnawal people. We're really, like FRSA, delighted with the efforts that the government has taken to simplify and reform our family law system. Relationships Australia is a federation of community-based, not-for-profit organisations with no religious affiliation, and we've provided family relationship services and family dispute resolution services for over 75 years. Our services are for all members of the community and include a range of services including dispute resolution, counselling, services for children, and services for victims and perpetrators of family violence, services for older people, and many others. We aim to support all people in Australia to live with positive and respectful relationships and believe that people have the capacity to change how they relate to others. In acknowledging the bill and the work that's been done to bring this bill before Parliament, we would like to acknowledge the department and the recommendations or the changes that they have made following recommendations made by Relationships Australia and other entities commenting on the exposure draft which was first circulated. These include clarifying that obligations of disclosure in property and finance matters are continuing obligations, refining the disclosure obligations imposed on litigation guardians, and removing from the CCS accreditation scheme provisions or references to intake processes. We do believe, however, that there remain opportunities to enhance the bill, and these include a standalone provision emphasising that application of the just and equitable principle should never derogate from the paramountcy of children's best interests where there are dependent children. Further clarification of language, including adding economic before effect when talking about the link between violence and its impact on current and future circumstances and past contributions to the relationship, and to preempt concerns about reintroducing fault within the Family Law Act. Acknowledging the range of relationships which courts order CCSs to support, as our colleague Dr. Clough mentioned. Mandating pre-filing FDR and screening in all matters. Explicitly including history of cruelty and abuse to any animal as a factor in determining ownership of a pet, clarifying the scope of any CCS accreditation scheme, and, importantly, pending consultation with service providers, Relationships Australia has recommended omitting the protected confidences provisions. These provisions were not included in the exposure draft, and we're concerned about unintentionally creating or exacerbating risk and an unresourced workload increases to help clients seek directions that evidence not be adduced or disclosed. We would like to say that there are opportunities at this point for complementary reform, including a public education and awareness campaign about the amendments and the broader family relationships and family law system. Improved CPD for lawyers and courts on DFSV and broader workforce planning by government. Amendments of superannuation legislation to allow survivors of domestic and family violence to be awarded an amount from their perpetrators' additional contributions to satisfy any unpaid compensation order. Court resourcing to sustain the use of the less adversarial trial provisions, and increasing the upper limit of eligibility for the PPP 500 designation and regular review of that limit. These were contained in our submission, but we're happy to take any questions from the committee on these or any other matters, and thank you again.
Thank you very much for those opening statements. We're going to go to questions from senators. I think Senator Scarr's in the room with you and ready to ask you some questions. Senator Scarr, you have the call.
Thank you very much, Chair, and thank you for the witnesses for appearing today. Thank you very much for your submissions, and thank you very much for all the outstanding work you all do as individuals, but also through all of your collective organisations. So thank you very much. First, can I ask you to take on notice, could you please have a look at the recommendations made by the Law Council of Australia in its submission? So I'd be very interested in your views with respect to their recommendations. I'd also be interested in your views with respect to the recommendations that were made by Fitzroy Legal Service in its submission 14, Women's Legal Services Australia, submission 27, and National Legal Aid submission 20. And the National Women's Safety Alliance submission 2. So I'm sorry, there's a bit of homework there, but if you could, I just... It's very useful to get alternative views with respect to what different organisations are proposing.
I realise, Senator, that you'll probably mention this at the end of the hearing, but are you able to give us an indication of when you need our views on these?
Yes.
Thank you, Senator.
Once I'm told. 25 October we're looking at. So I'm not looking for War and Peace. So
that's good.
I've read War and Peace, but so to the extent that you can simply say if you agree with something, that's simple. I'm more interested in points of difference if you've got different perspectives on particular issues.
Yes,
in terms of teasing that out, that'd be very, very helpful. If I can go to you first, Dr. Clough, just in relation to the matters which you raised. In terms of children contact services, I note your request or your proposal that significant others should be included. What's the ambit or scope of that? What's the particular lived experience you're trying to convey by adding that particular class of people, and is it clearly identifiable as to who a significant other is?
Look, I think the main point is that it should be around the best interests of children.
Yep.
So if there is someone in their life that is important to them and meaningful to them, then that should be facilitated. I don't know that I can give you... but Susan can certainly give you some particular examples around that. But we do think that's incredibly
I understand
important.
the point in principle, but Dr. Cochrane.
Certainly, Senator. So for many years, the Family Court has been empowered to and does make orders for children to use CCS services to maintain what is termed in the Act to be significant relationships with a range of people. Now, that might be a family member, it might be an extended family member, but it can also include people like teachers or neighbours, where a child has had a significant relationship leading up to the family separation, and it is so significant that the court feels it's in the child's best interests to have the opportunity to maintain those significant relationships. So there is not a definable known class of persons. However, what that constituency is takes its shape from the individual circumstances of the child who is being considered by the court.
Okay, understood. So there needs to be some flexibility to provide for those that constituency, if you like, of relationships. It's not something we can define with any greater particularity, but it should be left to the court to consider the evidence or
We are anxious to ensure that CCSs are able to provide services to support whatever relationships the court has found to be in the child's best interests.
Okay. In relation to this accreditation issue with CCSs, should it be the case that the organisation that employs people who are actually performing the work should be accredited, or should the individuals be accredited, or should both be accredited? And I'm alive to issues of administration, cost. What should the framework look like in your view? Dr. Clough?
Yeah, in our view it should be at the organisational level. And one of the main reasons for that is that, working in a children's contact service is quite a niche sort of field. So in order to attract people into, it's going to be difficult to get a pool of people who come armed with children's contact service sort of accreditation. So particularly in rural and regional areas, we think what's really important is that you've got people with a range of different skills that would be suited to work in a children's contact service with additional training, perhaps, various different modules, depending on the role that they're taking within that service. So for us, it's really a workforce issue, and it's an issue of where I think the risk should lie, and I think that should lie with an organisation. It's an enormous, I think it's an enormous burden on individual workers, and I just don't think that we'll get the workforce we need.
I think from a workforce perspective, Relationships Australia absolutely supports what Dr. Clough has said. It's important and I think more appropriate to impose that regulatory requirement on the entity, which then has its own obligations in terms of employing the right staff and managing those staff through, as Robin has said, professional development and just employment contracts generally. I think there are ways that a accreditation scheme can provide for a safe and high quality service without requiring that to be on every individual to be accredited within the scheme.
And if I may, Senator, by way of example, one of the amendments in the bill would require CCS workers to provide to family members an explanation of the principle of the paramountcy of the best interest of the child. We agree with that, but we also consider that that obligation should be borne by senior and experienced practitioners within an entity. It might not be appropriate, for example, where you've got casual workers on the weekend who are supervising, who are perfectly competent to appropriately supervise contact, but may not be in a position to talk through with family members what the best interest principle requires of them.
So there's a real issue in terms of ensuring that the and I don't want to put words in your mouths, but it seems to me what you're saying is there's a real issue that we need to be careful that we don't swing the regulatory pendulum so far that there's an issue in terms of people being available to provide the service, especially in rural and regional areas. Is that correct?
That is correct. And we have also supported the availability of an individual accreditation for sole practitioners, so that that there will be areas where maybe that is required, and so we propose entity accreditation, but having a solo accreditation also available.
Okay.
And if Dr. Clough? Just add to it. I mean, it is not uncommon to have an accreditation system in which the organisation is accredited, but of course within that you have human resource standards that deal with qualifications and skills of staff, etc. So it's not a, it gets covered. Absolutely, you want your workforce to be skilled and appropriately trained.
Yep. Dr. Clough, you mentioned in your opening statement the concern, and it has been raised by other witnesses who are supportive of the bill and what it's seeking to achieve, but the need for both lawmakers and those in the system to be alive to the fact that perpetrators of family violence may look to take advantage of particular processes provided in the legislation, take advantage of them in a perverse way, which of course is not intended by anyone, but which could still be damaging. There's the education piece, obviously, around making sure those who have a role in terms of implementing the system, the changes, are aware of of issues like the meaning of coercive control. You gave us an example. Are there any particular amendments that you think, and happy for you all to take this on notice, which you think would make a difference in terms of that, a material difference to that risk that perpetrators of family violence may take advantage of the system?
Look, sure. I mean, I guess from our perspective, we see it as what happens around the legislation. So our focus is on, is on training, is on making sure that, for example, that mandatory risk screening is taken within the court system, which it currently isn't. It's voluntary. so those kinds of mechanisms of judges being able to have the confidence to look, if a family violence order is being used as a kind of indicator that family violence has occurred, of judges being able to have the confidence and the skills to look behind that family violence order, to look at other bits of information and assess whether it is really the victim that has that family violence order in place and not the perpetrator. But
just in relation to that point,
Yeah.
sorry to interrupt.
Yeah.
One would hope that it's the situation at the moment that those who are appointed to those positions have a level of expertise and level of practical experience that they could look behind the written material and glean that there might be something further involved that needs careful consideration, and it's incumbent upon them as a judicial officer to do justice in the circumstance of a particular case. So if there are red flags that are raised, you would hope that they would pick up on that and take steps. Is that not happening at the moment, or is it not happening to the extent it should? And is that a question of training or resources?
Look, you would certainly hope that would happen. I think there are two responses. I mean, we do know that there are, so putting aside the kind of the property matter, we do know that there are a number of victims, including children, who are actually put at extreme risk on the basis of court decisions. So I will say that. And I think the second point is that as a society we are all grappling with coercive control at the moment, and what it means and how it looks. So, I think this is a case of everyone. We all need to come along on this journey in terms of training and ongoing professional development. Back to your point about legislative amendments, that is not our area of expertise. Sure. So unfortunately I can't comment on that.
That's okay. Dr. Cochrane?
Yes, I hope I can assist the committee in this regard. I'll take the training and resources issue first. As you may be aware, judges appointed under Chapter 3 of the Constitution have protected independence, and so it is really incumbent on the Attorney-General of the day to ensure that persons appointed to the bench have the requisite training, expertise, and also the commitment to undertake ongoing training and development as required, because neither the Executive Government nor, to a great extent, the Chief Justice of the Family Court, as it takes form under Chapter 3, has the ability to mandate training. However, we now have a situation where the Federal Circuit and Family Court has received some significant funding over recent years to bolster its resources, and many initiatives have been taken by the current Chief Justice to ensure that judicial officers in that jurisdiction are DFV informed, are trauma informed, and that they have the resources available. If I could go back to your question about amendments to harden the bill against unintended consequences arising from perpetrators engaging in systems abuse, there are a few elements of the bill that provide examples of where changes could be made to better harden the bill against that kind of abuse. One would be in relation to the scope of professional services that are specified in the bill as being able to avail themselves of the protected confidence provisions. Those services at the moment are limited. They include, for example, specialist family violence services. We would call for them also to specify gambling help services and alcohol and other drug services as well. It is likely that over time, if there was any doubt about that jurisprudence would emerge to clarify that point. But that would only emerge after families had been put to the time, the expense and the emotional trauma of testing the legislation to demonstrate they could be included. So I think the bill could be very easily amended to provide certainty there. my colleague Mr Tebby mentioned ensuring that the reference to animals and companion animals and pets, we would call for any animal, the abuse of any animal or threatened abuse of any animal to be taken into account in terms of deciding ownership of a particular animal. That cat there might be fine, but the perpetrator might have strangled 5 in the last 2 years, and that should be relevant in determining ownership of that companion. Yep.
Understood.
And finally, I just want one more.
Well, actually,
economic
I think...
effect.
Sorry, go on. Yep. Economic effect.
Yes.
Okay. Last question before the call moves, which it should.
Thanks.
I note, Mr Tebby, there's quite a major recommendation you're making that pending consultation with service providers, omit the protected confidences provisions, Part 5 of Schedule 3 to the bill. These provisions were not included in the exposure draft, and we're concerned about unintentionally creating or exacerbating risk and unresourced workload increases to help clients seek directions that evidence not be adduced or disclosed, end quote. So that is quite a significant recommendation to actually call for those provisions to be removed. I'm wondering if you can explain why, in the view of Relationships Australia, those provisions should be removed at this stage, as opposed to seeking to amend those provisions to deal with some of the concerns that you have.
Yes, certainly, Senator, thank you. Several of our members, when presented with this bill for the first time, have raised a number of concerns with us. And I think those concerns point to the fact that this is something that needs more time to draw out what are the consequences in terms of the level of work that would be required and the resourcing required to comply with those requirements in a way that does minimise risk or doesn't create additional risk. The issue, and we've raised this directly with the department, as you can imagine, is that we can't necessarily put forward a range of amendments to it until the time is taken to fully explore what those risks are and to have a proper opportunity to consult with them. And just given the protracted nature of this consultation, we felt that the safest thing to do would be to hold them back. We understand the attorney has an intention to bring additional amendments to the Family Law Act in coming years, and we think there may be further opportunities down the track once our members and other members of FRSA have had an opportunity to truly tease out what the effect of these amendments would have on them and on our clients.
So I guess the concern is, if you do that, you're delaying the introduction of these amendments. Is that going to do more harm than actually introducing amendments which aren't necessarily perfect?
I feel the issue...
You don't necessarily have to answer that question. I'm just trying to work it out in my own mind.
I think it's too dangerous because we are dealing with a constituency of highly motivated systems perpetrators. In testing out what these provisions mean, they will take every opportunity to use them and the uncertainty around them to perpetuate abuse. If they had been part of the exposure draft, if we had not had such a brief time to consult, we would have had an opportunity to work through with our members how these could be safely and effectively operationalised. We haven't.
Dr Clough, do you have anything on that? Happy for you to take it on notice.
I've got to say I feel very torn about whether, they should be removed or not. But we certainly have concerns about the amendments as they're currently drafted. We actually, absolutely support the intent. But, there does need to be further consultation around definition of professional services, what's in, what's out and what circumstances, and we have not had an opportunity to fully test that with our members. And we're also, I guess, disappointed that the amendments landed on the side of the onus being placed on the confided in terms of, objecting to to that material being subpoenaed. We think the onus should be on the party seeking the material.
Got it.
So,
Yep.
yeah.
Okay, thank you, Chair.
Thanks, Senator Waters, you have the call.
Thanks very much, Chair. Hello there, folks. Appreciate your time and expertise. Can we just stick with that last point? Did you have the opportunity to have a look at the exposure draft where that onus was in fact proposed to be flipped in relation to protected confidences, and where rather than the confider having to defend and oppose the release of material either through subpoena or usage of it in evidence, that actually it was the person seeking to access that protected confidence that had to demonstrate some probity or some relevance that outweighed the harm that could occur. Did you have, what were your views on that, given your reference to the switching of the onus?
Senator, it wasn't that the onus was switched, it was that the protected confidences provisions were not consulted on in the exposure draft.
No, the lady in orange, and I'm sorry, I can't see your name tags, my apologies. You just referred to switching the onus, which is something I feel very strongly about, that was in the exposure draft that was then removed.
Sorry, I think the issue is that in the exposure draft, there was the opportunity to reflect on protected confidences, but the exposure draft didn't actually include amendments. So I think a number of us in our responses to the exposure draft suggested that the onus should be on the party seeking the subpoena. But that was never actually put into, there were no amendments to actually reflect on. So it hasn't actually been switched.
I stand corrected. It was in the initial draft of the exposure draft, but then in the final draft of the exposure draft, it had Schedule 6 had been removed. So thank you. I think we're on the same page.
Yeah.
So is it your view that the onus should be switched?
Yes. It's certainly our view. We think we're not comfortable with the amendments as they currently stand. We think that safety should be the priority consideration here.
Senator Waters.
Thank you. Look.
Oh, sorry, yes, Senator Waters, this is Dr. Cochrane. Our view is that the provisions cast an onus on often self-represented litigants who will have been family violence survivors to take action, and the onus should be squarely placed on the person who is seeking to have that information disclosed or admitted.
Thank you. I completely agree. It makes perfect sense to me, and I cannot fathom why this bill doesn't adopt that approach. The Women's Legal Service have proposed, in the absence of that onus flip, which you and I are in favour of, that there be a list of protections that should be applied. I don't know if you've had a chance to have a look through their suggestions. I'm sure you're very busy people, but they proposed extending the definition of protected confidences to records associated with the protected confidence, clarity around the specialist service that it applies to, that there be a positive obligation on the court to advise the confider that they can in fact object, and that there also be legal advice provided to the confider about what their options were, including a full or a partial consent to release. Are those suggestions something that you could get behind in the absence of flipping the onus?
Senator, look, I did have the opportunity to really quickly skim those, and look, if we end up with the amendments and staying with the onus as it currently lies, then I think absolutely, particularly providing legal advice to the confider, that I think it's an excellent suggestion.
Thank you. And forgive me, Dr. Cochrane, if you went through this, but there was a suggestion actually in the Family Relationship Services Australia sub for a more trauma-informed approach, which I support. Can you give me any further detail of what specific amendments you'd be looking for to have that approach in both property and parenting matters?
Thank you, Senator. That is one of the issues that we would like to tease out more with our members, having the advantage of further time to consult on these provisions and really tease out what's required. Certainly, imposing on the court a positive obligation to advise parties that they can object, that is a good example of a trauma-informed approach. It recognises the particular disadvantages and circumstances of vulnerability of a victim survivor, and it takes concrete action to address, as would, of course, the requirement for legal advice. We would also like to see the professional services aspects more clearly define and delineate which services are able to be included as protected confidants. And I think it was just before you joined the hearing, Senator, we particularly mentioned also gambling help services and alcohol and other drug services as being examples that given that those gambling harms and alcohol and other drug harms do have such strong associations with DFV, we think that those services certainly should be within the ambit of the protected confidences provisions.
Thank you. I did have the benefit of hearing that. I was eating my lunch at the time, so I had my camera off. But yes, thank you. I thought that was an interesting suggestion. Just one last question from me, given the shortage of time. We've had some debate about whether or not the clause that's currently in the Act that says if you would like a divorce but you've not been married yet for 2 years, that you have to undergo mandatory counselling. But do you have a view? Obviously, counselling is something that both your organisations undertake. Do you have a view on whether that should be mandatory or whether that should actually be up to the parties to decide whether that's something they want to do rather than being forced to do by the court before they can get a divorce?
We have some anecdotal feedback on that from some of our members that perhaps that adds an unnecessary extra layer of complexity. And as recently as this week, having conversations with our members about this and the feedback from some providers, direct providers of the counselling services were that there are potentially unintended consequences of that in terms of safety and other aspects, and that there should be an acknowledgement that whether it's 2 years or 2 months, adults in a relationship are able to make those decisions in relation to what they do or don't want as the outcome of that relationship. And so the actual mandating of counselling did seem to be slightly at odds with that, with those provisions. So that's some feedback we've received. I think we didn't address it directly in our submission, but certainly happy to stand by that as feedback directly from our member organisations.
Thank you very much. That provision seems to be friendless, so let's try it again. Thank you very much.
Thanks, Senator Waters. I really appreciate that. I've got some questions, not many, so that's helpful. Some of them have been covered already. I just wanted, if I can go to Family Relationship Services Australia, I had a read of your submission earlier today, and I just note you've sort of noted the inclusion of housing needs of the children in the legislation, and I just thought I might ask you how that would assist your clients when they're negotiating property settlements to focus on the needs of the children. What impact might that have not only in the courts but also when people are going through, I guess, separation conversations before it gets to a court?
Look, we certainly support the inclusion of housing needs. We haven't really talked this through thoroughly with our members or had an opportunity to, but I think it's just another aspect of, housing is obviously, it's critical to family stability, and so being able to have that considered, and for our family dispute resolution practitioners to be able to articulate that as a really important consideration, I think is really good for focusing separating parents on the housing needs of their children in the future.
Thank you, Dr. Clough. Senator, I would add that we are increasingly aware that homelessness and housing precarity is a circumstance in our clients' lives, and that family separation and the costs attended in establishing 2 new households can push families into homelessness and housing precarity. We also are aware that some family groups find it particularly difficult to get emergency accommodation. For example, women fleeing violence with sons who might be over 10 or 11 years of age can find particular challenges in seeking emergency accommodation. That is not perhaps directly falling out of your question, but it is clearly a related and important consideration.
There's a growing body of literature that I'm sure the committee is well aware of, showing the adverse economic distress caused by separation, and particularly on women and their dependent children. And so we feel that any increased focus on future circumstances and including the housing needs is a critical component of centring the best interests of children.
Thanks, and I guess with a similar type of question, the inclusion of family violence as a consideration in property proceedings, how would that be taken into consideration with your clients when they're negotiating a post-separation property settlement, particularly, I guess, for people who have suffered family violence? Will it make it clearer to them what their rights might be?
Senator, this is Dr. Cochrane. Yes, it will make clearer the rights. It will also make clearer the obligations of people who may have chosen to use violence. For example, someone who is perhaps pushing for a 50-50 split, who has been using violence in a way that, for example, might have caused physical harm and absences from employment and education by the person who has experienced violence, a perpetrator of financial abuse who is pushing for a 50-50 split. If it can be demonstrated that the victim survivor was impeded in having access to control of their own financial resources, that can be a factor in doing a reality check with the perpetrator and saying, look, you can call for a 50-50 split, but the reality is the court's going to look at this and is going to look at the outcomes of your physical or your economic abuse, and they're going to make an adjustment upwards to recognise first that the person might not have, the victim survivor might not have the savings, the superannuation and those other resources, but also looking to future circumstances where the person who's suffered family violence and that has led to a disruptive work life may have additional difficulties in securing employment or undertaking other educational or training activities. And I mean, one example of this is the very high incidence of acquired brain injury among victim survivors of domestic and family violence, and the psychosocial and physical consequences of that ABI.
Okay.
Chair, if I might just add, I think, one of the issues, and I think that my colleagues will agree with me, is that I think it'll be really important from a family dispute resolution context that there is greater access to legally assisted family dispute resolution, so that those so that the expectations of presenting parties can be better managed, so that, that they have the information that goes, this is how the court will see it, and leave the family dispute resolution practitioner to do their role of mediating.
Absolutely. Completely agree.
Yep. And the evidence that I've heard in previous inquiries and throughout the work I've done before Parliament was that people, that often the way that the system is set up now is that in a parenting arrangement or discussion, family violence is present, that is being taken into account, but that the perpetrator of the violence would use the property settlement or the property process to sort of perpetuate or lengthen the time of contact and sort of drag it out almost, so it almost becomes another form of violence in and of itself. So it's just the very basic, including these considerations in the property part of the separation. Is that really key to getting the balance right, so that, you know, I guess victims and perpetrators know where they're going to stand once the court sees this information?
We think there's a crucial element here that we certainly hear from our members quite frequently around educating the broader community about the full suite of consequences that arise from the use of violence, whether it be coercive control or other forms of violence within a relationship. And I think as under the National Plan to end violence against women and children, we know that a whole of society approach is required. And I think incorporating these in here, one of the really important messages that sends is the ongoing effort to break down the silos and not to treat domestic and family violence as a separate issue that's dealt with elsewhere. And I think incorporating it here actually does send that message. It brings with it risk that there needs to be greater education about the impact of its inclusion and understanding of what the consequences of that are for both the perpetrator and the victim. But we see it as an incredibly important step towards making sure all different elements where families will be touching support services or legal services or whatever it might be are lined up and are talking the same language.
Yep. We're about to run out of time, so I'm going to squeeze in one more question. And I think Ms. Cochrane, I think you, or Dr. Cochrane, you referred to some small changes that you suggest around the factors that could be taken into account for companion animals, particularly cruelty to other animals, if not specifically that particular one. But again, I guess just to get the premise of that idea on the record, why is it important that pets are considered as part of the property process or considered differently to other types of property? So, you know, they're not like a car, for example. They're treated a little bit differently, and they're going to be if these amendments are successful. And I just thought I would ask, you know, a pretty basic question, but something that people might not understand why we're taking these steps.
Thank you very much for that question, Senator. We think that, I mean, acknowledging that we've been quite harsh in our comments about protective confidence provisions not having been part of the ED, neither were these, but this is we take a very different view of this. We think that the government has appropriately recognised that pets do play a key role as a family member in modern Australian families, that the relationship is often one that transcends the physical but includes the emotional, the psychological, certainly where children are involved. You know, I know I will be criticised for this, but they do become like furry siblings or feathered siblings or scaly siblings. There is an emotional dimension that simply doesn't exist with inanimate objects, and we are very pleased to see them recognised, and we are also pleased to see the nexus between violence towards animals and violence towards other humans as being part of the same kind of controlling behaviour. We think that is a helpful link to continue to draw.
Okay. Well, thank you. Thanks for squeezing that one in for us, everyone. That is all the time we have, unfortunately, with our witnesses on this panel, but thank you very much for your evidence. You have been asked to provide some questions on notice, and we usually give everyone a date at the end, but it sounds like we're all going to agree that's the 25th of October. So we'll get that date to you formally in an email, but thank you very much for your evidence. Our next witnesses are waiting for us online, so I think we are ready to go straight to them. I now welcome via video conference representatives from the Australian Institute of Family Studies. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I just want to remind senators and witnesses that the Senate has resolved that an officer of a Department of Commonwealth or a state shall not be asked to give opinions on matters of policy, shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy or does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you to please state your full name and capacity in which you appear today?
Thank you, Senator. My name is Kira Duggan. I'm the Research Director of Systems and Services at AFES, and I'll hand over to Dr. Carson.
Good afternoon, everybody. My name is Rachel Carson, and I'm the Executive Manager of the Family Law, Family Violence and Elder Abuse team at the Australian Institute of Family Studies.
Thank you very much. Do you have an opening statement you'd like to make before we go to questions?
Thank you, Senator. I'll make a quick opening statement on behalf of AFES. Just to provide the committee with a quick overview, we are a statutory agency. We were established in 1980 under the Family Law Act of 1975. And since our inception, we've conducted research relevant to the factors affecting family stability in Australia, with research on separating and separated families, domestic and family violence, and other matters as relevant to the committee. Our submission to you on the Family Law Amendment Bill 2024, Schedules 1 and 2, draws on a great body of empirical research that AFES has undertaken into these issues over a number of years, with references to other research relevant to the committee's consideration of this bill. The AFES submission builds and makes reference to our submission on the exposure draft, which was February 2023, and you will note our submission supports the aims of Schedules 1 and 2 of the bill and presents research findings regarding the experience and impact of family violence with respect to property settlement, the continuing need for a focus on upskilling lawyers working with clients who've experienced family violence, and also findings from our evaluations that show the benefit of simpler, quicker dispute resolution processes for post-separation property disputes, as well as the need for greater consistency across children's contact services sector that would be best supported by the development of national accreditation framework. So I will now hand over to Dr. Carson. Thank you.
Happy to answer any questions. Thank you, everybody.
Okay. Well, thank you very much. We might start with Senator Scarr, who has questions, I understand.
Yes, thank you. Thank you, Chair, and thank you for the witnesses for appearing today, and thank you for your very helpful submission and your work in this area. It certainly was of great assistance to me in providing context, and it's a very good summary of the research that informs the amendment. So thank you very much. I'd like to ask some questions in relation to the Children's Contact Services. So we've had a bit of a discussion with previous witnesses with respect to how the accreditation system may work, in particular in the context of, say, an organisation that's providing such services, whether or not the accreditation should be at the organisation level as opposed to an individual level. So the organisation should have the obligation to be accredited and therefore have the commensurate obligation to make sure the people working for them, providing the services, are trained and appropriately trained to provide those services. And those comments were provided in the context of concerns that, especially in rural and regional areas, you don't want to set the bar of accreditation so high that it actually results in a lack of services in those areas. So I'm very interested in your comments and views with respect to that conundrum.
It is indeed a conundrum. Drawing on our evaluation, I'd like to state that AFES does support the development of accreditation standards and a regulatory regime. Our findings of our recent evaluation, to which you refer, of the Children's Contact Service activity, which is funded under the Family Relationship Services Program, did indicate that there was a need for greater consistency across the Children's Contact Service sector and for the application of child-focused, child-inclusive measures and family and domestic violence-informed and trauma-informed practice in delivering those services. our evaluation indicated that there was a need for greater consistency in training and professional development of service providers in relation to child safety, child inclusive practice and DFE and trauma-informed practice, as I mentioned, but also in terms of meeting the guiding principles framework. So this need for consistency would be supported by an accreditation regime. Ideally, an accreditation regime that supports consistency across service providers wherever they may fall, including in regional and rural and remote locations, would be important to ensure that families accessing these services achieve consistent service provision when accessing those services.
Do you have any views as to whether or not that accreditation should be at the organisational level or the individual level?
I don't feel that we could specifically answer that conundrum based on our evaluation data. However, the data does show the need for consistency, and that consistency should apply regardless of where people are accessing those services.
Okay. Understood. The Law Council of Australia, and again, feel free if there are areas which you don't wish to provide any further detail, that's fine, but I just want to put some of these propositions to you because I'm interested in your perspective based on your evaluations in particular.
Yes.
I think, speaking from my own perspective, it's clear that the direction of the amendments is in the right direction, and taking into account family violence is incredibly important. A point the Law Council of Australia makes is it will necessarily flow from the amendments where family violence has to be considered or will be required to be considered in relation to a number of additional contexts, that there will be additional legal resources required to assist adjudicators, the court, to make determinations, and that could have direct and indirect consequences in relation to the funding requirements of, say, the community legal sector, etc. Do you have any views or observations based on your research you could share in that regard?
Yes, certainly. In our submission, we indicate that there are some issues in relation to implementation, and your question, I feel, foreshadows some of those. It is likely that with the broadening of the group of cases in which the provisions will apply will increase the number of cases and the likelihood of a greater number of cases accessing the system. In addition to that, the quicker and simpler resolution options detailed in the provisions are also likely to increase that demand on the system. So these are important considerations when determining how the system will manage in the event that the legislation is passed. It's important to note, however, that support provided to both legal and non-legal professionals to facilitate the way in which these provisions are applied will be critical. Very important, and I note similarly in relation to the Children's Contact Services in this context with the application of these proposed principles in relation to the broader application and consideration of domestic and family violence in property matters is the need for lawyers and the court system to be not only prepared for that added caseload, but also the complexity with which the matters that will be coming before them. So upskilling lawyers and other professionals who will be working with clients who have experienced domestic and family violence is very critical to ensure that their access to these provisions is facilitated and that their experience of engaging in the system is one that is safe and effective.
Yep. And my last question, the bill proposes some reforms in relation to the duty of disclosure.
Yes.
I'm interested in your views with respect to those reforms.
Yes, based on our research in relation to the small claim property pilots, which took place both in the mediation context and in a court context through the PPP program in the court and the Legal Aid Commission trial external to the court, the importance of supporting disclosure and timely disclosure at that is critical. And so AIF's position on the basis of our research is that this is an important factor and reason as to why we are supportive of the provisions. The mechanisms that were involved in the implementation of the PPP small claims program in the courts and the Legal Aid Commission trial are likely to be supported by a duty of disclosure, and in the context of a less adversarial trial, that's an important facilitating feature.
And you made the observation in your submission in that regard. Professionals also described the skilled registrars managing PPP matters as supporting earlier and more comprehensive financial disclosure. So we're coming up to Senate estimates where I usually give a wrap to the registrars. Yes. You've just given me a tool for me to congratulate them. They're an important part of this ecosystem, aren't they, in terms of resolving matters as quickly and effectively and efficiently as possible. Is that correct?
Absolutely. Critical aspect of the successful implementation of the PPP program in the courts, and equally outside of the courts in the lawyer-assisted mediation program that was run through the Legal Aid Commissions and is continuing today. It was also critical to have facilitators, mediators who supported disclosure through their engagement with parties, as well as the lawyer-assisted aspect of that program was critical in supporting disclosure as well. So the duty to disclose provisions within the legislation will further support those mechanisms.
Okay, thank you. Thank you, Chair.
Thanks very much, Senator. Senator Waters, do you have questions?
Yeah, just a couple. Thank you, Chair. Hello, both. I promise I won't make any Silent Spring jokes, although that was my first thought when I saw your name. Sorry, I'm sure you've heard it all before.
My very famous namesake, yes.
Yes, my apologies. And forgive me if you've covered some of this ground already with Senator Scarr. Did you have any views on what the accreditation standards for children contact services should include?
Our evaluation of the Children's Contact Service activity was undertaken separate from the moves towards accreditation. However, our engagement in this evaluation did support us to understand the need for that consistency across service providers to ensure that there was greater consistency in the training and professional development in relation to child safety, child inclusive practice, DFV and trauma-informed practice among staff and in the implementation of the program, and also greater consistency in meeting the guiding principles framework. So these are all supported by an accreditation regime, and we're of the view that the sector is at a sufficient level of maturity to support an accreditation regime.
Thank you. Yes, in my opinion, it's long overdue and I very much welcome it. But I think the detail is not going to be with us until the regs are drafted.
Yes.
So, yeah, your early input here about what those regs should include is useful. Thank you. If you have any further comments to make, you can either do that now or by all means chuck some in on notice, because I suspect that those regs are being worked upon probably right now. You've talked a lot about systems abuse, and we've obviously covered this issue quite a bit in the course of today and in previous hearings. And we've heard in particularly that the withholding of child support can be considered both economic and financial abuse. Do you have any suggestions on how this bill could address that issue?
Yes. Systems abuse is a very significant and important dynamic in these matters. And certainly, as we observed in our exposure draft and in our response to the exposure draft and in this response, we do think the provisions proposed in Division 4 are quite critical to supporting and addressing this dynamic in the family law system. So in our previous research, we've discussed and demonstrated from our data the way in which systems abuse can be perpetrated through the court processes, but also through out-of-court processes, and most recently through our Compliance with an Enforcement of Family Law Parenting Orders project, looking at that repeated instigation of litigation, including in contravention matters, but coupled with that, as you mentioned, Senator, the use of administrative processes is quite critical. So in our view, AIF's view, the division potentially supports an improved response to systems abuse because specifying that responsibility that the courts have to actively direct and control and manage the proceedings is quite critical. And we talked a moment ago before with Senator Scarr about the critical role that registrars play in managing proceedings, outlining that obligation that proceedings have to be conducted in a way that safeguards both children and parties who have experienced family violence and to avoid the further experience of family violence, and also providing that significant discretion in the way in which fact-finding takes place in relation to the application of the Evidence Act. So our position is that these provisions would be supportive of measures to address systems abuse. But we do also emphasise, circling back again to that need to support professional development and training for those critical players in the court and outside of the court to support the application of these principles in a way that best acknowledges and identifies systems abuse where it occurs.
Yes, thank you. I fear it's deeply ingrained at this point, so I strongly support your suggestion for training for all involved in the legal system. Do you have any views on the balance that the bill has sought to strike in relation to protect confidences?
As an institute, we haven't undertaken research that is specifically relevant to that, and so we would be happy to consider that on notice, but in our submission we did not provide.
No, that's fine. Thank you. And just the other issue that I'm particularly interested in progressing is the current rule in the Family Law Act that is not proposed to be changed by this bill, but theoretically could be, the rule that in order to seek a divorce, if you've been married for less than 2 years, that you are obliged to undertake mandatory counselling before you can apply to divorce. Does the Institute have any views on the utility of that provision and whether it should be expunged?
Yes, I don't think our research could point specifically to that. It is important, circling back to the issue that we discussed just a moment ago in relation to systems abuse, the critical need for parties to be able to access remedies through the court system where that's required without undue delay is important. And although our research wouldn't speak directly to the provision that you're referring to, the importance of accessing the court system without that delay, that potential for mechanisms to be used as to further perpetrate domestic and family violence is an important one to consider in that context.
Thank you. And just last one from me. I'm sure the Chair has lots of questions too. Given all of the research that you've undertaken over many years in this broader field, is there what should this bill include in terms of other reforms to address inequities or family violence? What would you like to see still done in this area of law?
That's a wonderful to have that opportunity to have that question, and we'd be delighted to have an opportunity to put a more considered position on notice. But critically, it's a long overdue mechanism by which, in the context of family law property proceedings and financial proceedings, we can, by virtue of this amendment, if it's successful, consider domestic and family violence as it impacts on parties' contributions and future needs in family law matters. From an institute's perspective, it's critical that we monitor the implementation of these reforms if they're successfully passed, to ensure that any unintended consequences, whether they be positive or negative, are identified, and then there may be need for further adjustment subsequent to that. But be very happy to take your question more broadly on notice.
Thank you very much. Just whatever thoughts you have to hand that won't spend too much of your precious time. Thanks very much. Thank you, Ed.
Thanks very much. I just have a couple of questions, and we don't have too much time, so I'll do my best to bring them all together. First of all, your submission refers to research findings that engaging a lawyer is not the norm when it comes to separating couples, and fewer than 3 in 10 actually use a lawyer as the main pathway for post-separation property division. I think that's an important distinction to make, because I think when we see these amendments, we think about how the court will apply the law, but what it also does is signal to people before they even get to that point what the likely outcome is, and that gives them an idea of what they can do when it comes to negotiations in post-settlement, hopefully not even get to the court. So in terms of these amendments, do you think it'll make it easier for parents particularly to navigate the property division framework? Will it make it clearer about there's a lot of case law out there, and will it make it clearer and easier for people to navigate that system?
Absolutely. That's certainly a key tenet of our submission in relation to the proposed legislation. Indeed, most families do not resolve their matters in a court context, so that accessibility to the principles as applied in case law is not available for many families. So having those principles clearly set out in the legislative amendments in the Family Law Act would be a very important a step in the direction of accessibility to understanding and signalling, as you say as well, the anticipated means by which matters would be resolved.
Okay. You also mentioned in your submission that women affected by family violence don't always pursue property settlements. I can imagine it's all very difficult and complicated and probably seems easier at the time. And when your main focus is actually just to leave the violence itself, the property settlement part seems, minuscule compared to how important it is to not be in that violent situation. But can you explain what you mean by that? Like, what does your research show about the pathway that victims, survivors of family violence are taking when it comes to property settlements at the moment in the law?
Yes. Our research over a number of projects has indicated that, yes, indeed, pursuing property settlement in the context of experience of domestic and family violence is a challenging feat. Not only is one escaping the circumstances of domestic and family violence and attempting to secure a safe home and setting, particularly where there are children involved, but often in these sorts of circumstances there's a lack of access to an understanding of the financial arrangements for the parties pre-separation, and the idea of engaging in court proceedings to resolve these is a significant burden, particularly where the asset pool is modest. Pursuing legal proceedings to seek a property adjustment can seem quite overwhelming, particularly in the context of the experience of domestic and family violence post-separation. Indeed, also our research has indicated that the experience of domestic and family violence is exacerbated once negotiations or proceedings in relation to property and financial settlement are instigated. So there are a range of complications for family members escaping family violence, and why engaging with legal processes is not identified as the preferred option.
Yeah. Thank you. And I think you touched on this in your answers to other senators, but your research and evidence shows that women who separate after experiencing family violence have a much larger income loss compared to women who have not experienced family violence. How does the bill seek to sort of, take that into consideration, particularly around the way that family violence is used as a specific consideration in property proceedings?
Yes, well, it's two-pronged. It's in relation to taking into account family and domestic violence in terms of assessing the contributions and future needs, but it's also in relation to the application of the less adversarial trial processes as well. So that importance of supporting parties to access a cost-effective, quick and easy mechanism through the court system to gain access to these provisions and have outcomes that accommodate adjustments in relation to those experiences of domestic and family violence, but in doing so, being able to access proceedings in a way that supports their engagement and enables them to take those proceedings where they might not otherwise be in a position to do so if progressing through the standard court processes. So both aspects of the proposed amendments are critical in that regard.
Yeah, okay. And I guess it's about financial security after separation. That's not always a main consideration. As I said before, particularly women, the main consideration is just to be safe and to get into a safe situation. But I guess a few months or maybe even a year after that part of the separation takes place, that's when the property settlements are being dealt with. In that time, in the year that takes, the period of time that takes for the property settlement to be discussed or even negotiated, sometimes the asset pool can change. And I just wanted to know if you had any evidence or views around the considerations around, I think the considerations being included are wastage and liabilities incurred by either parties. And that's considerations that should be taken into consideration in relation to further and future circumstances as well.
Yes.
So that's, yeah.
Yes.
I'll hand over to you.
Yes, the Institute is supportive of those provisions. Our previous research, particularly the evaluations of the Legal Aid Commission trial and the Triple P program in the courts, identified how critical it was to access timely processes to support dispute resolution, and that in turn has that more timely engagement and the provisions to support financial disclosure and to address wastage and dissipation of assets in a timely way is quite critical. Those evaluations indicated that having that access to that simple and more accessible and affordable process and the engagement, the case-managed engagement by the registrars also led to outcomes where parties who would ordinarily be disadvantaged had improved their financial well-being. So both the Triple P program in the courts and the Legal Aid Commission trial established that, but specifically in relation to the Triple P program in the courts, our data did show that in terms of determining just and equitable outcomes, there was a general pattern of more likely acknowledgement of non-financial contributions and a higher division of assets. So accessing that program is critical, and being minded to those prevention and acknowledgement where there has been wastage and dissipation of assets is quite critical in that regard too. I think the fact that these less adversarial trial mechanisms support that more timely engagement, we're encouraged to see that based on the findings in the evaluations.
Okay, well, that's helpful. We haven't asked too many questions about that part of the bill, but that's interesting to make that link. So thank you, but that's all the time we have. I'm sorry. Thank you for your evidence. If you've taken questions on notice, we'll give you a date to return them by. It'll be 25th of October, I assume, but we'll communicate that to you when you get a chance. So thank you very much for your time, for your evidence. The committee is going to suspend briefly for a short break, and we'll be back at 2:30 Canberra time with the Law Council of Australia. Thank you.
We are ready whenever you are.
I can't hear you, Sophie. Hopefully you can all hear me and I can all hear you. Hopefully we get there eventually. I now want to welcome representatives from the Law Council of Australia. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you please to state your full name and the capacity in which you appear today?
Thank you. My name is Di Simpson. I'm the Chair of the Family Law Section Executive of the Law Council of Australia.
Thank you.
And I'm Natalie Cooper. I'm a Senior Policy Lawyer at the Law Council of Australia.
Well, thank you very much for joining us today. Do you have a brief opening statement you'd like to make first, Ms Simpson, and then we'll go to questions?
Thank you. The Law Council of Australia welcomes the opportunity to appear before the committee today. We acknowledge the traditional owners and custodians of the lands where we are providing evidence today, and we pay our respects to elders past and present. We extend that respect to all Aboriginal and Torres Strait Islander peoples who are in attendance. The Law Council supports reform to Australia's family law system to ensure that it meets the safety and best interests of all who are in need of family law assistance, including some of the most vulnerable members of our society. There is no doubt that family violence remains a significant and ongoing issue for the Australian community and our courts. We commend the Australian Government for its efforts in progressing meaningful change to the benefit of Australian families and victim survivors of domestic and family violence. We also recognise that the legal profession itself has an important role to play in addressing family violence and embracing that ongoing challenge. The Law Council supports many elements of the bill and the underlying policy intention of these reforms. We acknowledge that the bill has already passed the House of Representatives without a division or amendment. This demonstrates the strong appetite of the Parliament to progress these reforms as a priority, which is very welcome after multiple inquiries and reviews into the family law system in the past decade. However, we have concerns that without substantial additional resourcing to the family law system and the legal assistance sector in Australia, the measures proposed in the bill will further increase unmet demand. There is a very real risk that this will place such pressure on the existing family law system that the measures in the bill will fail to achieve the government's aims. Therefore, we have recommended in our submission that the bill's passage must be supported by urgent additional resourcing and funding to the family law system and legal assistance sector, consistent with the recommendations in Dr. Warren Mundy's recent National Legal Assistance Partnership Review report. The other recommendations in our submission, informed by our family law section and constituent bodies, are focused on discrete drafting suggestions and opportunities to minimise the risk of unintended consequences arising from various aspects of the bill, particularly Schedules 1 and 4. These recommendations include that there be a further review of the operation of the Section 102NA cross-examination scheme to support the ongoing viability of the Family Violence and Cross-Examination of Parties scheme, that upon the bill's passage, all amendments should apply to every matter heard after a single commencement date, that further consideration be given to the proposed provisions about companion animals, given that these changes will likely exacerbate conflict and extend proceedings, that the drafting of Part 2 of Schedule 1 to the bill relating to the less adversarial trial approach for property or other non-child-related proceedings should be reconsidered with respect to the various issues identified in our submission, that proposed Section 90RI of the Family Law Act be amended to clarify the requirements arising from the codification of the duty of financial disclosure, and that the provisions in Part 1 of Schedule 4 to the bill relating to costs orders should be redrafted. We would be pleased to speak to any of the recommendations in our submission today, in addition to any other matters of interest to the committee. Thank you again for the opportunity to appear, and we look forward to responding to your questions.
Thank you so much. We will go straight to questions because I think we'll have a few for you. So, Senator Scarr, we'll hand the call to you to kick off with.
Thank you, Chair. I just want to ask a preliminary question in relation to, in paragraph 20 of your submission, you made the acknowledgement that the bill passed the House of Representatives without a division or amendment, and you've referred to that again in terms of your opening statement. As I understood it from your opening statement, you're interpreting that simply as a desire of the Parliament to promote the legislation as quickly as possible. I just want to clarify that because, and this might be something for the Law Council of Australia to reflect upon, quite often legislation goes through the House of Reps, but in the expectation there will be a Senate inquiry and there will be an opportunity to more fulsomely consider legislation. I just want to tease out whether or not there are concerns which you listed in paragraph 17 of your submission with respect to some of the fundamental nature of the amendments. From my perspective, I'm still interested to know if you still have those concerns. And from my perspective, I don't think you should interpret the fact the legislation has gone through the House of Reps in the way it did as meaning that this inquiry, certainly speaking for myself, we're not interested and indeed, in my case, have been charged with the responsibility of looking into those issues. So are there any other, and maybe take this on notice as to whether or not there are any fundamental concerns with respect to the approach taken? You made the comment in paragraph 18, nonetheless we submitted many of the concerns we raised were not insurmountable and could be addressed either by revised drafting or through an alternative policy approach. I just want to make sure that the Law Council puts on the record through this forum its particular concerns, even in that regard, not just the drafting concerns.
If I could just perhaps respond maybe in a general way, Senator. The Law Council certainly feels that it has had opportunity to engage and to express concerns, suggestions, questions, and we do recognise that that's an ongoing or has been an ongoing process. We acknowledge in all of our submissions the very constructive engagement that we've had with our colleagues from the Attorney General's Department, some of whom are here. So we certainly understand that this is a dynamic process, and those statements to which you've made reference were not intended to suggest that we thought the process was one, and I'm going to use a phrase, a colloquialism of rubber stamping, but we recognise there are some things in this most recent submission where we have suggested some specific drafting pathways that might resolve some of the tensions.
Right. Well, the simple point I'm making, yes, the opportunity I'm giving you, and take it on notice, if there were some more substantive issues that you raised with the executive in the course of consultation in relation to the exposure draft, which you think we should consider, because this is the first time that the Parliament, the Senate, has had an opportunity to engage in this process. If there are particular issues in terms of the submission on the exposure draft, and you did provide it to us, and I've had a look at it, and it seems that some of those issues were addressed, as you've noted, by the department. But if there are some legacy issues of a more substantive nature that you want to bring to the attention of the inquiry, there is still the opportunity to do that. So perhaps I just leave that with you, Ms Simpson. Does that make sense?
Yes, it does. And I'm confident that the key issues that remain, if I can say, of concern have been expressed in this response. And of course, it's read in conjunction with our earlier detailed submission, and I'm going to suggest that was November 23. Yes, I'm being reminded about the dates, where we unpacked a number of foundational concerns about some of the amendments, the changes that were being contemplated at that time. And we've had substantial engagement with the Attorney General's Department representatives since then, and have been very pleased to see that some of our feedback and the feedback of other stakeholders is being understood and woven into what is now being considered. We recognise, as we've stated in each of our documents, that the purpose of the reform is a really important one, and it is one that we understand and we respect, and we're working constructively as a consequence of an understanding of that importance in terms of trying to find the best way to ensure that victims of family violence and their children are able to address those matters in the property aspects of their family law proceedings.
Okay. All right, understood. First question I want to ask you about is the protected confidence provisions. We've received a very strong recommendation from Relationships Australia that they're very concerned about unintended consequences and dangers flowing from those provisions, and their recommendation is that those provisions should be excluded from the bill. One of the issues discussed in that regard was whether or not there should be an onus on the party seeking the information, seeking the subpoena, or the benefit of the information, as opposed to an onus being on the party whose information it is in the system. Do you have any views with respect to that?
I can say this, that I've been a part of our consideration of the various iterations of that proposed reform over the last couple of years, year and a half. One of our primary concerns was to ensure that the balance was right, because when the court is being asked to make orders in the best interests of children, it's essential that the court has evidence relevant to those considerations before it. And our current system enables parties to issue subpoenas compelling the production of documents that inform those considerations. Now, equally, running parallel to that, we respectfully understand and acknowledge the concerns of those whose protected confidence are the subject of those subpoenas. But the exercise of getting the balance right is an important one, and we would err towards ensuring that the court has material rather than placing additional impediments to the receipt of that material. So previously, we made very clear and strong submissions about an earlier iteration suggesting that it went too far and that the protections were going to stymie the opportunity for the court to have that material, and would create very significant burdens for parties in terms of having additional court processes, so cost burdens and delay. And we flagged again a major resourcing requirement if the courts were going to be grappling with that. Yeah. So this version, this iteration, appears better. It appears more ably getting that balance right, still acknowledging the difficulties for those whose protected confidences are going to be produced, at least at first instance, to the court. I've seen the changes in terms of expanding the group of providers whose notes and materials would be the subject. That seems sensible. But again, the idea that we make it difficult for a court to receive that information is something that we would be concerned about. And making it an obligation on the person who was seeking the information to have a separate and discrete hearing about that, which had been previously contemplated, was something that we opposed. And of course there was the initial tension, Senator, about the material being produced to the court anyway and inspected under the usual subpoena processes. So the idea of not sharing your confidential material was still being missed in that process because it was being reviewed and inspected. So having a system that allows the material to be carefully accessed and subject to orders limiting and protecting it, in my view, is still a better system and one which doesn't place too many additional burdens in place.
Okay. Well, we have received strong submissions from, for example, the National Women's Safety Alliance in relation to their concerns. One of the issues they raised, and perhaps you can take this on notice, is how this regime would dovetail with law at a state level, which applies controls with respect to accessing counselling documents in a criminal law context, say where there's been a sexual assault and the concern's been raised, well, why should you potentially be able to access the documents through a Family Law Act process but you can't access the documents through a criminal law process? There seems to be a disconnect there.
And one of the reasons for that apparent disconnect, Senator, is that best interests of children is a different focus to whether or not someone can be found to have broken a law based on, beyond reasonable doubt evidentiary test.
Understood. Okay, I'll move on. I've got a heap of questions and the other senators have a heap of questions. If there's anything you want to add on any of these questions, feel free to take it on notice. We've received submissions that compensation awards should be for family violence should be excluded from the purview of a property settlement, and the Women's Legal Service in particular referred to the fact that compensation awards under, say, a state regime may prevent the payment of compensation if any part of that compensation might find its way to the perpetrator. Do you have any view with respect to that issue?
I'll make some preliminary comments and then it might be something that benefits from us providing a more detailed response. But you can certainly appreciate the curiosity or the tension that a party to family law proceedings may well have received an amount of compensation because of the terrible conduct of the other party, and to then have that that financial benefit added to a pool, or at least arguably added to the pool for division. And you can understand the curious tension about the person whose poor conduct was the foundation for the compensation payment making a submission about the contribution that they've made to that part of the property pool.
Correct.
So
I'd go even further, Ms Simpson. I'd call it a perverse outcome.
Yes, but those are the sorts of matters that can be dealt with, in my view, in our current discretionary system. Parts of property pools can be excluded from adjustment. Contributions can be recognised as being overwhelmingly in favour of one party. And when you say it's perverse, I expect that's how most of our judicial officers would respond to that kind of submission.
Okay. The Fitzroy Legal Service, and indeed some of the other submitters, made some submissions with respect to the proof of family violence in the context of these provisions. The Law Council of Australia has talked about the increase in resources which would be required to support these amendments, and I think you've made that submission very strongly and very powerfully, to be frank. But the Fitzroy Legal Service was looking for more direction as to the standard at which family violence would have to be proven in terms of the legal processes under the bill. It also suggested, and I'm interested in your feedback in this regard, whether or not there could be any presumptions that are made by the court in the event that there's been orders made by state courts with respect to family violence, which would potentially obviate the need for victims to have to relive the experiences and give evidence again in a different jurisdiction. Do you have any comments in relation to those suggestions? And happy again for you to take it on notice.
Yes. Complex and a number of interlocking threads in that, Senator. One of our observations has been that the less adversarial trial principles, which are well suited to children's proceedings, don't sit as comfortably in non-child related proceedings, and we've made our concerns about that clear. And the intended benefit of making, the hoped-for benefit of making these proceedings perhaps less difficult, that's my language, not necessarily that of the drafters, for victims of family violence, we're concerned won't be achieved. And the rules of evidence have an important role to play in our proceedings, so that matters which are serious ought to be capable of being tested against a standard of proof that takes into account the seriousness of the issues. And that has a benefit for both parties, because if you're then able to particularise and account for those matters at that clear evidentiary standard, then it provides a proper foundation for serious consequences to flow. And that's what we're talking about here, there being serious consequences for conduct of this nature. So, again, it is one of those matters where the intention is a very good one, but whether the expression will achieve the outcome is the concern. And I'm concerned, Senator, I've lost my memory of what the other elements of that question that you made were.
Well, it was really... I don't think... I mean, this is my view in terms of the concern raised by Fitzroy Legal Service. The principles, the standard of proof, which was the other element, this is all balance of probabilities, presumably.
Yes, but it can be up the higher end.
Like the Brigginshaw principle?
Yes.
Right.
So in our rules and the Evidence Act, the more serious the allegation, the higher the test.
So to what extent does the family court jurisdiction or family law jurisdiction at a Commonwealth level, to what extent can it take, say, judicial notice of the fact that an apprehended violence order has been given, or some other process has taken place? It might be a prosecution for assault, and therefore obviate the need for a victim survivor to actually have to give evidence again and be subject to cross-examination.
The existence of those orders is something about which the court must be told. The legislation and the rules make clear that the parties and the lawyers must inform the court of those matters. So it's a foundation to the court's approach to these issues. If I could, I expect, Senator, that the issue here is about the burden to parties to repeating their story. And if they've told the story in one forum, could it somehow be relayed into the second forum?
So that the victim survivor isn't put through the trauma of having to tell the story again in the context of a property settlement under the Family Law Act, where they've gone through, it could even be a criminal case.
It's difficult to offer that kind of shield in any absolute way, particularly because the two proceedings will have different focuses and different issues and different contexts. But the fact of, for example, a conviction for certain conduct in another place will routinely be part of the issues that are placed before the court. Certainly in matters where there are serious allegations of family violence. So it's not like it's not happening at the moment. It is taken into account, but in circumstances where the matters to be considered by the court under the Family Law Act will have a different shape to those being considered elsewhere, then you could appreciate that the focus may also need to be different.
I appreciate that. I was concerned, to be frank, in terms of the submission that the Law Council made in relation to the family violence and cross-examination of parties scheme. It indicated to me a deep concern that there have been unintended consequences flowing from the aspirations of that scheme, and you refer to in paragraph 34 your submission practical and procedural issues. In the ACT, you also refer to a particular case where the trial cannot, the judge was quoted as saying, "In short, I conclude a trial in this matter cannot proceed in a manner fair to the wife if she is precluded from cross-examining the husband." And you, in recommendation 2, you call for a further review of section 102NA of the Family Law Act. Does this bill actually change the operation of that section, or are you basically saying that a review of the other provisions under this bill should include a review of that existing system at the same time as a matter of convenience, if you like?
It's an imperfect system at the moment, Senator, the 102NA scheme. It's important. It's not adequately funded, if I can say that with great respect, and it will be oversubscribed if these amendments are passed, because we will go from having family law being alleged in 84% or 83% of filings in our court to potentially almost 100%. It is in virtually every case that family lawyers deal with, because, of course, this committee would recognise that families who don't have these complex needs are able to resolve their matters, but the people who come to family lawyers will often have a number of more serious pressure points and factors, and family violence, regrettably, is a really significant one of those. So if these changes are made, it is likely that there will be more people standing before the court who don't otherwise have representation, and who, because of the operation of the 102NA scheme, would be precluded from cross-examining their former spouse in those proceedings. They will then turn to the scheme, or the court will make an order permitting them to access the scheme, and so the demand upon the scheme will increase. It's already struggling to meet the requirements of these complex cases, and there are some difficulties in terms of finding practitioners who will be prepared to be on the panel to do the work, and it's very difficult at the moment to properly resource those the orders that are being made.
Yeah, well, I'll explore that with the department when they appear, but that's a point well made. The recommendations, or your discussion with respect to the transitional arrangements, seems to be somewhat conflicted in some to some extent, insofar as you advocate for a single commencement date. You warn that the council warns that we need to be careful about having a long-dated commencement date, because this may inappropriately incentivise perpetrators of family violence to commence proceedings before the commencement date. But then at the same time, you say there does need to be some time taken to allow accreditation, etc., to take place, and education with respect to costs. So what's the happy medium after I get through those competing, what I found to be sort of competing considerations, or is that for us to try and grapple with?
It may be for you to grapple with, but one of the key observations is it's easier for people to adjust to these things if there's a consistency.
Sure.
You're not looking for particular sections to remember when this bit comes into effect versus another, and having sufficient time for education to occur, that's appropriate, and it's not unusual for these sorts of bills to have different commencement dates for different provisions, recognising perhaps seriousness or complexity of some versus others, but our response is to suggest there may be benefit in just choosing a time period after assent and then starting from that.
Have you got your submission there in front of you? I just want to ask quickly, paragraph 60, I think this is
Under the heading of resourcing implications.
Yeah, so it says if the bill is passed, these changes will lead to a reduction in the time to hearing. I suspect that's intended to mean a increase in the time to hearing.
I expect that is indeed, Senator.
Yeah, okay, I just want to get that in the hands up. That's fine. That's how I read it. Companion animals or pets.
Yes.
I note the observation the Law Council's made about the provisions being inserted now. They weren't in the exposure draft, the concerns the Law Council's made. Having said that, there still seems to be support from the Law Council with respect to the legitimacy of amendments dealing with this issue, as it is an important issue, and we've received evidence earlier today. There was and we might be able to get the Hansard record to you, but I'm keen, given the Council made the observation that the number of considerations under the relevant provisions now exceed the number of provisions dealing with best interest factors in respect to children, which I think...
It's perhaps a cheeky reference, but
well,
yes.
Maybe, but it was effective. I'm quoting it. I actually raised that with one of our previous witnesses from Lucy's project, which has a particular keen interest in relation to these matters, and they proposed a way in which that might be, from their perspective, that might be simplified. So if the Law Council could perhaps take on notice, and we'll find some way to get to you, I think, and you can look at the recording, your view with respect to that simplification. And they spoke about some of the issues you raised, including who maintained the animal, is that really relevant, et cetera, and whether or not there could be a simplification of it. So I am interested in that. And you've made some technical observations which I'll provide the Attorney-General's Department an opportunity to respond to. I think I found those very useful. This issue of wastage, so I think the exposure draft I think the bill as it's now presented does reflect one of the suggestions the Law Council made as to where the issue of wastage should be included. It should be in the future and present and future considerations as opposed to contributions. Is that correct?
I don't recall whether or not that's where that distinction being part of it. I'm very conscious in my preparation about other aspects of the current draft, Senator, but if you would like me to address that, I can look more
Well, just in terms of wastage, we're talking about in different... there's been a bit of a debate as to whether or not it should be defined. We should be more particular around the definition of wastage. I just want to explore with you in the first instance what we're talking about here. Is it intentional or recklessly indifferent acts which are taken by a party in the context of the lead up to a separation or after a separation, as opposed to negligent acts, recklessness that occurred during, say, the 20 years of a relationship? What are we talking about here? Because there's been reference to gambling. So is it wastage if someone who's one of the partners 10 years ago lost $50,000 because they had a gambling addiction, but they've subsequently gone to treatment and the relationship continued? Do you go back in time and consider that? Or what are we talking about here in the context of wastage, at least in a common law context? So what are we trying to codify?
Senator, we have suggested in our submission that it's important to ensure the continuing benefit of the jurisprudence around waste. And COALIV and other cases that have dealt with that. And one of our concerns is that it's not quite the way it's being expressed in the bill at the moment. But the examples you've given, Senator, are broadly capable of being considered as waste. But given our discretionary system, I would be confident that if parties were asserting that something had occurred I think your example was perhaps decades ago, the waste of money as a result of a gambling problem, but the person has addressed that and it's not an ongoing one. It's just part of the narrative that might be placed before the court, but it's my suggestion at the moment that would be unlikely in the way that you framed it for that to have an impact. The tension is often in cases where there might be a consequence of an investment choice that's been made that wasn't a course of conduct designed or which had the effect of diminishing the pool, nor was it reckless, wanton or negligent in terms of what the party did. We often talk about the swings and roundabouts of life. You take the good times and the bad times. So we need to distinguish from just making a poor financial decision in the course of a relationship versus someone who has perhaps excluded the other party from knowledge and participation and has engaged in that conduct that would be considered to be reckless. And as a consequence of that, the asset pool has been diminished. So we recognise the benefits and the importance of ensuring the latter is captured, but not wanting to throw the gates open so widely that the court will be bogged down in trying to manage categories of conduct that just don't fall within that
Is there
framework.
a concern under the existing drafting that the concept which the drafters have sought to incorporate into the bill to capture existing jurisprudence, is there a concern that the current drafting moves away from the existing jurisprudence? And if so, and perhaps you take this on notice, but how can that be addressed? Because I think it would be, from my perspective, it would be a shame if we lose the benefit of all that jurisprudence in terms of this codification process.
Senator, I'll just say this wasn't something we raised in our submission to the committee, but it was raised to the department last year, so we can take on notice and elaborate on that.
Well, I go back to my original comment about the fact you'd engaged in the process with the department and et cetera. So I'm still interested if there's, with respect to those issues that were raised last year, right, as well. So this might be one of those that fall in that category where you can provide additional information, because it would seem problematic from my perspective that we're opening up a new front of uncertainty if that's not needed and if there's a way to address that. One last, can I just ask you to take on notice? I'm going to give you some homework, I'm afraid, but...
So please do.
I admire your honesty, Ms Simpson. Ms Cooper, can I give you some homework? And only to the extent that I don't need War and Peace, right? But it always helps me, especially the standing of the Law Council, to get your views with respect to recommendations other parties make. So there were certain recommendations that were made by Women's Legal Services, also the Fitzroy Legal Service. If you could have a look at those recommendations in a short form way, provide any response to those recommendations. In particular, any concerns you have that there are other considerations that need to be incorporated if we were to adopt any of those other recommendations. So it doesn't need to be War and Peace. Just a heads up as to things we need to be concerned about in that regard. That'd be very helpful, Ms Cooper. It'll be due 5 o'clock Monday. No, it won't. It'll be 25 October, I think yeah. Okay. Thank you.
Thanks.
Thank you, Chair.
Thanks, Senator Scarr. I just have a few questions. If I may, and thank you for your really lengthy submission and for your engagement throughout the consultation process, which, as you note in your submission, has been lengthy but genuine. Obviously, the centrepiece of this bill is the inclusion of family violence as a factor for consideration in property matters. And I've read through some of the points that you've made in your submission. Is this issue not necessarily raised at the moment or unlikely to be raised as an issue in property matters currently?
No, it will be and frequently is raised as an issue in financial matters. But at the moment, we're guided by the jurisprudence, particularly since the decision in Kennan and Kennan, in terms of the category of cases where this kind of focus is appropriate. And the tension exists, therefore, about retaining perhaps that limitation, if I can express it in those terms, versus having a much broader and open approach to the consideration of family violence in all financial proceedings.
Okay. I guess to that point, does it mean, because I guess what, if I can clarify in a bit of a layman's term, it's at the moment it's in case law, it's being discussed. This codifies that understanding and makes it clear for people that it is a factor that will be taken into consideration. So how is it, and what do you and your members consider will be the impact of putting into legislation? Will it be argued more in family property matters, do you think?
Yes.
Why is that? If it's already in the law, but this is codifying it, why do you think that that's going to make people raise it as an issue more often?
Because it goes further than codification of the existing case law. And there's a preliminary and probably a positive element too, that if it's in the legislation, people will more readily have regard to it. So we recognise that one of the benefits of moving these issues very squarely into the Family Law Act is that people will be negotiating and working in the shadow of the provisions in the legislation, and that makes it accessible to people who don't necessarily have lawyers advising them and who wouldn't necessarily have access to or understanding of the existing case law. But it goes further than the limitations that had been developed through the case law following Kennan in particular, such that we have expressed our concern that it may result in virtually every party who's seeking financial orders, property settlement orders before the court, including their evidence with respect to family violence. So that's not what happens at the moment. We talk in jargon terms, if you like, by reference to Kennan cases. Is this a Kennan case? Isn't this a Kennan case? And that is then, those of us who understand the shorthand recognise that that would mean a case where serious allegations of family violence are being made, where there's a notion of a course of conduct which has had the consequence of making the other party's contributions more arduous. And so there's a qualifying or a seriousness consideration about those matters, and we don't see those considerations in the proposed amendments. And we recognise that there's a very clear policy intention about that. It's not an oversight, it's not a mistake in drafting, it's a clear intention to make these issues more expansive or to make the legislation more expansive. But we recognise there are likely to be consequences of that. And one of the consequences is, will result, a number of consequences will result, but the product of those considerations is that it's our view that cases will become longer, they will be more hotly contested, if you can imagine such a thing, and the burdens on our courts will increase, the burdens on those who are providing supports in our family law system generally will increase, the burdens on those in the access to justice sector will increase. So there are a number of consequences, unintended or otherwise, which we are concerned may flow.
Perhaps if I'm a little more direct in my questions, one of the terms that you use in your submission is floodgates, and I'm always a little worried about those sorts of terms in relation to matters where family violence might be reported, because obviously we want people to raise these issues if they've occurred. We don't want victim survivors to not mention the family violence. So the whole purpose is for it to be taken into consideration. If there are already Keenan cases where issues have been litigated, and those cases are usually more expensive to conduct, what is the balance of making these issues clearer for people so that they can have more forewarning of how the courts will respond? It's clearer to people approaching the separation or the property separation that these are the rules that will be applied. I guess I'm almost giving you an opportunity to clear that confusion up, because I wouldn't want people to think that you're suggesting that women would start making up claims of family violence. I know that's not what you're suggesting, but the concept of floodgates is a difficult one. It's thrown around sometimes inappropriately, so I just wanted to clear that up with you.
Well, allow me to say this immediately. It is not our submission, nor has it ever been, that we are suggesting that women falsely report or will make up allegations of this nature to secure some sort of perceived financial advantage. And I have been a passionate defender of quite the of that position, that it is not something that we should blithely assume is fabricated. These are very serious issues in our society, and we recognise the challenges being faced by those who have an opportunity to make policy to address these problems. And it is appropriate that in our society, as we grapple with these terrible realities, that we say to women that family violence matters, and family violence will be taken seriously by these courts. Family violence will be taken into account, not just when it comes to the care of your children, but when it comes to addressing the financial outcomes at the conclusion of your relationship. So we recognise the importance of that. We are expressing our concern that the pathway to achieve that, that great intention, may not best be represented in the current bill to this extent. The very people we're trying, or which the bill may be trying to assist, may end up being absolutely burdened by these changes. That's one possibility, because the Kennan-type cases are very difficult cases. They're hard fought, and people will go to great lengths to defend themselves when they're facing these types of allegations. So one of the things we've touched on, and which other stakeholders have touched on, is the tension around people being prepared to reach a settlement in circumstances versus having contested hearings. So when we talk about floodgates, our concern is that the focus that the case law required us to apply before embarking upon these types of cases, so that they would be less common, they would be more exceptional cases, that's gone. Under these amendments, it will be consideration in any case where there are allegations of family violence. And statistically, and terribly, regrettably, that means it is likely to be in most cases. So floodgates isn't to say that people are being untruthful. It's simply to say if it's happening in our society the way we know it is, and if it's happening with the frequency that family lawyers tell us it's happening, it is going to continue to happen, and our court will be faced with family violence considerations in property cases in almost all of them. So the use of the floodgates phrase was not meant to be hyperbole.
No, and Ms Simpson, if I can assist you, I'm not inferring that that was your intention. But what I have seen happen, even in Senate debates sometimes, is that terms like that or things from your submissions might be used in a different way. And I wanted to make sure that you had an opportunity to clarify that that's not what you were inferring in your submission, because I know that that is not what the Law Council considers or believes, especially from the experience of your members. But I have seen it happen, and I just don't want that to happen when we have this debate in the Senate. I don't want there to be any excuses for not taking action on something as important as this. So just to assure you that that wasn't an accusation, it was more of making sure that I had a very clear statement from you about what those impacts will be. And it sounds like to me it's about resourcing for the courts, that you have a concern about making sure that the courts are adequately resourced. Is that right?
Yes, it's resourcing for the courts. It is the reality from our experience and the experience of our members that the cases will be longer. There are going to be more issues that are contested, and a hearing will then require more time from the court. But it's each step before you get to a final hearing, because, of course, a final hearing is just one part. Many cases settle before a final hearing, and many people don't go anywhere near the courts and are managing to resolve things without that pathway. So when we talk about resourcing, and we have been very clear and perhaps repeatedly so about the demands across the sector, and vulnerable people, the people who are going to the legal aid offices, it's the people going to the community legal centres, the women's legal centres, the women's legal services. They're the ones, the frontline family violence response teams. The resourcing consequences of this reform, this important reform, are very substantial.
Thank you. One other issue that's come up with a number of our witnesses, and there's a discussion in your submission about companion animals. I've talked to a few witnesses about this today, and we've had some good suggestions about how to improve or alter those provisions just to make them a bit more workable for the courts. You suggest that courts should be able to make interim orders for companion animals. I was wondering if you could expand on that and the reason why that might be useful.
When parties turn to the court for relief, often it is that they need help on something that is more pressing and immediate, and so that would be expressed as an interim order being sought, versus the orders that are sought on a final basis when the matter reaches conclusion, and that might be 12 months or longer. So the interim issues are the more urgent and acute, and they can change. There might be different moments in the journey when further interim orders are required. So parties might go back to the court more than once for interim relief. So you can imagine in the circumstances following separation or in the postscript of separation that there can be pressing urgent issues that need resolution, and the care of companion animals we expect would be very much in the category of urgent pressing issues. We think about the circumstances in which women will turn to the state courts for protection orders, for family violence orders. It's in those sorts of circumstances that protections or arrangements for their pets are going to be probably most acute. So if this reform doesn't make it possible for the court to make interim orders to give ownership and responsibility of the pet to a person, then that would be a deficiency.
Thank you. And I think just bouncing off from that, I think you've already said this, but the orders that are in the legislation at the moment are pretty prescriptive, what they can order. You've suggested not limiting the orders the court can make to make it a bit easier. Is that sort of, you've already sort of mentioned that, but what types of orders do you think that the court should be able to make?
there's tension between making something open to the application of discretion versus putting some boundaries, some parameters around that. So unfettered discretion, which takes into account the evidence that's placed before the court, will allow creative solutions, for example, and appropriate solutions. Our concern was that the sub-paragraphs suggested some matters to be considered which we were concerned might lead to some unintended consequences. For example, the impact of consideration of who has maintained the pet and who might be able to maintain the pet into the future, and the possibility that that means that a person who's more vulnerable but who has been absolutely responsible for care of the pet is going to then be less able to argue persuasively that they should be responsible for the care of the pet because of that focus. So judges and senior judicial registrars can make pretty sensible decisions about these matters. And if it's on the basis of having a power to make orders about the care of the ownership of the pet on an interim basis, then that balance might be better achieved.
Okay, well, thank you. I appreciate that. That's all the time we have for you. And thank you for your submission again. Can I say it's always very helpful and lengthy, and thanks for your engagement with the process.
Thank you.
If we have any other questions on notice, we will try to get them to you either this afternoon or first thing Monday, so you've got some time to have a look at them. I know it's not it's a very short time frame to turn them around by the 25th of October, but I know you're very busy, so we'll try to do that as quickly as possible.
Thank you.
I won't give you any more.
Thank you very much.
Thank you all.
Thank you.
Perhaps if broadcasting could suspend quickly while we get the next witnesses at the table, and then I'll resume the hearing. Thank you, broadcasting. I now welcome representatives from the Attorney General's Department. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and protection of witness and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of the Department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can you each please state your full name and the capacity in which you appear?
Thank you, Chair. Chris Collett, First Assistant Secretary, Children and Families.
Good afternoon. Rebecca Mills, Acting Assistant Secretary, Family Law Branch.
Thanks very much. Would you like to make a brief opening statement before we go to questions?
No, thank you, Chair. We're here to assist the committee in any way we can.
Thank you so much. I'm sure we have lots of questions, so we'll go straight to you, Senator Scarr.
Thank you. Thanks. And at the outset, thanks very much for the quality of the submission. I actually found the table that you provided extraordinarily useful, and also the track change document to the exposure draft as well. That was very useful. So I'll certainly be making comments, hopefully to inspire others to follow that lead, because it really did assist in terms of a very complicated area where we've got a short period of time.
Thank you, Senator.
First question I've got is in relation to these protected confidence provisions, and I think you would have heard some of the testimony given earlier today, some of the concerns raised around where should the onus be in terms of the provision of documents, the sensitivity in that space, the issue around whether or not there are different considerations under state law in the context of, say, sexual assault cases. So I wanted to give you an opportunity to provide the thinking of the department with respect to how you landed where we landed in terms of the existing draft of the bill.
Yeah, look, thank you, Senator. Ms Mills will take you through the substance of that, but you go to the heart of, I think, one of the key issues here. The notion of protected confidence has been before this committee before. You've made recommendations. Yep. It is a complex issue. It is about balance, and it is about finding the best way forward for the community. Yep. But Ms Mills will take you through our policy position and the evolution of that.
Absolutely. Yep. Thank you, Senator. So this is one we've done extensive consultation on, and it is a difficult one to find the right balance in. So as you would know, there have been a few different opportunities where stakeholders have had the chance to weigh in on this one. Yep. There was the initial exposure draft back in February 2023. There were questions in the consultation paper on the second exposure draft of this initial bill. And then we did some targeted consultation with key stakeholders around a particular draft of the measure. The first iteration of the measure created a leave requirement for the admission of protected confidences information, so it essentially made it a presumption that the information would not be adduced into evidence unless you had the leave of the court. That was removed from the Family Law Amendment Bill, you would recall, before it was introduced, because we had such strong concerns from a number of stakeholders with that original drafting, including that it didn't initially address the harm caused by inspection of subpoenaed material, that it would prevent the court from considering critical information relating to children's safety and best interests by creating that presumption of inadmissibility, and that it could lead to substantial delays in resolving the matters in the best interests of the child, increasing costs for parties and requiring substantial costs for implementation. So the key differences with where we've landed now are that it widens the protection to include documents that are sought to be produced, inspected or copied at that disclosure and subpoena stage, which has been widely supported. It shifts the approach in where the onus for initiating action lies, which, as you've identified, is an area where there have been diverging views. And it simplifies the primary test to be applied by the court when it's deciding whether or not to make a direction from initially where it was a focus on the public interest, now to a focus around the possible harm that could be caused to an individual or a child if that information was disclosed. In terms of the onus, which I think is where you're heading, we really recognise that there's significant stakeholder support for the leave requirement as it originally was from some stakeholders in the family law sector. There's been quite diverging views on this one. As a result of the consultation, we did have really significant, strong feedback against the initial approach where it was presumptively excluding that type of evidence. And those concerns included that really the information that falls within that definition of a protected confidence can be really, really critical in evidence in determining a parenting order. So it supports fundamental findings of fact in underscoring those best interest factors. So really, when you're talking about the safety of children, I guess that was the issue, that it's a different scenario where it's around the best interest of the children.
Understood. Can I maybe ask you to take on notice if you can provide some observations as to the protections or safeguards in the bill as proposed now against potentially perpetrators of family violence using access to those documents to inflict harm.
Using it for systems abuse.
Yeah, systems abuse, and thereby inflict harm on the victims of that violence, and potentially because of that use and potential instances of that use leading to a perverse outcome where people don't actually get the counselling they need. So I'm interested if you can reflect on what are the safeguards, if we pass this bill as it is, what would be the safeguards in the system against that sort of abuse of the system? If you could take that on notice, is that possible?
Yeah, happy to take that on notice.
Second question I had, we've received submissions about the potential quarantining of compensation awards for acts of family violence from the property settlement provisions. And you were here for the discussion I had with the Law Council of Australia that it would seem, from my perspective, perverse that someone who's perpetrated family violence against a partner could take advantage of, could share in the compensation paid to that partner for that family violence which they've perpetrated. What was the consideration of the department around there not being a specific carve-out? Is the intention that it's covered under the just and equitable grounds? Is there any reason why we couldn't have a specific carve-out given the attention on that issue from some major stakeholders?
Thank you, Senator. I would agree with the Law Council's assessment that it could be captured already within the just and equitable framework, so you could consider that, and that the case law really bears out that where that's occurring, it's unlikely that it would be given to the other party or adjusted in that manner. I think that we could give consideration to including it in the future, but really the consideration was that we think that that's covered and that it would be an unusual circumstance where that would arise.
Okay, so that, I mean, the corollary of that is perhaps it could be included because we expected it to be concluded, effectively dealt with in the just and equitable side. Is there any downside in including it?
I think that's
and again, you could take it on notice.
We would need to take the opportunity to consider potential downsides and whether it fetters judicial discretion.
Could you take that on notice? I'm alive to the fettering argument, but it does seem as if it's something which has attracted some substantial attention, and so I would be interested in your further reflections on that. In relation to children contact services, there's been a bit of a discussion during the course of the day as to whether or not the accreditation should be at an organisation level or at a individual employee, sole trader level. Has there been any final assessment made in that regard, or do we wait for the regulations? What's the current position?
I think, Senator, there's obviously consideration. This issue goes back to inquiries over a number of years now. But to the heart of your question, that needs to involve consultation with the sector and the broader space.
Okay, understood. Just a small point on that space. I saw that there are provisions dealing with partnerships, provisions dealing with trusts, in terms of making sure partners are covered, trustees are covered, but there was nothing dealing with the obligation on directors in the event that a body corporate accompanies providing the service that I could see. Could you just take that on notice and see if directors are covered? Because I would have thought there should be...
My expectation is there would be, but we're happy to give you some
I couldn't see
advice.
it, but the light wasn't good in the plane as I was flying down. Fitzroy Legal Service provided some concerns around the burden of proof in relation to acts of family violence and queried whether or not more information or guidance could be provided in the Act in relation to, or in the bill, in relation to what the burden of proof, the standard of proof that was required in relation to an applicant demonstrating to the court that there had been acts of family violence which needed to be taken into account. And they also raised the possibility that presumptions could be raised if there had been orders made by state courts with respect, presumably, to apprehended violence orders or even criminal convictions. Has the department considered those issues in the context of the consultation, and what were the views of the department with respect to suggestions of that type?
Thank you, Senator. Really, it's that's an existing exercise the court goes through where allegations of family violence are made in those property proceedings. The courts do consider the strength of the allegations and then they make findings on the balance of probabilities.
Yep.
So they already are undertaking that fact-seeking exercise and making findings about family violence in the context of parenting and property matters routinely. And they can use any information before them to inform that decision-making, and that can include, and as the Law Council noted, would have to include where there are state and territory family violence and or protection orders or a finding of guilt by a state or territory court. The bill doesn't include that presumption that a family violence order or a protection order of a state should be taken as proof. And that's also recognising that perpetrators can weaponise protection orders. They can allege family violence where it hasn't occurred. So this is ensuring there's the possibility of a party to a family law dispute having the opportunity to put forward contrary evidence disputing the allegations of family violence.
Okay. In relation to the costs issue, some concerns have been raised, especially by the community legal centre sector, that the cost provision in section 114UB3B should apply to clients of all legal assistance providers, including legal aid commissions, community legal centres, etc. What was the intention in relation to that section? Is it intended to capture them?
So the case law has clarified that legal aid in the context we're referring to so it's in relation to the ICL cost protections, the current provisions say a court must not order costs against a party in relation to the ICL when they're in receipt of legal aid. We were intending to add a new element to capture the case law that recipients of funding under the Family Violence and Cross-Examination of Parties scheme do not fall within the legal aid exemption. So essentially sort of saying where they have the capacity, if they're getting support through that cross-examination scheme, to contribute to the costs that they should. And that's because there's no means test associated with that scheme. So we're trying essentially to say where individuals have the capacity to support the costs of an ICL, they should. We were intending it to capture those in receipt of legal aid. The issue that we had in a practical sense, so we understand that case law has clarified legal aid where it's from a legal aid commission is captured, and we consulted on this in the exposure draft. The issue that was raised with us was that many CLCs don't actually have a formal means testing process in place, and that can be really labour intensive. So if we did want to capture them explicitly, that would mean we have to place pressure on them to create that labour intensive means test in practice, whereas National Legal Aid has submitted to us that it's been very rare for a cost order to be made against a CLC client for a contribution towards an ICL cost. And so what we've retained in the legislation is just the existing position in the Act. And that includes that there's a financial hardship exemption. So that ensures that where individuals don't have the capacity to pay, they won't be asked to do so, which we anticipate would cover the majority of clients being supported by a CLC.
So it's not, you don't think it's reasonable just to assume that if someone's getting legal assistance from a community legal centre, that the community legal centre has its own internal processes, given the scarcity of resources that they have, to have undertaken some sort of reasonable process to consider whether or not they should provide services to that individual? You don't think that's a reasonable assumption we could perhaps make, rather than imposing additional burdens on them?
I guess I'd be wary of assumptions, and the indication that we have is that they don't undertake any form of means testing.
Okay.
And so that was the concern that we had.
Okay.
And also, I think we would consider that further were we concerned that the practical implications would be such that these clients are going to attract costs, whereas from what we understand, in practice, that's not likely
just
to be the
doesn't happen.
case.
Okay, all right. Well, that's a
balancing unintended consequences.
Yeah, I understand. Why do we call them companion animals and not pets?
The reason for that was really trying to draw distinctions between the different sorts of animals that might come up for consideration in these kind of proceedings. So drawing that distinction between companion animals and the particular purpose that pets play insofar as providing companionship versus where one might consider working animals or farm animals or wild animals, for example. And it's also consistent with the drafting that we've seen in other jurisdictions, such as British Columbia, which already has legislation that covers companion animals.
Okay. But presumably we could still define them as pets and achieve those outcomes, don't you think? And make it more accessible. I'm more concerned with the accessibility of the law. So if someone's a self-represented litigant, the concept of a companion animal is quite. It's not everyday parlance, if I can put it that way.
Look, and Senator, you've gone to the heart of the challenge with the Family Law Act, in that it's got to speak to Superior Court judges and it's got to speak to citizens in the community, and finding that balance is important.
Okay. There have been a number of submissions made in relation to issues such as the ability of courts to give interim orders with respect to, and I'll call them companion animals, to also the ultimate orders that can be made by the court, the need for some flexibility with respect to the orders, because at the moment, as I read the legislation, the choice is binary between ordering that a companion animal becomes the property of one of the two parties or it being sold. Is that something the department's considering in terms of those submissions?
It is, thank you.
Okay.
Firstly, in terms of the interim orders, I'll just confirm that it's intended that, consistent with the current approach to other types of property, the courts would have the power to make interim orders about the family pet before the final proceedings are finally determined.
Is that a drafting? Is that therefore a drafting issue?
We
fact that we're actually getting.
Whether there might
if the Law Council of Australia
it.
raises the issue,
it
does raise the question as to whether or not the drafting could be made clearer.
Yeah, we'll have a look at that. And then in terms of the options, in terms of the pets, the challenge that we have there is that the courts can only make orders about parties that are joined to proceedings. So the bill. It might be outside of their Commonwealth's legislative power for them to order that a party surrender or place an animal in the care of another person or an organisation that is not joined to proceedings. So that's the challenge in terms of the drafting there. So appreciate, certainly you could look at joining an individual to proceedings. That might be a complex way to go about it. It's also open to the court to make no order about the pet or companion animal, but were an order to be made that the pet cannot go to either party, beyond that, then they could look at what they do practically outside of the courts to give effect to that.
So what happens if the court orders a pet be sold and it can't be sold? You go back to court?
Well, I think if you were looking at rehoming options, I guess.
So you're saying the particular barrier is the concern about placing, giving the court the jurisdiction to make an order which involves a third party, which is not a party to the proceeding. That's right. The particular concern.
Yep. That's right.
Okay.
I think the answer to your specific question, Senator, was if you couldn't implement a court order, you'd have to go back to the court and explain that. In that sort of particular
But then
scenario.
the court's still left with that binary choice. So potentially you just get into a loop.
Yes, although I think in practice these sorts of issues have an emotional aspect where the parties want them resolved.
So I'm just trying to get my head around the practicalities, right? Yeah. So if what would happen, for example, if the court made an order that the pet becomes the property of Party A? Presumably Party A could then immediately surrender the pet to animal refuge, yeah? Would that be right, or would that be contempt of court?
In the context
sure.
of a final order, it would be a final settlement. It would then be the property of Party A, and Party A
they can do whatever they want.
In the same way as if the court awarded a house to Property A to Party A, they're then free to sell it afterwards or do what they wish to do with it.
I don't know if... can I ask you to just take that on notice? Because, again, it's... If self-acting litigants aren't going to appreciate, I would have thought, the intricacies of the court having to join third parties before an order's made, joining third parties. And given all the submissions we've received from organisations with quite a bit of expertise in this area, one wonders whether or not your self-representing litigant reading the provision will be left bemused as to what to do in practice.
And just so I'm clear, question, Senator, the intent behind your question is how do you ensure clarity for that self-represented litigant? How do you make this as straightforward as possible?
Correct, because because they'll look at the provision the same way. Potentially, I looked at it, which was it's even with the benefit of being a lawyer,
Yep. And an issue that other jurisdictions are grappled with when you bring pets into this sort of space.
Yep. Okay. Is there a number of submissions in this space called for the simplification of the considerations and made the observation, which you've heard, that the number of considerations with respect to best interest factors in relation to child custody are less in number than the number in relation to pets, and whether or not there can be some sort of rationalisation of the number of considerations. So can I ask you to take on notice, I won't ask for your views now, but take on notice the suggestions from Lucy's project, I think it was called, potentially with respect to rationalisation of the interests or considerations that need to be made, and in particular concerns were raised with respect to the relevance of who's in the past paid for the maintenance of the pet and how that may lead to unintended consequences if that's considered. So I'll ask you to take that on notice. The provisions with respect to wastage, are they simply meant to reflect the jurisprudence, the existing jurisprudence, and to codify that?
That's correct.
Okay. Understood. Thank you. We received some... Did you hear the evidence we had from the professors?
Yes.
You did. So one of the points they raised was the order of matters in the bill, and they put forward the proposition that needs, if I can put it that way, should be considered prior to contributions in terms of the order. I asked a number of questions to ascertain, is that a legal issue or is it a preference with respect to signalling to the community what the communications issue. Does the department have any, well, let me ask you, are you intended to get to the same outcome regardless of whether or not you put needs before contributions in terms of the order? Is the order of contributions and needs, is that intended to have any legal significance?
The order within them is really intended to codify and follows the flow of how it is applied in the majority of cases at the moment, and so that really is the logical flow that we see in the case law, and so that seemed the most logical way to include it in the legislation. And I do appreciate the rationale around why there's a push for considering future needs of that step by that audience. I think that's probably more something for education around the Act rather than for inclusion or of changing the order of the steps. It's also open to the courts, consistent with current practice, for them to approach those steps in any order, but this does codify the order that we understand is generally used in the majority of cases.
Okay, I've just got two further questions. The the concern's been raised by Law Council of Australia with respect to resourcing and the fact that these provisions are being introduced, whilst they're supported from a principle perspective, the practical consequence will be that these issues around family violence, from the Law Council's perspective, are more likely to be the subject of legal proceedings, and that may lead to costs and delays in terms of proceedings and the need to ensure that applicants are appropriately represented. What's the department's view with respect to that concern? And just for the purposes of Hansard record, I'll just read their recommendation 1. Law Council of Australia says, quote, "The bill's passage must be supported by urgent additional resourcing and funding to the family law system and legal assistance sector, consistent with the recommendations of Dr Warren Mundy's NLAP review report," end quote. How does the department respond to that concern, which is emphasised throughout the Law Council of Australia's submission?
Thank you, Senator, and you'd be aware of Dr Mundy's report. I imagine you'd also be aware of the announcements from government that have come out in the context of the National Cabinet discussions around the next iteration of the National Legal Assistance Partnership, which will become the National Access to Justice Partnership. That's been announced at a strategic level, if you will, by First Ministers, and the Attorney-General and his state and territory counterparts are working through the substantive detail of that now, of course, supported by their departments, including my colleagues in the Attorney-General's department, with a view to working through that agreement in the coming month or so. There's a lot of information to be worked through, but you would have seen in the public domain the additional funding that the government has made to legal assistance, which of course goes to these issues.
You do recognise, though, that the Law Council of Australia does refer to additional funding in paragraph 24 of their submission, which I think is a reference to the additional funding you're referring to. But then they do say, paragraph 28, "We have concerns that without substantial additional resourcing, the measures proposed in this bill will further increase unmet demand and will place such pressure on the existing family law ecosystem that they will fail to achieve the government's aims," end quote. How do you respond to that?
Yeah. Look, what I would say, Senator, is funding in legal assistance is an ongoing and significant issue for government. Funding decisions are a matter for government. There are significant announcements that have been recently made and that are being worked through. Subject to the Parliament proceeding with this bill, it'll be important that government and that the department continues to monitor the impact of the legislation as it comes into force. There will be a statutory review, of course, inherent in the legislation. And there has been, in the broader context of family law reform, significant reform in the last sort of 2 years. There are a number of statutory reviews that Parliament has already required of the Act. There will be multiple points where not only can we, not only should we must be reviewing the ongoing implications of these sorts of significant reforms.
Okay, and just on that issue of review, one area of concern that the Law Council of Australia raises is the operation of the Family Violence and Cross-Examination of Parties scheme, and recommendation 2 of their submission referred to the need to have a further review of the operation of Section 102NA of the Family Law Act. Does the department have any views with respect to the need to review how that scheme's working at the moment?
I'd say we do, and we need to continue to monitor that scheme. That scheme is not a static body of work that simply can be set and left. It's used across the country. There are differing demands in different jurisdictions for a whole range of reasons. We have continued to mature the oversight and monitoring practices for that scheme in the years it's been in existence. It's supported nearly 5,000 cases now since its inception. So there's a growing body of understanding, not just for us at the government level, but with the LACs. And we've put in place a scheme coordinator now that sits within the South Australian Legal Aid Commission to provide an ongoing holistic view and an ongoing reporting mechanism to us, so that there is I'd almost say like an ongoing review mechanism. That's not to say it shouldn't be considered as part of broader statutory reviews. I'm not that would be a logical thing to do. But we have to continue to monitor that scheme. It's not something we can set and forget.
Okay, so just maybe if I can ask you to take on notice, and I'll just ask you to take a few things on notice now, so the chair can chair the call. Firstly, in relation to that proposal, that recommendation, whether or not the department has any concerns with respect to adding a review of the operation of that section to the review that's in the bill as it stands at the moment.
Yep.
Whether or not there are any issues with that, given the current given the current process is underway, and in answering that question, you might provide some detail with respect to what's happening at the moment, as you outlined.
Yeah, certainly.
So I'd appreciate that. If I can also, I'm not going to go through the technical drafting recommendations the Law Council's made. They made reasonable sense to me, but I'd like to give you an opportunity, the department, opportunity to respond to recommendations 3 and 4 of the Law Council submission, and also recommendations 6 to 10 of the Law Council of Australia's submission and their particular drafting suggestions. And also, if I could ask you to, if there's any other particular comment you'd like to make in relation to some of the recommendations made by the Women's Legal Service in relation to in their submission. I think we've covered off on the Fitzroy Legal Service issue
in the early discussion
previously in terms of this interaction, but keen to understand the department's perspective on the recommendations made by the Women's Legal Service to the extent they haven't been covered in terms of this interaction. So if they have been covered, feel free to refer to testimony you've given. I don't want to place too onerous a demand on you, but it would be helpful from my perspective
Senator Sky, I need to share the call.
Can I, Chair?
I need to share the...
Just want to clarify
quickly.
those quantums. I'll be very... Obviously, there's not time to answer any of those questions now.
Well, no, there isn't.
And the deadline for us to respond, Senator?
The 25th of October. And if there's further questions on notice, Senator Sky or other senators can put them in writing to you after the hearing as well.
Fantastic. And Chair, we'll do the best we can in the time available.
Thank you.
Great. Senator Waters, you have the call.
Thank you very much, Chair, and hello to you both departmental officials. I really appreciate the expertise that you've clearly got in this field.
Thank you, Senator.
And thank you also for the briefings that I've had the benefit of from you previously. Again, it's really helped with my understanding. Just in relation to protected confidences, we've heard from stakeholders that the definition could be broader to capture documents like medical certificates or correspondence or other documents that are essentially associated with the protected confidence itself. Can I ask whether that broader definition was ever under consideration or whether it could now be under consideration?
Thank you, Senator. Sorry, I'm just finding my place. Can you indulge me a second? Here we are. In terms of the definition of the protected confidences adopted, we've adopted the provision that's similar to the definitions used to protect professional confidential relationships in a number of the State and Territory Evidence Acts, as you know. And it functions to protect communications between a confider and a confidant who is acting in a professional capacity to provide a professional service to a confider. So that communication has to be made in circumstances where there's an obligation of confidentiality to meet the criteria of a protected confidence. I did want to flag that the court's direction-making power is not limited to documents or evidence recording a protected confidence itself. So a court may also make directions in relation to evidence relating to a protected confidence. So that ensures that other documents that are necessarily generated in the course of a person's care and treatment can also be protected under those provisions. And that is discussed in the explanatory memorandum if you have a look at paragraph 581. So inclusion of the phrase relating to makes it clear that it's not necessary for a document to directly record a communication between the confidant and the protected confider for a direction to be made. So records containing observations and opinions of the confident or summary information could also be subject to a direction.
Okay, thank you. I hope that will satisfy the concerns of Women's Legal Service. This was one of the 4 things that they raised in relation to protected confidences. It sounds positive to me. You've referred to that issue being similar to how the states and territories approach it. On another matter, the Queensland Evidence Act currently says that the court should review a protected confidence prior to the applicant who's seeking to access the protected confidence, if you're following my drift. I'm wondering, given that you've seen fit to have the wisdom of some states and territories' approaches on other matters, have you or would you consider adopting a Queensland Evidence Act, I think it's section 14H, that says that the court essentially can vet protected confidence prior to an alleged perpetrator getting their hands on what could be quite damaging material?
I might have to take that one on notice, Senator. I think there's mechanisms wherein for the subpoenaed material to be considered by the courts, but I would want to take on notice that particular question just to make sure I come back to you accurately.
Yeah, thank you. I appreciate that. What are the mechanisms at the moment? How is the court?
In terms of the registrars within the courts may be able to inspect the material, but I would just want to clarify what their powers were in terms of that.
Yeah, thank you, because obviously we want to achieve all things and make sure that the evidence that's useful to the court can be both subpoenaed and then secondarily adduced, but we also want to make sure that that the sanctity of the relationship is protected and people aren't discouraged from seeking treatment. So yes, I look forward to your response on that. Just going back to the issue about the onus, which we have covered quite a bit previously and also today, and obviously the original Schedule 6 and the exposure draft that had flipped the onus for subpoenas was then dropped from the exposure draft, and it also doesn't appear in the current bill. Why do you think that the onus should be on the person who seeks to protect their confidence to object to those important documents being released, rather than the person who's trying to get at them having to show why?
I think it is a very difficult balancing act, and there is not a perfect scenario to ensure that there might not be distress caused to an individual in cases where this information might be relevant and where you have to consider the best interests of the child. I think it's a unique jurisdiction in the fact that it has the best interests of the child as a matter that has to be considered, and that while that information, it may be very distressing to a person to be revealed, it could be relevant. So we do need to have the mechanism to consider whether it can. At the moment, it's really the strength of the feedback we got around the amount of proceedings in which it's likely to be relevant. There, as I think we've discussed before, there's 61,500 subpoenas in the Federal Circuit and Family Court of Australia issued last year. The court indicates that a significant number of those matters alleged that a child had experienced family violence, or that there are allegations of family violence, or that those materials might relate to the kind of records that we're talking about. So I think the fact that they may be included in so many of those matters indicates to me that putting in a presumption that it can't be included is not the practical step to ensure that those matters will always be considered in the best interest of the child in each matter.
Yeah, thank you. That's not the presumption I'm suggesting. It's merely that at the moment the presumption seems to be one of provision of that material, and I'm concerned that there doesn't appear to be any vetting whereby a registrar or a judicial officer or a judge, someone associated with the court, gets to look at it first and judges whether it is in fact relevant and has probative value. That's my concern, that there be some kind of protection for the confidence, and that could itself give effect to the best interest of the child. So I don't think there is such a process, and if you can clarify for me, that'd be great. And if not, why not?
I guess what it adds is an additional safeguard to the existing mechanisms to object to a subpoena, which we know don't capture some of these tricky situations. We know that they can cover things where there's material that's not relevant or subject to professional privilege. But in these instances where the harm might outweigh the probative value, that's a difficult thing to determine. So this adds that safeguard in that it's the individual who receives it who would have to object to the subpoena. In the instance where they do object to it, and we will need to make changes to the court rules and forms to ensure that it's really clear that they have those grounds to object, but where they do object to it, then it would be the option for the court to examine that material to make an order determining the probative value of that, weighing it up against the harm that it would cause the individual potentially, and ultimately with the best interests of the child as a paramount consideration.
Okay, thank you. That's clear. The concern, of course, is that the applicant, or rather the person who's seeking to protect their confidence by objecting, might not have legal advice, might not know that they have the right to object. And I acknowledge you've said you'll make that nice and clear in your documents, but I still think there's quite a barrier towards understanding legal jargon and the process for unrepresented litigants. Has the government considered any funding for community legal centres or legal aid or some body of lawyers who could give advice to people in that situation about objecting and the fact that it could be full or partial consent? Because I'm just concerned that people won't know what their rights are and therefore won't use them.
The sort of government considerations of legal assistance funding is at a broader level than that, Senator. I'd have to take the specifics on notice, but I don't believe that level of specificity would be involved through a legal assistance partnership type discussion that would sit with states and territories and legal aid commissions. When it comes to education and awareness raising on the bill, there'll be a whole range of activities that we will undertake, subject to the Parliament passing the bill, as we did with the first tranche of reforms last year. And that, with the benefit of last year's experience, we have a really tried and tested arrangement of being able to move information through and across the sector and out into the community. And when I appeared before you this time last year talking about the 2023 bill, we were confident in that process. On the other side of that, I've been really pleased with how much the sector responded to the efforts of the department and of the court in promulgating that sort of information. And so we have tried and tested arrangements for pushing information out to the community.
Thank you. Well, I believe in Queensland they did in fact tailor specific funding to address issues like this in sexual violence context, so it can be done. I still believe it should be done.
And it may well be, Senator. I'll take that.
Your pay grade, so I'll take that up with the Minister.
Senator, if I could just clarify that, it's not that it's necessarily about, well, of course, it's the responsibility of the Attorney General around the final partnership. My point was where that level of decision-making sits, what the Commonwealth prescribes versus where the states manage it. That technicality doesn't sit within my responsibility, so I'm happy to take that on notice.
No, that's fine. I think it's a matter for the Minister to specify that he in fact wants the money to go in that particular direction. Sure. And if he did that, then it would go in that direction. So I think we're clear about the process. Thanks for that. Just in relation to section 44(1)(b) of the Act, which requires couples before they divorce to have mandatory counselling if they've been married for less than 2 years, there may well be religious underpinnings to that which might have been relevant 4 million years ago, but they're in my view no longer relevant. And I think given the extent of family and domestic and sexual violence that comes before the court, it seems like an entirely inappropriate section to retain. Is the department doing any work or to advise government or any work on actually removing this provision from our law books?
That's not something that we've consulted on as part of this bill, but certainly open to that being something we consider and open to the committee's recommendations in that regard.
Okay, have you done any work on it outside of the parameters of this bill?
No, we haven't.
Okay. Well, hopefully you will be tasked with doing so at some point fairly soon. And just a last question from me, and Senator Scarr touched on some of this, but Lucy's Project, the organisation that was doing some great work in relation to keeping pets safe in families where violence has been the cause of separation. Their suggestion was, in essence, simply change the word sell to rehome. And Senator Scarr put some lengthy questions to you, and I confess I got a bit lost in what the response was. Is there, can we change the word sell to rehome?
I think we can have a look at that option. It's not something I'd be able to comment on today. I am conscious that the challenge that we had that I raised with Senator Scarr is around the court's ability to make orders to send pets anywhere that it's not a party that's joined to proceedings. So their powers are...
But if you didn't specify where the rehoming was, surely you don't fall foul of that concern.
We can have a look at that, Senator.
Yeah, thank you, because otherwise you'd fall foul of the same issue by using the word sell. And the court's not saying where you've got to sell the animal to, and likewise it wouldn't be saying where you've got to rehome the animal to. So hopefully that problem, in fact, wouldn't arise. Anyway, thanks for taking that on board. I think that's it for me. Thank you very much, Chair. And thanks
very much. Thank you, Senator Waters. I just have some quick questions. Before I dive into the legislation itself and the amendments, your submission and also the briefing we got from the Secretariat sort of sets out where this legislation has come from. There's been a number of inquiries over many years that have made recommendations that have ended up in this legislation. But what are the key inquiries that you have used to, well, what are the inquiries that are that have made recommendations that this legislation is implementing?
Thank you, Senator. The bill, as you said, responds to a number of reviews and inquiries that have highlighted a number of significant ongoing challenges in the family law system, and they include the Australian Law Reform Commission's 2019 report, Family Law for the Future, an inquiry into the family law system. Also, the 2021 Australian Parliamentary Joint Select Committee on Australia's family law system. The 2017 House of Representatives Standing Committee on Social Policy and Legal Affairs inquiry, the Better Family Law System to Support and Protect Those Affected by Family Violence, which is also known as the Henderson Inquiry, as well as Chapter 4 of the 2019 Senate Legal and Constitutional Affairs References Committee report, The Practice of Dowry and the Incidence of Dowry Abuse in Australia.
And if you don't have it on notice, if you don't have it with you perhaps on notice, what particular recommendations from which inquiries are being implemented? It would be good to sort of draw the link for us.
I think there's a table in our submission that that covers those, Senator.
Great, thank you very much for that. Can I ask, in terms of consultation, there was a draft exposure bill and then an exposure bill, is that right? Can you take us through the consultation for this particular piece of legislation?
Thank you. Yes, Senator. So starting back in 2023, in August to September 2023, we conducted pre-briefs with a number of key stakeholders before releasing in September a public consultation on an exposure draft of an initial bill. And during that time, we delivered a public information webinar and conducted significant range of consultation meetings with stakeholders. From September to 2023 to July 2024, we undertook those consultations. So we received 86 submissions on the exposure draft. That public webinar we ran, we had 930 views, either live or via recording. And we met with approximately 42 stakeholders during and after that public consultation period. That also included a significant amount of engagement on the protected confidences measure. So that one had started actually back in February 2023 with the exposure draft of the first Family Law Amendment Bill 2023. And then we also did some targeted consultation on an exposure draft of particular provisions on protected confidences from 8 to 19 July 2024, all leading up to the bill being introduced in the Parliament on the 22nd of August 2024.
Thank you. And on protected confidences, so you said there was a targeted consultation around that provision, those provisions. It's come up a lot today, and obviously us been answering questions about it. That's developed over a number of exposure drafts and consultation periods. But the final provisions you had a targeted consultation around. Is that correct?
That's correct. We had some targeted consultations with particular stakeholders who'd given significant feedback over the course of that longer consultation period.
And you went to this in your answers with Senator Waters and Senator Scarr, but just for the committee's purposes, can you explain why the current provisions have a balance or need to have a correct balance between the protect from harm that could be caused, but also ensuring that crucial evidence is put before the court? Because I think that's obviously the balance that those provisions is seeking to find. I'm trying to understand where that balance lies and why that's an important balance to get right.
Thank you, Senator. Recognising that family law is a unique jurisdiction in terms of where we need to consider the best interests of the children. So it's recognising that the information that falls within protected confidences can often be really, really critical evidence in those parenting determinations. And so the balance really is looking at the potential harm to the individual who the record's about of adducing that evidence, weighing that against the probative value of including that within proceedings, and then considering the overarching paramount point is the best interest of any children involved in weighing up whether or not any potential harm is warranted in terms of the best interests of a child and the probative value.
Okay, thank you. One other issue that's come up, probably not as much today, but is of interest, is the provisions that allow a less adversarial trial process, but the provisions allow the court to retain discretion in that matter. Can you explain to the committee what's meant by discretion of the court for less adversarial trials and why that's important that we retain that discretion?
Thank you, Senator. So the Family Law Act currently provides for that less adversarial approach to be taken for proceedings about children's matters, and that really recognises that negative impact that an adversarial process can have on parties involved, but especially for children. What the bill does is expand it to other types of family law proceedings, so that's including where there are only disputes about property and finances, and so that's requiring the consent of the parties, or it can be at the discretion of the court, and that discretion is proposed because it might be challenging to obtain consent where there are allegations of family violence or other risks of safety risks to children. But essentially what it means is that the court has powers to more actively manage any type of family law proceedings using the principles and the duties that underpin that approach. So it's intended to give them better safeguards and supports for those matters involving family violence. Two practical examples of the impact might be the court could consider using technology to facilitate remote attendance for a party where there are allegations of family violence, or they might be able to ensure that evidence of family violence, which might not currently be admissible under those technical rules of evidence, would be able to be considered in property and spousal maintenance proceedings. So that enables people to raise family violence issues that they might not otherwise be able to do so. So including that discretion just enables the court to take a less formal approach that's flexible to meet the needs of the parties in each matter on the merits of each case.
Okay, thank you. One of the other things I thought probably hasn't got as much attention in this hearing today, but came up with one of our witnesses, was the There's the issue of having to attend in person if you are seeking, and you'll have to remind me of the terminology, but you're seeking to get divorced. I think you're a sole applicant, so the other person hasn't necessarily responded. At the moment, I think if you've got children, you have to do that in person, whereas the legislation seeks to amend that so that you don't have to necessarily attend in person. It can be pretty traumatic going to a court and probably costly, and you have to take a day off work. So I just wanted to understand the policy rationale behind that, and what that will achieve, probably throughout the court's time too, I imagine. Do you know the provisions I'm referring to?
Yes, I do. Sorry, I just had lost my place there. So the Family Law Act currently permits the court to hear divorce applications without either party attending court, where that application is jointly made or where there are no children of the marriage, where it's a sole application. But it doesn't permit a sole application where there are children of the marriage. So what the amendments do is change that. So it aligns the requirements for hearing divorce applications throughout the Act. So it means that all people who are seeking a divorce do not have to appear in court. So it's intended to simplify divorce processes, reduce costs for parties, and allow the court to respond to divorce applications more efficiently.
Great.
If I
Sounds excellent.
May, Senator, I think I also wouldn't mind just going back to the rationale for why discretion is important in terms of the less adversarial trial procedures. Just to note that in those cases, ensuring that there's the discretion of the judicial officer to apply that approach where they consider it is appropriate at any point within proceedings is important, rather than constraining it to potentially a particular issue. That just enables them to have the flexibility to ensure that they can apply it where it's relevant, and also that they can provide clear expectations for the individuals who are appearing before them.
Sorry, just one other question that occurred to me. The Law Council Australia has made a recommendation that they would like all provisions to commence at the same time. But as I know, look, I'm not a legislation specialist, but I'm a senator, so that's pretty close. I understand that sometimes in legislation we do have to stage things to start at certain times, but also to allow people to get, materials printed or get across the changes. We don't want all those things to happen straight away for various reasons. Is there a reason why there's a staged commencement for some of the provisions that we want to keep?
Thank you, Senator. So essentially there's two commencement timeframes within the bill, and the substantive measures would commence within 6 months of royal assent, and that's the approach taken to ensure there's sufficient time for all the preparatory work that needs to occur, including things like education, awareness raising, skilling up the profession, changing court forms, what have you. The other ones is where there are matters that are very straightforward. For example, the divorce provision that we just discussed, which we want to commence straight away on royal assent. And also the provision for state courts to be able to make their own court rules. So there's one in there that enables, it's particularly because at the moment the Family Court of Western Australia cannot make their own court rules, which is highly inefficient. So this simply would ensure that they can do their own rules rather than having to go through a lengthy process of having them approved by the Federal Circuit and Family Court of Australia every time they make a rule change. So that's the reason for having, it's in general just two distinct timeframes for the commencement provisions.
Thank you. Thank you for putting that very plainly for us. That's all the questions that I have, and that concludes today's proceedings. Can I say thank you for, again, I'll just reiterate the Deputy Chair's comments. Thank you for the very detailed submission that you provided, and particularly the table, which I hadn't got to the second part of the table, but I have read it now, around the different recommendations. I don't think we've given you an enormous amount of questions on notice, but we will get you a date to return those. So thank you very much for your time and your efforts and your work on this
Thank you, Chair.
reform. I think it's really important.
Thank you.
Thank you.
Cheers.
That concludes today's proceedings. The committee has agreed that answers to questions on notice at this hearing should be returned by close of business by Friday, the 25th of October 2024. I want to thank all witnesses who've given evidence to the committee today, and all the submitters as well, who put a lot of detailed information in a very short time frame to the committee. Thank you also to Broadcasting and the Secretariat. We'll see you all next week for privacy. So thank you. I declare the hearing adjourned.